So welcome to everyone here. And I'm Martha Davis. I'm a professor at Northeastern University School of Law and co-director of our program on human rights in the global economy, which is the current home of the Bringing Human Rights Home Lawyers Network. This is the 19th annual Bringing Human Rights Home Lawyers Network CLE program, which is, an amazing accomplishment. And over those 19 years, literally thousands of lawyers and activists have attended, hearing speakers and making connections with other attendees. After several years of online programs, we're starting with COVID, we're thrilled to be back live this year. And there are many friends that made that possible. I want to particularly thank our co-hosts, the Center on Race, Law, and Justice at Fordham Law, and the Leitner Center for International Law and Justice at Fordham Law. A special thanks to Fordham Law Professor Catherine Powell, one of the founders of the Bringing Human Rights Home Lawyers Network, for helping us secure this wonderful space, and she's sorry that she can't be here in person. We also want to thank our patrons, the Columbia Law School Human Rights Institute, which was a longtime host of the first probably 17 or 16 CLE programs, and as well the Center for Law, Equity, and Race at Northeastern Law, the Center for Public Interest Advocacy and Collaboration at Northeastern Law, the law firm of Schulte, Roth, and Zabel, the law firm of Skadden, Arp, Slate, Meager, and Flom, and the Unitarian Universalist Service Committee. And we also have a long list of co-sponsors and friends that you can check out in the program and online. It's been really gratifying to be able to draw on so much support in pulling this together. A lot of the law school human rights clinics from around the country and other human rights institutes have partnered with us in making this possible. I have a few housekeeping issues to address. First, this is a continuing legal education program. So if you're a lawyer, you know why that's important. CLE credit is available for California, New York, and Minnesota. We're open to talking with people about getting credit elsewhere. It involves some additional work, so we can't promise that it'll happen. But at least in California, New York, and Minnesota, we have processes in place to work on it. We have sign-in sheets at the registration desk outside. It is important that you sign in and out in order to receive credit. I think that's particularly true for New York. I think for California, you can just sign in, but for New York, you sign in and out. And we'll also be announcing CLE codes throughout the day for those who are seeking CLE credit in New York. California and Minnesota don't require that, but if you're seeking credit in New York, you need to listen for those codes, write them down, and you'll have to report them when you are seeking the CLE credit. Second, where are the bathrooms? I know there's some bathrooms that way. If you go out that door and turn to the right, there may be other bathrooms around, but those are the ones that I know about. Third, note that there have been a few changes to the agenda over the course of developing the program. Gay McDougall, originally slated as a keynote speaker, was unfortunately not able to join us in the end. And instead, we'll have a nice 1-hour lunch break with box lunches available for people. It's a chance to meet with some of the panelists, meet with your colleagues, make plans and make connections. And then at 1:45 p.m., we will reassemble in this room and hear from Mia McMorris, who's a public historian and expert on the reparations movement in the CARICOM in the Caribbean region. And that region, of course, shares a history with the United States, and she'll be joining us from Jamaica by Zoom. I think that'll be an interesting addition to the program. Now I want to say a few words about the substance. So when we began planning this, we knew that the momentum was growing and had been growing for a while in the United States. Reparations movement and human rights initiatives played a role in that. In the past few months, the momentum has only grown. At the same time, concrete gains, like the creation of a commission in New York State and the implementation of a reparations program in Evanston, mean a concrete backlash. So just a few weeks ago, the Conservative Judicial Watch, which litigated the anti-affirmative action cases in the Supreme Court, filed a federal lawsuit challenging Evanston's reparations program, drawing on the U.S. Supreme Court's ruling striking down the use of race in college admissions. More recently, we saw the Oklahoma State Supreme Court's tragic dismissal of claims for reparations for reparative justice for the 2 remaining survivors of the Tulsa Race Massacre of 1921, ages 109 and 110, I think. So really tragic end of that case. The case was dismissed after local state governments repeatedly failed to acknowledge legal responsibility for the losses and trauma caused by the Tulsa riots and the devastation of Black Wall Street in Tulsa. And there's really no way to look at that dismissal except as a failure of government, including, given the state Supreme Court's dismissal, the real failure of the justice system to accord justice to the survivors. And while the program today is primarily, though not exclusively, focused on race-related reparative justice, we know that there are many reparations movements. Most notably, many indigenous communities are pursuing reparative justice through land back initiatives. Here in New York City, the American Indian Community House sponsors the Mannahatta Fund for non-native settlers to make financial contributions to the services for Native people residing here as a voluntary form of reparations. We also know of the climate reparations movement gathering steam, focused on reparations or reparative stance for the impacts of climate change on certain communities, an initiative that also sits at the intersection of race and environmental justice. And in your reading packet, if you're seeking CLE, is an article by PHRGE member Azadeh Shashahani, was just published in the NYU Journal of Law and Social Change, calling for reparations for victims of the global war on terror. That is, all those who've endured various human rights abuses at home and abroad, military occupations and the resulting humanitarian crises or forced displacement and their descendants. Unfortunately, we can't address reparative justice from all these angles in a single day, but we hope that the deeper dive into the practical challenges of implementing reparative justice programs that primarily focus on the legacies of race discrimination and a discussion of how human rights connects with those efforts will be illuminating across the spectrum of reparations initiatives. So I think it'll be a rich and generative day for all of us. I will just say again that as we conceived of this, the focus was really on some of the practical issues, and which is why we're going to, we have the lineup of speakers that we have set up here. So we're going to be talking about some of the legal challenges and practical challenges of going forward with reparations programs. So starting us off will be a conversation between Margaret Burnham and Justin Hansford, and they're already up here. So I'm going to move over to initiate the conversation.
I stole your notes.
I'll read my notes. Okay, so it's a thrill to welcome our first two speakers for a keynote conversation and to set the stage for the discussions for the rest of the day. We've got little mini name tags up here, but I'll say, starting with Margaret Burnham. Margaret Burnham is the Distinguished Professor of Law, Director and founder of the Civil Rights and Restorative Justice Project, and faculty co-director of the Center for Law, Equity, and Race at Northeastern Law School. She is an internationally recognized expert on civil and human rights. Attorney Burnham serves as a member of the Civil Rights Cold Case Records Review Board, an independent federal agency tasked with examining unsolved murders of African Americans between 1940 and 1979. She's the author of a book by hands now known. I saw some people carrying it earlier. It's by hands now known, Jim Crow's Legal Executioners, which won the 2023 Los Angeles Times Book Prize for History and was recognized as a Best Book of the Year by, among others, the New Yorker Magazine and Publishers Weekly. So thanks, Margaret. And then alongside us is Justin Hansford. Justin is an associate professor of law at Howard University School of Law and executive director of the Thurgood Marshall Civil Rights Center. He's a leading scholar and activist in the areas of critical race theory, human rights, and law and social movements, and is a member of the UN Permanent Forum on People of African Descent. He's co-author of the forthcoming 7th edition of the book Race, Racism, and American Law, a celebrated legal textbook that was the first casebook published specifically for teaching race-related law courses. So we're going to structure this as a conversation, and so I'll ask some questions, and then you guys will talk too. So we'll be engaging directly with each other as well, but this is not meant to be an interview. Our conversation will go on for 25 minutes or so, and then we'll have time for questions and comments from the audience. The way that will work, I mean, the people that are live here, of course, will call on you and you can ask questions or make comments. If you're on Zoom, we've disabled the chat, so we'll ask you to use the Q&A function to ask a question, and then we'll convey that to the speakers. So I'd like to start by asking Justin to outline the components of reparations under international human rights law.
All right. Sure. Well, First of all, good morning, everyone, and thank you for coming. You know, this is a wonderful day for me because the reparations movement, to me, is the movement that helps me to understand what I think we're going to be doing in the 21st century when it comes to human rights. I think that the human rights lens traditionally has had, as you know, multiple approaches and frameworks that could be applied. You could have a more traditional, liberal, individual-based framework. And then you can have the human rights movement, which I think that most of you consider yourselves a part of, which is a more radical vision of human rights. And what reparations can do, should do, and I think will do, is push the broader human rights discourse into that more radical space. And the fact that it's being not accepted, it's being worked with across the world, I think that's a really important thing to think about in terms of something to be hopeful about. I was talking to Lisa Borden a few minutes ago about the upcoming election as something to not be too hopeful about. But I think this is something to be hopeful about, and we're seeing this is positive possibility out there. And in 2005, there was the creation of a resolution in the UN, I believe it was in the General Assembly, that laid out 5 elements of what would constitute reparatory justice. And the elements is probably familiar to many of you: compensation, restitution, non-repetition, satisfaction, and rehabilitation. And so those terms, to translate them a bit, and if you think about rehabilitation, that could be the provision of mental health services, other types of services to help people heal from the harms that they may have experienced during an atrocity. Satisfaction includes the apologies, the truth-telling process. Non-repetition is the inclusion of policy change that can ensure that the atrocity does not happen a second time. Restitution and compensation are moving more towards the economic aspects of reparations. And restitution would be the idea of providing full payment that would bring someone back to a point before when the harm happened, so sort of a full repayment. And if that is not possible, then you provide a fair compensation that gives some measure of justice. And so those are the 5 elements, and that's been a very important element to our work, which I'm sure we'll talk about later. Because if you go on the street and you ask people about reparations, what are they going to say? Where's the check? Show me the money, right? And it's a fully economic discourse, especially in the United States, which is such a capitalist country in its mentality. And just the fact that there are 5 elements as opposed to 1 is a revelation for most average people who are not thinking about this on a day-to-day basis. And that's one contribution of the human rights lens off the top.
Great, thank you. And then Margaret, so there's the human rights 5 components. Is there a domestic definition of reparative justice or reparations?
Well, so first of all, thank you so much. I'm also thrilled to be here, and thank you so much, Martha Davis, for organizing this conference, which will, I think, be incredibly important in clarifying the issues that we are all engaged with. We have here folks who are working with cities, folks who are working with community organizations, and lawyers who are helping both cities and community organizations and are themselves community activists. So this is an unusual gathering of people to confront the problems that we face in the movement and to assess where we are and where we're about to head. I really appreciate the human rights focus and take a lot of pleasure and also am inspired by the work that Justin has done over the years and that Martha has done over the years to bring a clearer human rights focus into the reparations space. I will also say that the issues that we confront in the human rights space are very much like human rights reparations space are very much like those that we face here in the domestic arena. The problem of intertemporality, the problem of whether or not the law, either human rights or domestic, addresses group rights, and the problem that some of these issues are generic in nature. And it strikes me that those crossover, those issues that we've battled with in the reparations arena cross over both the international space and the domestic space. I will also say that since Durban in 2001, advocates have harnessed international human rights and international law in really creative and productive ways. And I think someone's here from Chicago to talk about the California initiative, the Chicago initiatives around torture and the use of CAT to advance local issues, local travesties in Chicago. And so certainly we have found spaces where human rights have been effective tools to use in the domestic arena. It's also true that there, notwithstanding Justin's enthusiasm, that there are holes in international human rights that inhibit our ability fully to harness these global principles and norms. There is no fundamental right to reparations. Of course, we do have the 5 principles. We have other ways of addressing reparations in the human rights in human rights law, but there is no fundamental right to reparations. And what I think we should be talking about is what would a fundamental right to reparations look like? What would a convention confirming a fundamental right to reparations, a convention that might indeed also include the legal apparatus where claims could be brought and litigated. What would that look like, and in what way would it consolidate the various disparate tools in the human rights arena that we are looking to? So I would say that, I'd say that, as we come together over the course of the day and we think about the domestic arena, Martha has rightly pointed out that we are now clearly understanding the nature of the pushback in Evanston now that the complaint has been filed. But it strikes me that there are 2 issues that we need to really begin to zero in on here. One is what does the future of litigation actually look like? We have for a long time tried to squeeze, a round peg into a square hole here. We've looked at contract law, we've looked at property law, we've looked at civil rights law, all in an effort to mold these areas of law to fit our reparations agenda, and we've sort of come up cold, repeatedly come up cold, and so we need to think about what does the future of litigation look like, but as well we need to think about what I would call non-legal reparatory measures, and I consider Evanston to be a non-legal reparatory measure, and as we know, there are now 18 cities out there that have reparations on their agenda in one form or another. Obviously, Evanston has advanced the furthest. They've got remedies, they've paid money out, and that sort of thing. But there are other cities that are coming along. And And they're working on areas where we, as the legal community in this space, can provide some support and some support and guidance. The three main questions that face these cities are, what is the harm that they're looking at? Many of these cities are looking at urban renewal and at harms that are associated with housing discrimination and the subordination of communities of color with respect to housing. But there are other forms of harm that cities could be looking at and trying to make the nexus between the harm and the reparatory measures. The second is, what is the class of beneficiaries? Are we are we concerned about programs that that specifically address African Americans and other minoritized groups? Are we concerned about, the legal consequences of shaping our programs in this way? What remedies are there? What remedies, for example, or what guidance, for example, does Croson provide for us if we're looking at not litigation, but programs that are reparatory in nature and that are addressing past harms? And then finally, what are the sources of whether the resources that cities can look to pay for reparatory programs. So two things. One, where are we going with litigation, all right? And two, for these programs that are not litigation-based, but that are coming from governmental entities, what can we do to support those programs when we know that the legal pushback is going to come and that these programs are going to be open to suit? So the short answer to your question, whether we have in domestic law any comparator to international human rights law, is no, we don't. But nevertheless, there are tools in international law that we can and have used. And perhaps as importantly, what international human rights law has done for us is to provide a global reparations arena from which we can gather strength, inspiration, and ideas. So we look, for example, to Barbados and elsewhere in the world to think about the ways in which our efforts to advance reparations here in the United States are in sync with and aligned with the folks around the world who are dealing with the legacies of colonialism.
Thank you.
That's the short answer.
Short answer.
Justin, yeah.
First of all, I neglected to say what an honor it is to be on the stage with Margaret Burnham, as you can see why in terms of her brilliance, but also a legendary lawyer who I greatly admire. So I'm normally usually the more skeptical person on the stage, so this time I'm in an odd position, but I want to talk about a little bit of, just to respond to this great statement. Number one, I've created an organization, co-founded an organization called the African American Redress Network. What we do is we provide legal support and organizing support for reparations movements across the country. And we have our claim to fame, which is a map that we've created, which documents reparations movements around the nation. And we have now over 435 movements that we've documented, and nearly 100 campaigns for city municipal reparations projects. So one of the reasons that I'm excited is to see, this uprising, and as you said correctly, the legal portion of it is still to be determined. When we have Nick Cummings here, who is one of the architects of the Evanston plan and an attorney for the city of Evanston, and he'll tell you that plan was very specifically designed to survive a 14th Amendment constitutional challenge. And one of the ways that design came into place, or one of the principles behind that design, was to create a record that was specific and spoke to concrete harms, using some constitutional language, concrete harms that the city of Evanston admitted to, in this case involving redlining between 1919 and 1969. And the creation of these types of records, these types of harm reports, to me is one of the first things that cities need to do for what Margaret described as non-legal approaches to reparations, legislative approaches to reparations. Creating a record. In California, there was a 1,100-page record that was created by the California Reparations Commission. I'm working with the city of Washington, D.C. to start their process, and we're also working with College Park, Maryland. So that process of helping cities, and I would also say other actors, municipalities, states, businesses, churches, helping them to document harms that have taken place in their institutions in such a way that they can make the argument that there is a record here that can withstand any type of challenge. And then creating a reparations plan that is narrowly tailored to address those specific harms. That's the Croson test, right? That comes out of the 1989 Supreme Court case, Richmond v. Croson, which argued that in order to survive strict scrutiny, you had to have a narrowly tailored plan that would be designed to provide a remedy, specific remedy for the harm outlined by in this case, it was the city of Richmond. And our goal is to make sure that that jurisprudence is the jurisprudence that is applied, as opposed to what you're all probably thinking, the jurisprudence of SFFA, which came out of the Supreme Court last summer, which was an affirmative action case that argued, that concluded that diversity was essentially no longer a compelling state interest. A lot of the work that I've been doing in the week and a half since the Evanston lawsuit is trying to reiterate to people that those are two separate lines of jurisprudence. The affirmative action jurisprudence and the reparations jurisprudence are going to be two separate lines of jurisprudence. One line of jurisprudence, affirmative action jurisprudence, was designed to promote diversity. It's a completely different project to seek to provide a remedy of reparations for specific harms. That is not a diversity advancing agenda. As a result, there should be a separate line of jurisprudence. So one of the things we're looking at in terms of the litigation process, and that's the fight that's happening. If you look at the Judicial Watch's lawsuit, one of their first attempts to tie the two lines of jurisprudence together into one thread is to tell this narrative that says, okay, so we saw in Croson there was an initial attempt at providing remedy, but most recently now in SFFA that's been struck down, and here we are in 2024, and we have to apply the most recent precedent, and unfortunately the undeserved handouts, which they believe reparations to be, are unconstitutional, right? So in their narrative, they're tying the two lines of jurisprudence into one. And that's one of the first things that I think about as an attorney. How can we separate those two lines of jurisprudence? But it's an interesting thing that's happening if you look at the Tulsa case, which was a case that, if you look at that opinion, essentially concluded that the attempt to use the public nuisance statute, the local Oklahoma public nuisance statute in that case, was misfounded because reparations is a political question. So it's almost this catch-22 where you have the litigation approach in Tulsa being rejected on the grounds of being a political question and it should go to the legislature. And then when you go to the legislature, you have the attempt to reject the legislature's approach because you're saying that this is not narrowly tailored enough to meet judicial scrutiny. So there's a two-pronged attack now to really try to create a catch-22 where you can't go to either avenue. And one of the things that I think our role is as attorneys, especially as human rights attorneys, is to, number one, help these campaigners, help these organizers make their case. Oftentimes they have to make their case in the field of public opinion, the court of public opinion, and they can use a human rights lens to make that case in the court of public opinion, because their first objective is to pass these reparations bills. 18 have passed. You have nearly 100 that are in the process of being pushed. And to get that over the hump, they can use human rights language to convince other legislators, especially on the local level, if you're in a progressive city council environment, to support the bill. But then the second project outside of that right now is this constitutional project where you see they're trying to create a catch-22 where there's sort of nowhere to go. You can't go the legislative route, you can't go the litigation route. You know, you have the campaign to go the executive route. We know that President Biden does have the power to create an executive order on the federal level to create a reparations commission. And then maybe on certain state level, grounds as well, you have different governors or mayors who may be able to do certain things as well. I know that in many cities where there are reparations commissions, one of our problems has been commissions have been created, but then mayors have decided to not provide any funding for those commissions. City of St. Louis is a prime example. So that applies even if you have African-American mayors. This is something that is not following traditional lines that you might predict in terms of the political element. So that's just my response to that. I think there's a lot of room for us to provide some sort of support on all of these levels in terms of thinking about who's going to be the beneficiary, where can you get the funding, things of that nature. But right now, in my view, helping these campaigns create records of harm that they can be confident will survive judicial scrutiny is step one. And when you create these records, using the human rights lens is crucial to providing them a starting point, and so that they can go deep into their analysis, not just in a descriptive way, but in an analytical way as well.
Great, thank you. So let me to get back to maybe where you ended. I'm interested in what role human rights as law might play, not as an organizing tool or as a kind of a framework, but is there anything that human rights law can bring to the table in terms of resolving some of the issues, some of the thorny issues that you talked about, Margaret, like group rights or questions of eligibility or prioritizing or that kind of thing? Does human rights law help at all in that way? And Margaret, I don't know if you want to.
I'm going to let Justin go ahead. He's the one who thinks the answer is yes, so let's hear what he has to say.
Right. Well, so the human rights law angle is important, I think, firstly, from a rhetorical perspective. And so we're thinking about U.S. law. We know how the U.S. has taken a stance when it comes to the binding or the non-binding nature of human rights jurisprudence. So there's a rhetorical element which is important. So here's a case in point. One of the projects I have ongoing is a case before the Inter-American Commission on Human Rights on behalf of the family of Mike Brown. August 9th will be 10 years since Mike Brown was killed in Ferguson. We know what happened in 2014. And we have a hearing on July 10th where we're going to be arguing that this was clearly, number one, a violation of the American Declaration. So in here we have the Organization of American States, which has drafted a set of human rights laws and norms that many countries in the Western Hemisphere consider to be binding, but the United States is not one of them, right? But we are taking that case and leveraging amicus briefs by some organizations here in this room with the hope of bringing a spotlight to the case so that there can be, number one, a call for reparations that will coincide with the 10-year anniversary. Number two, a call to reopen the case. And there's actually a congressional race happening right now in the jurisdiction of St. Louis between Cori Bush and Wesley Bell. Wesley Bell is Ferguson's prosecutor, and so he has the power to reopen the Mike Brown case. He ran as a counter to Bob McCullough, who was the prosecutor who decided not to bring charges against Darren Wilson, who killed Mike Brown. So he ran on that, used the movement's resources for his campaign, and then once he was elected to office, you can predict the rest. Decided to act like a politician, failed to fulfill his promises, and now he's running to the right of Cori Bush. So I'm using that example just to show that, to me, the most effective use of human rights law in the sense of actual cases and litigation that can appear in human rights courts is to, in the same way all movement lawyers use litigation, not always with the aim of having a particular outcome that you can implement through the courts, but you use litigation as an organizing tool. You use litigation as a tool to gain publicity behind a cause. You use litigation to frame the issues so that those issues can be translated into the political realm. You use litigation for many different goals outside of actually winning in court. So to me, human rights law as a litigation practice is going to have to take that same approach when it comes to the broader reparations movement. It's going to have to be used as a movement lawyering tool. I don't see, now I do think that there are some things happening on the global level that are relevant. At the UN Permanent Forum on People of African Descent, we've held meetings with many different countries in the African diaspora about reparations. And we see a lot of progress being made. There's going to be the creation of a fund that will receive reparations monies from former colonial powers. We have the dream that is one of my dreams, which is to create a UN tribunal on reparations for slavery and colonialism. So I outlined that in a speech last summer. And since then, we've got about 4 countries, maybe 5 countries, that have said that they will support the creation of that type of tribunal or some sort of mechanism of that nature. And if that was created, then you'd have, in my vision, a platform for countries throughout the diaspora to bring charges, so to speak. That could be Haiti bringing charges against France. That can be Kenya bringing charges against the UK. And also in a situation like Brazil, you can have reparations claims both against the Brazilian government on behalf of Afro-Brazilians and against Portugal. So that type of platform is a vision that I would love to see fulfilled, and that would be a possibility for using human rights law in a more direct way for reparations. One last thing I'll say, there's been talk about the creation of a crimes against humanity treaty, a war crimes treaty that's been in negotiation over the last few months. And if that ended up coming to pass, that would be another opportunity perhaps to explore using human rights law directly for reparations, because that is one of the ideas would be to allow there to be some type of framework that would eliminate statute of limitations concerns.
Great, thank you.
I want to just add to what Justin has said, that, I think we can also look at human rights law, not just for the apparatus that allows claims to be pursued, the adjudicatory apparatus that human rights law might provide, so that a Michael Brown case could go before the Inter-American Court or Inter-American Commission, but also for the kinds of remedies that are being developed in human rights law under the 5 principles, for example. As we talk about, so the 5 principles. So this is not just inspiration. This is kind of the framing that human rights law provides as to what do we mean by what does reparations mean in international law, in international in international human rights law. The example that I used before, I think, is a really solid one of the ways in which advocates in Chicago leveraged the Convention Against Torture at a point when they were going nowhere, trying to get the torturers and the police department in Chicago, Borg, and others to be indicted. They leveraged the convention in order to gain some awareness that what was occurring there was, in fact, torture, a violation of international law, and therefore adjudicable in a U.S. court. Not only adjudicable, but it had to be adjudicated in a U.S. court. Since Justin has taken a moment of personal privilege to talk about his project, I wanted to say a word about mine, which is that as Martha has indicated, I've spent a lot of time thinking about the violence of the Jim Crow era, the legal violations resulting from the Jim Crow era, and one of the projects that our team is working on now is examining whether there are federal remedies that would address the crimes that and the violence and then the harms, homicidal violence that we have uncovered over the last 10 years. And so here we're talking about a federal reparations project that would clearly different in many ways from the efforts to generate reparations around slavery, simply because here you avoid the temporal problem. You have identifiable victims and identifiable crimes, which were crimes at the time they were committed. So thinking about the ways in which the federal government failed to provide protection for individuals who were subjected to lynching and other forms of racial homicidal violence, and also failed to provide adequate remedies, although the legal structures were available at the time these crimes occurred in the 1920s, 1930s, 1940s. You had 18 U.S. Code 241 and 242. Repeatedly, the Justice Department fails to, let me put it that way, fails to, without, I don't want to impute motive here, fails to do anything to protect these folks. So there is this legal nexus to the harms, and so considering the ways in which such a program might, first of all, jumpstart the federal reparations initiatives generally, and the folks have been talking for a long time about, is there a discrete and clearly deserving class of victims who could be the subject of a reparations initiative on the federal level. And so I think I've identified that class, and we're moving forward to consider what kinds of.
Great, thank you. So we've been talking for a while. We've got a few minutes for questions from the folks that are live here. I've seen a couple questions on the Q&A, so people that are on Zoom, feel free to put those up and we can convey them to the speakers. So any questions, comments from folks here in the room? Yeah. Oh, Eric, I think.
Earlier you said that there wasn't a right to reparations in international law. I'm wondering, I've always thought of the special measures clause of CERD as a place for that. I guess it allows them, if not requires them. But do we think it's more important to push for a treaty that clearly embodies that, or is it important to try to find it where it already exists, or is it a equivalent?
So I would say both. I said there's not a fundamental right to reparations. I didn't say there wasn't a right to reparations. I think there are various places in international law where one can assert a right to reparations. With the Articles of State Responsibility certainly provides for a right to repair. The five elements that Justin referred to, the Bassiani principles, all of these provide for or impose on states an obligation to repair and remediate harm caused by states. I didn't mean in any way to suggest that legal apparatus was not in place. All I'm suggesting is that it's here, it's there. One has to obviously piece it together, and this is purely, sort of thinking in the future. What would the world look like if there were a fundamental right to reparations and a unique and specialized tribunal, forum, commission that address these claims?
Great, thanks. So I forgot to suggest that people identify themselves. That was Eric Tars from the National Homelessness Law Center. So we have another question. Maybe you could just identify yourself.
I'm a retired lawyer, so I don't know, would anyone care to speculate on what the short-term future of this movement will be in terms of the upcoming presidential election and specifically the selection of judges and state and federal legislators?
I'll take a stab at that one. So I'm pessimistic about the creation of a commission to study reparations, even though President Biden has gone on record both during his campaign and I know on the last Juneteenth 2023, his press secretary was asked directly, do you support the creation of a commission for reparations? And Karine said, yes, I do, but of course there has been no commission, and we're running pretty short on time, and there's been a campaign, Earn the Black Vote campaign, which has been put together saying that there should be a commission to help to increase black turnout, but I'm very pessimistic about the opportunities for that, looking at just the political wins. And even I can say in Washington, D.C., with the reparations bill that I'm helping to support, introduced by D.C. Councilman King and McDuffie, we know that D.C. is being, not a full state, being a city district that has to have its bills supported by Congress. As a result of that, there has been political calculations for us to postpone the full introduction of the DC reparations bill, because we anticipate that on the House floor it'll be voted down by Republicans, and then President Biden does have the ability to override those House votes, but it seems like he is likely not to do so, because in their political calculations, it does not seem to be something that would excite black voters around the country as much as it would incite anti-black voters around the country. So because of that, looking at those political calculations, I anticipate that this would not happen before the upcoming presidential election. However, in terms of state and local elections, I do believe that this is going to continue to be an issue, especially where commissions have been created. I think on the city council level, on the mayoral level, this is going to be something that will be debated, and I think that's a positive thing. In terms of the judicial elections or judicial functions on the state or municipal level, I don't know. So we did not get a chance to go into the details of what types of municipal or state legal concerns might be before such a court in a reparations environment. I think at this point, this may be something we talk about later, but in terms of the local state constitutionality of using certain funds, like, there's the issue of using the sales of marijuana, the sales tax for marijuana sales to fund reparations, how will reparations impact the tax status of recipients, especially those who are receiving public benefits. All these different municipal issues are things that we have not seen really fully explored by municipal courts. And there may be a time where this becomes a political issue and we see local judges running on a platform which says they may rule one way or another on a reparations case that comes before them. I'm not sure what the likelihood is of that, but as of yet, we have not seen that issue. In Tennessee, we saw the proposal of a ban on reparations commissions. This proposal took place, I believe, in April or May, and that would have been challenged locally on state law grounds. Specifically, issues of preemption are issues that may be ripe. There's just a number of different local issues. That ban was walked back once the people who were proposing it realized there were a bunch of lawsuits ahead, and they were afraid of those lawsuits. So that was a victory for the movement in a sense. But those types of local bans are also legal issues that may be on the horizon on the local level.
Great. So I'm going to announce our first code here for CLE. It's M as in Martha, P as in Peter, 48, H as in Henry, 2. So it's MP 48H2. MP 48H2, right? We've got time for just one more question. Joanne Camerford, do you want to introduce yourself?
Hi, I'm Joanne. I work at the New York City Commission on Human Rights. I guess my question is maybe more in the unradical space, but thinking about, I think there's been a lot of movement in the apology arena and thinking about the non-restitution prong and how we can leverage that for laws that either are recent or moving forward as a way to say, yes, this is a way that we're going to say never again, and not just about slavery, but the attendant harms, and thinking more about tools that have been used for other human rights principles like women's rights to assess how laws are doing along these principles, even though it doesn't put them legally into place. So just a question about progress there.
So let me just say, try to grapple with that. I would say that apology is what distinguishes reparatory measures from other efforts to deal with, the deep disparities in racial disparities in our country. Both apologies as well as the involvement, the active involvement of
Somebody's.
the active involvement of the affected communities. So those are the two features that are critical to reparations programs and that are in fact recognized by international human rights. So if you think about the 5 principles, again, these 5 principles that Justin laid out at the beginning, when he talked about satisfaction is about apology. So it clearly is an important, certainly if you think about, the articles on state responsibility also include satisfaction, i.e. apology, atonement, as an essential element of any reparations project. So, there are those who say that comes cheap. And indeed it does. That doesn't make it any less critical or important as one necessary element in a reparations project, which should really be mindful of all of the 5 elements that Justin laid out. To repeat, compensation, restitution, satisfaction, rehabilitation, and never again. Yeah. I think I got them right. Did I get it?
All 5.
Okay, last word, Justin.
Last word, and that was such an important point. I have had some discussions recently with activists in Brazil where there's a much more robust affirmative action regime. They can use quotas. Those are fully constitutional, things like that. And they keep asking, why should we use reparations as opposed to moving forward with affirmative action if we can get similar or even better political outcomes by not asking for apologies? And I always say that the reason, this is my analysis, the reason that affirmative action has failed in the United States is because essentially what it was an attempt to avoid grappling with the history and to say that, okay, if you just give us some fairness on whatever grounds you want, you can say that it's because diversity is something you care about, whatever the grounds may be, we'll take it. But by failing to have a public articulation of what happened in the past, institution by institution, by failing to have apologies, by failing to have the history truly documented, what happened when it comes to public opinion? People can make the argument that these are handouts. As weak as that argument is, it only exists because there's a lack of understanding of the harms in the first place. If you tie the reforms to the harms and you have a public reckoning, racial reckoning or a public record, then that handout argument doesn't fly because people understand you're trying to make up for something that was wrong and trying to make things right. But here in the United States, we had a failure because institutions were able to, on the cheap, say that we're going to try to make things right without actually admitting to anything. And that has set us back many years.
Great. Thank you so much for the Margaret and Justin. So we have another panel coming up here. While they are coming up, I'm going to correct something I said earlier, which is the people who on Zoom who are seeking California credit do need the codes. People in the room who are seeking California credit do not need the codes. And so because of that, I'm going to give the code that I gave earlier again, same code again. It's MP48H2, MP48H2. So our next panel is Reparative Justice and the U.S. state and local initiatives. Will be a chance to follow up on some of the things that Justin was talking about earlier.
Oh, that's where they are.
Thank you.
They're very well behaved. It's still early, right? Maybe not.
It's very optimistic.
Mr. Robinson and Mr. Hansford, we need you to sit down. Good morning again, everyone. Glad to be here. Fordham is actually my alma mater. This building did not exist when I went here, but thankful to be having a conversation that's so important in this space. As I mentioned already during my question, I'm Joanne Ford. I'm the Deputy Commissioner of Policy and External Affairs at the New York City Commission on Human Rights. I'm not here today to talk about New York City, though, as I've told some of my friends already. And everything I say today will be my personal opinion, not the views of any others. I think at the outset, it's really worth pausing to recognize that today we're not engaging in a theoretical discussion of what reparations could look like, which is a discussion we've had for many years. But we're talking about what existing plans and programs look like. How do we defend them? How do we expand them? I think it's really important to just recognize this because it's not to say there are not significant challenges. Some of those have been flagged already. And I think there's backlash and opposition that we can't yet anticipate. But it's the strength of the advocacy of many people in the room and really generations of people before us who have been fighting for equity and justice. And that's really who we're here to honor and to build on that work. So I think, the history of the U.S. is often told as a triumphant one. It's also can be told as one of destruction. But if you're not looking at both of those things, you really don't have the whole picture. And it's that whole picture that I think we were talking about just at the end of the last panel. It's so important to recognize where we come from so that we can do better and differently. And I'm really elated to be here for this conversation today with three people who are doing that work at the city level in different parts of the United States. So I'm going to try to minimize how much I repeat what Professor Burnham and Professor Hansford have already said, but I think there's some important context, so I'll highlight some key points. We've already heard today there are 18 cities with some form of reparations commission and three states. And we know there are also concerted efforts in state houses and courthouses to put an end to and prevent race-based programs. So how do we navigate those things? It's sort of the conflict of the United States really showing up on our doorstep. Because those questions are so important, there's a panel here really of experts who are going to talk about their own experience in their jurisdiction. So I'm going to introduce everyone alphabetically, and I'm going to start with Brad Burnham, who's the city attorney for Asheville, North Carolina. Brad's the chief legal officer for Asheville, advising the council, the mayor, and the city manager. He's deep experience in municipal government, and we'll be talking about efforts in Asheville, which include a vote to provide reparations to Black residents, city council apology for past harms, so check on one of the 5 elements, and the establishment of a reparations commission, along with financial commitments. This is important, I think, for us because Asheville, for those of you who are not in the United States, is in the southern U.S., which has a very particular history with slavery and racism. Second is Nick Cummings. Nick is the founder of Osiris Professional Services, which advises on reparations initiatives. So we are going to hear some great information, not only from Nick's background as corporation counsel and city attorney in Evanston, Illinois, also something that we've already flagged today, but about other jurisdictions as well. And Nick was an advisor to the reparations efforts in Evanston. I think it's one of the most, if not the most, developed reparations initiative where $10 million has been committed to fund reparations, really focusing on restorative housing to address discrimination between a set time period, so 1919 and 1969. And our third panelist is Joseph Feaster Jr. Joseph is of counsel at the Dane, Torpy, Ray, Wiest, and Garner law firm in Boston. Also founded a consulting firm that supports strategic planning and community outreach, and I think we'll talk a bunch today about community collaborations. And significantly, he's the chair of the Boston Reparations Task Force, one of his several civic roles in Massachusetts. And in Boston, City Council has apologized for and condemned slavery and created a reparations task force to collaborate on research around the legacy of slavery and its ongoing impacts, as well as to engage with community and make recommendations to the mayor. Thanks also, of course, to Martha and the Northeastern team and all the co-sponsors for bringing all of us together today. So, where are we going to go today with our conversation? We are going to talk about what is the role of local government. This is either a very radical panel, because what is the role of local government in reparations initiatives is a radical question, but we all either sit now or have sat in the seats of local governments, and that's a very different perspective than some of the advocates and attorneys who are pushing government to do better and to do more. We already talked about the elements of what are reparations, so I'm going to skip that, and you will take an exam later to see if you remembered all the 5 elements. And we are going to explore what steps these 3 local governments have taken with a snapshot of approaches challenges. I think we're hopefully going to cover a lot of the questions that Professor Burnham really laid out for us as well. We're going to spend the bulk of our time really getting into the nitty-gritty of some of the legal issues that have already been flagged, and how do you address those legal issues? It's one thing to know what they are, it's another thing to think about how do you work around them. So some themes that we hope to draw out are questions about who are the decision makers in the local initiatives that are taking place, and what does that mean? We've heard about executive authority, legislative branch, and other parts of government. And how do voices of communities stay at the table when one of the foremost challenges of human rights advocacy is you're targeting a government body to do all the things the government body may not have done before. So how do you keep that important prong? We're going to talk about the legal forms that can be considered for reparations. What does it look like in terms of resolutions or ordinances or potentially other ways that might avoid some of the litigation? And then the scope of reparative justice measures, something we've already heard a little bit about this morning. So if there's time, we will also hear about how do you fund these initiatives? What are the ways this has been happening? We know, and we've already heard, there are fresh legal challenges to both new reparations efforts and longstanding ones. So how can we think about that as jurisdictions design their own programs? So that is the most talking that I'm going to do. And we're going to start really, just so that everyone is on the same page, we're going to set the stage with each speaker talking a little bit about where they are in the reparations journey in their jurisdiction. So we're going to start with the sort of more recent efforts and move our way to those that have progressed the most. So we'll start with Boston, we'll go to Asheville, and then we'll end with Evanston. So Joseph, tell us where we are. Oh, Joseph's from Brooklyn, that's important.
Oh, no. Well, she has part of it. Born in the Bronx, raised in Queens, worked in Brooklyn, partied in Manhattan. But let me, who? Good morning, everyone. I'm a Baptist. Good morning, everyone.
Good morning.
Thank you very much. Let me use a bit of my time. My mom always taught me to to be respectful for those who bring you here. So first and foremost, I want to thank Martha and the Northeastern University for bringing me here. I am a Northeastern University undergrad and law school alum, so I definitely, since I have to go back to Boston, want to make sure that I do that. Secondly, I want to thank Professors Hansford and Professor Burnham for setting the stage for what we are going to be further discussing today, and particularly Professor Burnham, who I knew as a distinguished jurist in Boston that wasn't mentioned in terms of her bio as a jurist, and what she's doing at Northeastern Law School is just legendary. So I just want to say for both of them, let's give them a hand for the work that they did in presenting this effort. While I've been practicing law 48 years, I am not going to come at this from a legal lens. I'm coming at it from an activist lens, and I think you're correct that we're going to be in terms of the ones, because I am, let me tell you folks, I am a strict believer, I'm a reparationist. And I will talk more about that at the appropriate time. But let me do what I've been asked to do, and that's to set the stage for what we're doing in Boston. In December of 2022, the City Council decided to introduce an ordinance creating a reparations task force in the city of Boston. The mayor was Mayor Wu, who was a city councilor prior to her election as mayor, was, through the ordinance, was the one who was to appoint the task force. 10 members of the task force, of which I was made chair of, were appointed in February of 2023. We were sworn in April of 2024. Now, in the good graces, and I constantly hear this in terms of everyone wants us to rush to a resolution. Well, I tell folks this has been an issue that's been going on for 400 years, so don't rush me. I'm going to get the job done. So we were appointed as I pointed out, we were sworn in April of 2023, and by the ordinance, it said that we had to have our phase 1, which was the research, done by June of 2023. Well, I've been practicing law long enough to know that that's not realistic, so therefore I asked the mayor to extend that time frame. Within that context, at phase 1, there were 3 phases. Phase 1 was to do the research. Phase 2 was to, through a community process, to come up with, have the task force make a recommendation to the mayor as to what form reparations should take. And you've heard some of that discussion today under the 5 principles that Professor Hansford mentioned, but everyone seems to want to go straight to compensation, but that's okay. We will have some deliberations around that. And the last one would be the implementation, which I'm not sure even that the task force will be responsible for that. Well, we had to go through the process of getting to that phase 1, and that phase 1 process required that we prepare a request for proposal, which we did. Request for proposal went out in August or so.
Doing okay?
Yes, I'm doing quite fine. And we made the selection of the team to do the research in November of last year. And fortunately, we had two teams were selected, one from Tufts University, one from Northeastern University, led by the distinguished Professor Margaret Burnham, and we had divided our research into 6 areas in terms of timeframes from 1619 all the way through the present time. Northeastern University's team will be looking at the research from 1940 until the present. So we did that in November, announced it to the community in December, and recognizing once again that phase 1 would not be able to be completed by December of 2023, I submitted to the mayor that we would be able to go until December of 2024.
Yeah, we missed like the last 3 minutes of his remarks.
Okay, we'll see what we can do. If you could also.
Hear you either.
Okay,
We can't.
we can hear you, so we
Can't hear all
will
the speakers.
chat. Northeastern team, can we just chat that we hear them, but they need to mute themselves?
I'll repeat all of that again when we get a chance.
Whoever's responsible there.
It should be fine now.
Okay, we think we've fixed it. If you guys can also just mute yourselves, that would be fantastic. Thank you and apologies. Okay, so start again.
So, just to pick up where I left off, where that we were in the process of selecting our researchers. The researchers were selected in November. We announced it to the community in December. We extended the time for the researchers to do their work until December of 2024. As I mentioned, 2 teams, one by Northeastern, one by Tufts University. The Tufts team has the 5. We broke up the time frames from 1620, I believe it is. Professor, you can correct me on that if I'm wrong. All the way to the present time. The Tufts team has 5 of those areas. Northeastern has the final one. We're now going through discussions. We had meetings the other day, and we'll be going through the process of having the discussion. What I want to mention is, to the point that Professor Hansford said, on what it will be, there's much discussion as to what form reparations will take, and I'll end with this. This is my own personal assessment of what my responsibility is. I think it's embodied by the task force in Boston as well, is this. I think we have to answer is, who is entitled to reparations? Who's going to pay? And that could be in many different forms. When I use the word pay, is not only compensation. The other one is how much, and that's, again, not strictly just in compensation, and when. And to me, that's ultimately what we have to do and present to the mayor when we get to that particular point. So I'll stop there. There's more I certainly have to say, but I'll wait until later on. Thank you.
Okay, thank you. And now we're going to move a little geographically to Asheville. So, Brad.
Thank you, Joanne. I do want to say quickly that we've mentioned at least twice that I'm from the South, from North Carolina in particular, and no translators have been provided. So I'm going to do my best to bring my accent down a notch or two. Okay.
No one understands.
If I see glazed looks, I will try to minimize my slang and pronounce my you-alls instead of y'alls. I really want to start this by highlighting what you've got up here, which is an area of expertise focused particularly on local government. And here's why I think that's individually important. Although local governments are under two major strains in this effort, one being the financial side of it. Local governments are never going to have the budgets that the state governments, and certainly nor the ability to print money that the federal government has. Despite how many times we are asked, we are very limited in the dollars that we have available to us. We're also at the bottom of the food chains when it comes to the legal authorization that we have in many cases. When we are looking at the latitude that the federal government, the state governments have, local governments sit at the back of the room in the bottom seat with fewer legislative tools to work with. However, I think it's important to note, and I'm sure that people up here will speak to the firsthand experience they've had with this, we're on the front lines in the way that local governments impact the lives of people who live, work, and play in our communities. So who better than local government, despite the challenges? You can certainly see that from a pessimistic standpoint. I choose to see it from an optimistic one. And if nothing else, I can say, if not us, then who? We certainly have not seen that kind of a movement. And there is, I think, a greater political barrier in many cases at the state and federal level than many local governments. And where you can have a few sparks, I think fire can take hold. So I do want to highlight that. In the city of Asheville, North Carolina, the beautiful city of Asheville, I should say, I do have the pleasure to serve as the city attorney, a city which has, as many people would admit, a long, storied, and fairly bleak history of racial relations. We have a beautiful city, incredible architecture, up in the mountains. Much of the road, the rail network was constructed by forced labor. We have incredible architecture, much of which was constructed by forced or underpaid labor. And we are now a city which is a destination around the world. People know us, despite our small population, as a place to see, to visit, as a bastion of progressivism, beautiful nature, liberal principles. But at the same time, we have had issues with redlining, which has drastically altered the landscape of that community. We have had several thriving African-American neighborhoods within the city of Asheville, which were decimated completely by urban renewal up until the 1980s. And we're now looking at the remnants of what was a once thriving population, now representing only about 11% of our total population. The wealth gap is not only significant, it's growing. And our achievement gap, which is one of the most striking figures, we have one of the highest achievement gaps of our student population between our black students and white students of anywhere in the nation. It is a source of shame, quite frankly, and it's one that has focused multiple initiatives. One of the most recent and most powerful was our reparations initiative. So let me transition into that. In July of 2020, the city of Asheville City Council voted unanimously to pass a reparations resolution. The primary goal of that reparations resolution was really twofold. It provided a direct apology for the local government's actions, consent, or direct creation of some of the institutional, some of the systemic problems that directly impacted and harmed Black Asheville. Beyond that, we empowered our city manager, city staff, and a future commission, reparations commission for our area, to create recommendations for the legislative board to consider and adopt, which would tackle the generational wealth gap that we have in our community, as well as seeking to provide opportunity and economic mobility to our Black community. Now, those are clear, easy goals to get behind, Well, what does that mean? Well, in order to determine that, the rubber hit the road by the creation of a reparations commission. And I do want to note that we were fortunate in Asheville that our local county, Buncombe County government, which we are the seat of, also joined us just a few weeks later and passed their own reparations resolution and has been walking arm in arm with us. So I do want to mention that local governments have other governments around. It is a very good thing if you can to have some support from local government. We were able to gain that from our county government as well. So together, they passed joint resolutions. A reparations commission was to be formed, but we went through a process first of information sharing and truth-telling. We put venues together, we brought in experts, speakers. Luckily, we have a university in Asheville, part of the University of North Carolina state system, that had already been doing a lot of research on this and had a tremendous amount of data that they could provide about our community, about what the effects that redlining, urban renewal, even Jim Crow had on that particular population. And by seeing that, we really began sparking a more community conversation as opposed to just a political one, which brought in a lot of additional people. The next stage of that was the funding. I'm going to say initial funding because I think that's highly important. City Council voted to utilize the recent sale of a property that it obtained many years ago during urban renewal to fund the initial reparations effort. $2.1 million from the city went into that effort. The county government then followed suit with another $2 million of their own to start that process. I will jump ahead a little bit and say that both of those local governments have agreed to continue with their annual budgets, funding $500,000 each with a 2% escalation. So we just passed our local annual budgets in the last couple of weeks. And each one of those had another combined a little over $1 million. So we are now, despite the fact that we have spent some money, a little over $5 million worth of funding purely out of our local general funds that have started that process. Now, following funding, we did stand up a reparations commission. It's a 25-member commission. And we did this by a joint appointment process, both from the city side and the county side. And what we did was we asked the community to appoint something completely foreign to elected officials. They like to sort of have their hands in that, but they divested themselves of that authority and let what we call our legacy neighborhoods, those communities that had been traditional African-American communities, get together amongst themselves and select representatives. We also had a couple of members selected from our local housing authority communities, so that we ended up with jointly appointed 25-member board with a few alternates. That board has now been going through a 2-year process, and the primary work of that body started out very much on a research focus. With the help of our university and some other local organizers, they have been able to divide themselves into 5 focus areas, and make sure I can get these right. Those 5 focus areas are health and wellness, economic development, education, criminal justice, and housing. And those are the areas that were originally identified in the resolutions that were some of the areas we wanted to focus on to address the harms that we had already identified. So each of those focus areas has been studying and coming up with their own recommendations, and in the past month, the commission has now passed about 45 to 50 recommendations that is going to move forward to the 2 local government boards for final consideration. So we are now at the process of having our work cut out for us because we now have the end of one process and the start of another. So this is a perfect time, I think, to talk about it. With that, I'll hand it back.
Okay, amazing. And I think it would be great to hear some of the flavor of those recommendations as we move into the next pieces of the discussion, but definitely want to turn to Nick to talk about Evanston and lay the groundwork there.
Thank you. Good morning. I want to, like Joseph, echo my thanks to Northeastern and Fordham for hosting me today. This is the second opportunity I've had to share space with Margaret Burnham. Very humbling experience. I felt definitely some imposter syndrome the first time. So this time is no different. Always good to see my brother, Justin Hansford, sharing space with him. We've been lockstep in this journey since my time in Evanston. So always good to see him as well. The one thing about Evanston sort of being the quote-unquote first to do this is we got to make the mistakes that others don't, right? So it's always amazing, especially as one of the folks that sort of designed the legal framework for this work, to hear jurisdictions say, oh, well, we established a commission and did the research first. We decided to identify areas of harm based upon the research we had. Evanston established a fund first, and then passed a resolution and said these are the areas we're going to fix first. And then when I sort of assumed the role of deputy city attorney at the time, I said, well, wait a second, we need to be able to find out what harms we're allowed to fix in the first place. So one of the things that Brad pointed out in terms of the limitations of local government that is sort of very obvious to the lawyers in the room is local government is very restricted by the 14th Amendment. What was once meant to protect the recently emancipated individuals is now being used as a sword to stop them from getting any sort of repair. And so the local governments are not allowed to repair societal discrimination, which is what Evanston is being accused of trying to do with their program. Instead, what they have to do is limit their repair to the harms that they caused. So this is why the harm reports that Professor Hansford talked about are so important. When you do the work and the research to find out what exactly your city government, your state government did, then you can actually shape the repair based on those harms. And so that's what Evanston eventually did. It did develop a harm report, relatively comprehensive harm report, but the low-hanging fruit in that harm report dealt with housing. Evanston's, we have a sound problem again, I just want to make sure. We good? Okay. Evanston, the reason why we started with the period of harm of 1919 and 1969 is the city plan that was developed in 1919 really sort of drew a map that would limit opportunities for where people of color could live within the city. Further on in that work, in trying to implement the city plan in the years of 1930 to 1940, the city established a land clearance commission in which they demolished and or relocated housing of people of African descent around the city. So it was very obvious, like that was the area of harm. Actually, one of the members of the current reparations committee is his home as a child was one of those homes that was relocated out of one place and moved to the 5th Ward. So those are the types of harms that we saw demonstrated and made it very easy to sort of develop this housing program. And so now, fast forward to today, Evanston has paid out the ancestors. The ancestors were those people that lived in Evanston over 18 years of age between 1919 and 1969, could establish that they were residents of Evanston during that time period. They've received payment. Those payments were limited to paying down a mortgage, paying down payment assistance on a new home, repair of that home, and right before I left City of Evanston, cash benefit was discretionary to use towards housing in general. And I think that also gets missing, is I think people assume that that was just like free cash. It is still meant to be part of the housing program to be used towards housing. And that was because you have some ancestors that don't own a home, they rent. And so you want to be able to still establish their repair as well, because in their later stage in life, they're not going to go buy real estate. The focus is on real estate because real estate is sort of a foundational area of wealth building in the United States. So there's that. So now the city has moved on to trying to pay out ancestors, which when we talk about descendants of those ancestors. So when we talk about the lawsuit, that'll be an interesting discussion because all the plaintiffs claim to be descendants of non-African folks in Evanston. Additionally, what goes untold or undertold, if you're not in Evanston, is the city's efforts around other areas of repair beyond just paying out in the housing program. The city is currently underway of redoing its zoning, period. One of the things I highlighted for them is though, okay, we have this housing program that's based on the fact the city plan was discriminatory. We still got some zoning issues that are problematic. So what they've done now is they're trying to actually redo a comprehensive plan to ensure that the city's map is fair, that you can actually have certain types of housing in certain types of neighborhoods, which are currently right now excluded. You know, the favorite lakefront area, you can't have certain types of housing along the lakefront. So they're trying to look at the zoning areas in that. They're looking at reforming how each of this, you know, all of the city's ordinances can affect people fairly and more fairly and equitably, right? Are we enforcing our codes concentrated in one area but not another, right? Are we seeking income from specific wards and not others? So trying to balance that more fairly and equitably as well. And I keep using this "we" as if I'm still there because I'm not. I left Evanston in August of 2013, established my consulting firm to try and help jurisdictions in other private areas do this work. One of our clients is actually the Episcopal Diocese of Chicago. So it's not just government that's doing this. And the last thing before I pass it back, I will say is, you know, these places are institutions. We as lawyers understand that. Institutions are, you know, it doesn't matter who's in office in Asheville or in Boston. It's still the city of Boston, right? You got a new mayor, you got a new city council, but that endures. And I had to learn that lesson hard as a litigator, as an assistant state's attorney a few years ago, representing the sheriff of Cook County. And I decided I was going to, you know, answer a piece of discovery truthfully. But the issue was that same question had been asked previously and had already been answered. And I was stuck with that answer. And so guess what? You're now stuck with all of the acts of the past as an institution, as a government institution. And so you're also stuck with those answers that were previously given. And so when we talk about repair and restoration, we're talking about, even though the people that are in office now didn't do it, the city, the government, the entity is stuck with those decisions that were made back then. And so now we're talking about trying to change and shift the conversation to restoration and repair.
Thank you so much. And I think, I mean, just highlighting a few elements. First, I'm going to start with optimism from Brad. But I think how recent some of these stories are, right? One of the individuals on the commission, his house was torn down or he was removed from it. We're hearing about policies in the 80s. So I think there's a tendency to talk about historic harms without the recognition always that the same policies were playing out 10 years ago, maybe today as well. And we've started to flag a little bit, I think, of the measures that go past the apology and start to think about restitution and non-repetition. But we did promise Martha we would talk specifically about legal challenges, and there's one that has always been present for localities that are trying to be progressive, and that is preemption. So we often think about preemption, right, when federal law prohibits states or localities from doing something. You can also have state preemption, right? You can have a state that is prohibiting localities from passing stronger anti-discrimination laws, for example, or reparative justice measures. I think this morning we already heard about a state trying to say you cannot do that. So we wanted to focus a little bit specifically about how people are either navigating or thinking about state or federal preemption. And Brad, I'm going to start with you because you talked about the county being friendly, but what is the landscape in the state, and how are you all thinking about that, and then also the federal government?
The landscape of the state government in North Carolina is decidedly different from what we have as a local government in Nashville. And let me say this, because I think this will apply to quite a lot of people. I think the primary issue that so many local governments are facing is really the authorizing enabling statutes that local governments have of whether or not you are a home rule state or whether or not you are a Dillon's rule state. And just for the non-lawyers or the people who glaze over when I talk about local government, the simple analysis of this is if you're a home rule state, you have been empowered as local governments to sort of do a lot of stuff. You don't need specific enabling legislation in many things. And unless you are particularly preempted, you're good to go to try stuff. In a Dillon's rule state, which I think is now, at least in some capacity, maybe 30 or 31 total states, you have to have specific state legislation saying you can do something before you can do it. North Carolina is not exactly, but pretty close to a Dillon's rule state. And we're a beautiful state, as I said, so we have a lot of people move to us who used to live in home rule states. So we hear all the wonderful stories about the brilliant ideas that people in home rule states have done at the local level, and they can't figure out why we can't get off our butts and do those same things. We in North Carolina and many other states are particularly limited by the Dillon's rule concept. So the first thing that everybody should look at a local level is whether or not you have that additional leeway of being a home rule state or you are a Dillon's rule state, where you've got to look at specific legislation that enables you to do certain things, which is oftentimes incredibly limited. And I promise you, there's no Dillon's rule state out there that has a reparations enabling statute. That does not exist. So we are having to be, I think, additionally creative around that preemption issue in our state, and I think many other people are dealing with that as well. So be aware that the research applied to particular measures isn't going to always cross state lines, and look to those states that have similar enabling statute at the local level to try to give you some measure of what you might be able to achieve.
Can I just ask if there's been any particular pushback or repercussions from the state? I don't know if you can answer that.
There's a long history in the state of North Carolina of Asheville being the problem child of the state. We love to do interesting things, at least in our minds, and the state likes to remind us that we are not quite as big and powerful as they are. So this is something that we are keenly aware of in terms of the possibility. It hasn't happened yet on this effort, and this is something that, from a legal standpoint, we are not immediately jumping to defending the reparations programs. We are trying to help guide the process such that it is defensible along the way, reminding the people who are legislating for this, who are actively engaging in promoting the programs and forming them, that state action is out there, and that at any point we can have so many of these things taken away. So we want to be very, very careful in what we do as attorneys of not stepping in and guiding the process, but providing the knowledge base to those who are creating it, so that I liken it constantly to, you are in a minefield. Whether it is those who are going to challenge this in litigation or the legislators at the state or additional level that are going to step in at any point and try to usurp that process, let the lawyers help you navigate that minefield. We don't want to tell you where to go. We know your destination, but if we can point out the problems along the way, I think it helps.
Great. And Nick, preemption.
Sure. So Illinois is one of those home rule states. And Evanston is a home rule municipality. But just Illinois in general is a very red state. Cook County, being a population center, is blue. So very blue. Illinois is one of those three states that has its own commission. Very little known commission, but Illinois has its own state commission on reparations as well. So there's two things that in Illinois have been sort of quote unquote problematic. The first being is, Illinois Constitution bans ex post facto laws. So you can't really pass a law that tries to fix something that used to be legal, right? So luckily for Evanston, between the periods of 1919 and 1969, discrimination was already illegal in theory, right? So trying to repair that harm of discrimination is not necessarily an ex post facto issue. The other concerns are the use of public dollars for private benefit, right? That's also banned by the Illinois Constitution. Illinois jurisprudence, however, makes it very easy to create a public benefit. It's not a high hurdle. It's not a heavy burden to create a public benefit under Illinois law. In fact, one of the things we did in Evanston, not related to restoration or repair, but the city sewer system, there's a portion of it that is the responsibility of the homeowner and a portion of it that is the responsibility of the city. City passed a resolution determining it was a public benefit for the city to actually pay for the repair on the homeowner's side, on the building owner's side. And they had some language in the recitals that made it nice and flowery to say, this is for everybody's benefit. This will benefit everybody. And that's all you really need to do in Illinois is basically to say, it's like, oh, this will benefit everybody. Reparations should benefit everybody, right? So using public funds, in Illinois, we couldn't sell a public building and use that money then to fund directly reparations. That would be problematic unless you came up with some rational basis for the public benefit. I get the question though in terms of how you use the marijuana tax, because although the legalization of marijuana and the tax that's assessed is done at the state level, it is given to the municipalities based upon if you have a dispensary in your municipality, and that those profits are shared amongst the two groups. Well, the city, once it gets in the city's hands, because they're home rule, they can do with it what they want. And the same thing with home rule taxes that are levied by the city, specifically by the city, they can do with those taxes what they want. So one of the things Evanston did before I left was use the graduated real estate transfer tax, which is an exclusively home rule tax, to fund the reparations fund. That was also strategic because when you talk about these challenges, which we will probably shortly, who has standing to challenge? At the local level, taxpayer standing is much easier to achieve than it is at the federal level, right? If you don't like how the federal government spends your dollars and you want to sue the federal government based on taxpayer standing, good luck. But if you want to sue your local government based upon how it spends your money, how it spends the general fund, much easier to establish. And so we figured both of those taxes. Marijuana tax is only levied against people who actually buy legalized marijuana in the city of Evanston. The graduated real estate transfer tax only applies to those who sell real estate and pay the real estate transfer tax over $1 million. The property being sold over $1 million pays the graduated real estate transfer tax. Very small pool of people that should be able to challenge based on taxpayer standing. So those are some of we do have home rule, and that's what has helped Evanston sort of skirt some of those issues at the state level.
Just very briefly, Boston as well is under home rule. As we always say in Boston, to prevent the Irish from controlling Boston, the Brahmins took home rule to the state, and therefore there's home rule in certain situations, but in this particular case, discussing reparations, it is not. State government, currently there is some bills that have been filed in order to establish a commission in Massachusetts as to state senator or state representative that have filed that. I don't believe it has passed this session, and it'll probably come up again in the next session, so they have moved in that regard. There's another community in Boston, Amherst has put together a commission, and there's other local groups. I just want to take the liberty to do two things. I wanted to talk about 7 areas of harm that are by this organization called Embrace Boston report, which you can go online and read. And in keeping with what's already mentioned by Professor Hansford, they've looked at 7 areas of injury under culture and symbols, housing, transportation, education, criminal legal systems, health, income, and wealth. And we're having the conversations, collaborating, and there's several community neighborhood groups, and I'll repeat that: culture and symbols, housing, transportation, education, criminal legal systems, health, income, and wealth. That's by a group in Embrace Boston. They just put a statue in commemoration of Dr. Martin Luther King and Coretta Scott King on our in Boston. The one last thing that I do want to say, if I can, and I know I've just learned, I'll just use the mic while I got it, is this. As I said earlier, I'm a reparationist. One of the things I respond to, and you can use this if it works for you, this is the legal side of me, because primarily my practice, Nick, is in zoning. I'm a zoning and permitting practitioner in Boston. And one of the things that I always say to when a person comes up to you and said, well, it's my ancestors that did it, I didn't do it, it wasn't me, I shouldn't have to, deal anything around reparations. My response, since I do real estate law, is this: if any of you have received a relative passes away and they've left you in terms of in the will, and there's a house that's there with a mortgage on it, and you go forward and you go to the bank, I have yet to see a bank say, well, listen, since the mortgagee has passed away, you don't have to pay the mortgage. So that's my response to folks. No, it may not have been you, but I have yet to know a bank that has let the mortgage go. So that's my little imparting some knowledge to you today.
Thanks, everyone. I'm just going to take a break for a second to read out the CLE code. That is BK52M8. BK52M8 for folks who are seeking legal credit. So we've talked a little bit around some of the litigations that are happening, and I think that people are anticipating. So we have about 7 minutes until we take audience questions. So start thinking about your questions. But really wanted to dive a little bit into the current Evanston litigation, and some of the challenges, but also think about what are lessons learned that we want to impart to folks who are thinking about undertaking these efforts. And I will highlight too that Osiris and Nick have created a super helpful toolkit that goes through something many lawyers are scared of: sources of funding and the strengths and downsides of different sources of funding. So we will see if we can get that shared out to folks after the fact, but turn it over to you, Nick.
So I will not go too deep into FIN, because it is active litigation, and I am likely a Rule 26A witness. A couple of things that I sort of previewed and noticed in the complaint is the plaintiffs are all alleged descendants in the complaint. And what's really interesting is that there was a political decision, and I wanted to talk about this briefly, but neglected to bring it up. There's a little bit of history, specifically not just in Evanston, but in the Northern District of Illinois, of how this came about. One of the former alderpersons in Evanston, who's now a judge, was also a lawyer, as well as the current Attorney General in the state of Illinois. They brought a lawsuit back in the 90s in an attempt against private entities, in an attempt to try and get reparations from some of the people who benefited from slavery in the slave trade.
But I think actually communicate in here to ask my question.
Can you please mute yourself? We can hear your personal conversation. Thank you.
No, that's fine. I'm not on camera, and they won't be able to hear if they're doing.
We can hear you, and Martha, you can't chat to people. Very interesting. Thank you.
And so I believe he's now the late Charles Norgal wrote the opinion in that case, dismissing the case, and he was the one that sort of pointed out that reparations and the discussion around reparations is indefinitely, and I believe this term came up during the last discussion, a political question. And so that is why I personally, and now my firm, advocate for a legislative solution, because it is a political question, and for all of the reasons why that we know as lawyers stand, all the hurdles, procedural hurdles in trying to establish Article 3 standing to try and bring a case legally for reparations. And so in establishing the idea that we have ancestors and then their descendants. Those ancestors suffered a harm, and there was a political decision made to provide restitution and repair to the descendants of those ancestors. So then for a group to come in who are the descendants of folks who did not suffer a harm goes outside of the political determination of the city of Evanston. And so I question whether there is now standing for those individuals. Additionally, they did not establish, from my reading of the complaint, maybe I missed it, that they were any of the taxpayers who were harmed by the political decision of the city of Evanston. They did not claim that there was any sort of substantive due process violation on the part of the city of Evanston, that the decision to make this was arbitrary and capricious and that it harmed them in any way. I didn't see any of that. Perhaps I'm wrong. I didn't try to look at it too deeply. My phone was blowing up the day the press release came out, and I'm like, I'm not worried about it. And, and what I told another group of attorneys that are worried about it, at the end of the day, if we fight this thing to the end, and there's a decision that comes out that's negative, that decision will do exactly what Judge Norville did for us in the 90s. That decision will lay out all of the ways that this program is unconstitutional, thus giving us the blueprint on how to make it constitutional. You got to look at it from a different lens, right? And so that when we decided on the legal framework of this, we looked at Croson, we looked at Adirondack, we looked at some of the other cases where the Supreme Court said you can't use race. Well, what are the reasons why they said you can't use race? Let's dissect that and figure out, well, these are the areas in which you can use race. Justin pointed out earlier about the affirmative action decision. Two issues with that. First, it's very limited to affirmative action and education programs. It doesn't talk about affirmative action in any other context because, as far as I know, the Department of Labor still has rules for affirmative action programs in employment. And guess what? It lays out very specifically, if you can lay out the case as an organization that you were discriminatory in hiring and promotion, then you can have an affirmative action program. Very, very plainly. The problem with affirmative action education, as Justin pointed out earlier, none of these institutions wanted to say we were racist in our admissions. And so now we don't have, we don't have affirmative action. We can't have affirmative action education because no one was willing to admit that. So if you're able to admit and show the case, you should be able to implement some sort of program similar to what Evanston has done. Evanston has admitted it in multiple resolutions. They have now laid the case with this harm report, and so we will see what happens with the litigation, but I am optimistic based upon the things that I just talked about.
Great. And I want to give Boston, Joseph, a chance to share anything you haven't covered yet? No? You're good? Brad?
I just want to add one thing that I think expands this a little bit, and not particular to Evanston, but we're thinking constantly, watching, again, what that blueprint might be, or if it's a successful outcome, then we have the blueprint on the other side. When you are beginning to think about what a reparations program might look like, there are two schools of thought. There are we understand that strict scrutiny is going to be the bar that we have to get over, and let's run into it and let's hit that with all the vigor and the background and the evidence that we need to create that compelling interest, and then narrowly tailor it. But I think that's great, and I don't think you should run from that. But I believe that you're missing an opportunity in your programming if you are not looking at other alternatives that might not necessarily require that strict scrutiny bar. We have received, as I mentioned, over 45 recommendations from our commission that included, they would send them to me and they would say, how hard is this going to be a fight? Can we win this one? And I would say sometimes, this is going to be hard. This one's going to be tricky. But I would get some and say, this is easy. You don't need me on these. Well, I never say you don't need me. They always need me. But they had situations that were suggestions on policy changes, implementing equity training requirements. And just as an example, we have the ability in North Carolina, despite not being a home rule state, to spend on economic and community development initiatives. Well, there's lots of things that we can do around community development and economic development that will directly benefit, in large part, the community that we feel needs repairing, without ever even using the word race or black. And I admit that strikes even some of my commission badly sometimes when I say that. And I tell them, I'm not going to say that you should do this, but know that it's out there. Know that I could say we could design a grant program that provides reparations for those that suffered from urban renewal, that came from some of our historically, what we call legacy communities. And not one time did I say black Ashevilleans in that. And I tell them, that's just an example, and that's not fully fleshed out, but I may not trigger strict scrutiny in that. And that allows us a stronger potential defense to some of the things that I think Evanston is going. So I do think there might be a second avenue that you should consider.
Okay. It's time for you all to ask questions. Yes, I'm just going to ask you, if you can, to go up to the microphone so we can make sure we all hear you and the folks on Zoom. So I think we'll take the first two questions, and then we'll answer those in turn.
Thank you very much. My name is Larry Pickens, and I serve the Pennsylvania Council of Churches in Harrisburg, Pennsylvania. And when Mr. Burnham was sharing the areas that their commission is addressing in Asheville, I was kind of intrigued because I think the city plays a policy-making role, but I'm interested in knowing whether there has been buy-in, and maybe this applies to everyone, from the business sector, healthcare industry, faith communities, the criminal justice apparatus, in terms of moving toward the direction in which you're going as a city.
Yeah, we'll take your question as well, and then we can have a bit of a conversation about this.
Sure, wonderful, thank you. My name is Jean-Pierre Brutus. I'm the convener of New Jersey Reparations Council, and I just want to thank you all for the work that you're doing. This question is for Nicholas. You've been very intentional and thoughtful about the design of the Evanston Reparations Program, particularly anticipating this kind of attack. My question for you is around strict scrutiny. As you pointed out, the Evanston program is designed specifically for a particular time period, 1919 and 1969, and those who are ancestors have to demonstrate that they lived at that particular time. One of the things I'm wondering is whether, given how reactionary SCOTUS is, but SCOTUS has been historically, since the inception of the 14th Amendment, on racial justice and on the original interpretation of the 14th Amendment being race conscious, right, and empowering legislature to be race conscious in coming up with remedies, is whether you anticipate the court saying that simply living in Evanston as a black person in that time is not enough to demonstrate that one was harmed, but rather those who are ancestors must demonstrate with documentation or other forms that they were harmed specifically by the redlining. And so the idea that just by living in Evanston in a particular moment is really societal discrimination. So for example, you point out that Evanston admits that they engage in discrimination under redlining during this time period. One can see the state of Illinois then saying, we discriminated against black people during this time period. Then the US government could say, and the SCOTUS could say, oh, that is a societal discrimination. Every black person who thinks that they've been harmed has to then demonstrate with documentation or some way, we've been harmed. And I just wonder whether, rather than, dismissing the case on standing, let the case pass, go to the actual material elements of the case, and narrow it so, and create the threshold that's so high, it's so limited, right? And we are at this point where, after every kind of dismissal, the Fourth Amendment gets narrowed and narrowed and narrowed and narrowed and narrowed. So the terrain in which we are arguing is this small little space, right? Rather than going back to the origin of the 14th Amendment about how expansive and powerful it is. So I just want to raise that, whether you think SCOTUS can be sort of cynical in that regard, because as we know, not everyone has documentation or can prove documentation for being harmed, right? And some harms were not even documented, right? Even though we know how widespread the harm was. So I just want to raise that.
So there's There's a question about definitions and how defining a class, I think as we talked about it earlier, can have some potential downsides because it ends up limiting what is otherwise a transformational objective. And then there's also the question for Asheville, but for other jurisdictions as well, about buy-in from faith groups, business community, and who else have been champions that either was surprising or that's been really important.
And I just want to answer your question, Mr. Pickens. Just in Boston, we're the youngest of the three in terms of starting our program, so I can't speak to results at the present time. However, I can say to you that there's a Episcopal Church in Massachusetts that's engaged in looking at this issue. We've had Harvard University and other universities speak to that issue as well. Yeah, there could be Lutherans as well in other places, but I'm not sure that I'm aware of that in Massachusetts. But the other thing is, and then you start talking about institutions. I'm not going to name them. Certain institutions have stated that they're looking at it. They're waiting to see what we do in Boston with regards to that. So that's what we do. So there are others that are supportive of the effort and will get involved.
The idea to do a little bit more group thinking on
Somebody needs to get this is the reason why at conferences, why you have the mute button for when people are online.
We can't hear the speakers again.
Because you're being very, very disrespectful to this body.
We can't hear.
So they can't hear now.
That's one person.
It was the same.
The speaker is muted.
You guys should be good.
Okay, sorry about the sound issues in the room, but we can also hear personal conversations happening off screen, so just be mindful of muting. Nick?
So Evanston does have buy-in as well. There's actually an alliance, a faith-based alliance that is working alongside there's actually a community arm as well as the city's reparations committee, sort of that are all sort of working hand in hand. So there is buy-in within the community outside of just the city as well. With respect to the question regarding the definition that was presented in order designing the Evanston program. So the city wanted to take more of a class-based approach as opposed to putting the burden on the harmed party who is entitled to repair to try and prove that they were harmed. Somewhat similar to Rosewood in Florida, similar to the Civil Liberties Act in 1988. There was a certain amount of documentation required, right? But you didn't necessarily have to say that I was living at 123 Ash Street that was torn down by 5 white men as part of the mob in Rosewood on this date in order to receive reparations from the state of Florida, as far as I'm aware. Now, that was intentional. And, part of the issue with the 14th Amendment in terms of authorizing legislation to enforce it is that power vests, according to the Supreme Court, primarily and only with the federal government, who at this point has only taken the steps of passing the Civil Rights Acts of 1965 and et cetera, which didn't include any sort of reparative or restoration at all. It certainly banned the practice, but it didn't provide any sort of repair or restitution to those who have been harmed by legal forms of discrimination even after the 14th Amendment was passed. So I am neutral on whether it should go all the way to the Supreme Court, particularly this Supreme Court, for them to say, yes, people need to basically make a case, almost like administrative adjudication, and come before the city council or whatever body the city council establishes and says, I was harmed. In Evanston, I talked about one of the members of the committee, his family home being moved. That street doesn't exist anymore, right? But for the old maps being required to be held by the city clerk, we wouldn't even know where this was, because if you walk the city of Evanston, it's not there. right? So you can't say, like, oh, I used to live at this location, and you would go and look and say, well, I can't find that on Google Maps, because it's not there. So, hopefully the record that's been established is sufficient to show that, the city has established this record of harm, and that these people can opt into that record as opposed to having to prove for themselves that record, and the city then defend it and say, well, we need you to show that that we did this, as opposed to the city saying, we did this, and now we want you to just make sure that you were one of those people that we did it to, much like a class action.
Just to respond to the buy-in question from this gentleman, it's a mixed bag is the answer. I hope it's increasing and improving, but here's why that's important. Although local governments were absolutely complicit in many cases, and Asheville has admitted that as part of a resolution in the harms that were perpetrated, it is not the end of the story in terms of the harms that were created. The business community absolutely played a role in that, and other institutions as well. We see those disparities across education, healthcare, and other areas where I think if you are going to have a holistic solution, the local government can only do so much. A legislative solution takes you a great deal of the way, but it does not directly address or even recognize some of the harms that were primarily from other members or segments of that community. So I think as we move forward in Asheville, and I think as other initiatives move forward, it's going to be really important to move beyond just the purely governmental actor in this, and to get, quite frankly, to get funding options from some business communities that don't have some of the same limitations that you're going to have from governmental public funds. So we are beginning to engage those other aspects in our education system, our healthcare system, as well as the business community. We'd love for not just participation, but some check writing as well.
And one of the, just piggyback on what Brad was saying, is one of the things that my organization sort of advocates for when we talk about messaging is in your harm report, it definitely needs to be exclusive to your entity, right? However, if you happen to come across other information from other bodies that were involved in some of the harm, there's no harm in publishing that, right? To say, well, Chase, you divested in these communities significantly, or you discriminated against these folks significantly and didn't allow them to get loans or business loans or home loans. And that sort of ability to shame folks into a way of participating in your efforts is always something to consider.
I just wanted to add one quick point on that. That's the reason why in Boston we started with the researchers that I mentioned, because that's going to speak to, and I anticipate it's going to be speaking to individuals, institutions, educational, as well as businesses that benefited from the transatlantic slave trade, and that's going to come forward and, if you will, flush out some individuals who are going to have to get into the conversation that both Brad and Nick have said. So I think that's why we started with the research.
And we took it full circle to naming and shaming, which is a very classic human rights strategy for advocacy. But we have, I think, 2 more questions, or at least a question and a comment. So please go ahead.
Oh, yeah, I've got the questions from the Zoom. So if I could just quickly.
Yes, please, go ahead.
One is, Joanne, could you please repeat the code one more time with clarity about what the letters are?
That is BK52M8, B as in basic, K as in Kansas, 52, M as in Mary, 8.
Thank you. And then quickly, because I know we're almost out of time, got one question here about whether there is any recourse for people who are part of the African diaspora but who are in the United States. And then second, maybe easier to answer, is what level of participation what kind of participation has there been of people affected in devising the reparations measures?
Great, and let's take the last question also, and then we can answer those.
Well, I would like to maybe ask a question, also make a comment. I've once compared the European Court of Justice with the Supreme Court that we have, and our court tends to be a little bit more political. and it really winds up being majoritarian. And in general, if they are a majoritarian kind of court, it will be very unlikely for them to be sympathetic, I think, to the reparation issue, the reparation need. So you would like a comment on that if possible. In addition, historically, most reparations have been a lump sum of money, but the way it's been described by the panelists, it seems it's a cocktail of different issues. Why not one lump sum of money as it was done in other cases of reparations?
Well, the first thing I will say to that particular question, local government typically doesn't have the funding to just make the simple lump sum. And even when it does, it's simply not enough to establish a repair. I know a conversation that Brad and I were having prior to this program starting during the breakfast portion was that it doesn't actually, it's finite, right? You get that one lump sum payment, and then after a generation, if a generation, it's that repair is gone. So you want to establish something that actually goes beyond just that one lump sum. With respect to people being involved in coming up with a repair, that is sort of one of the pillars of this work, is community engagement and actually getting the harmed party involved to sort of establish what they want to see as part of the repair. We don't want to be paternalistic with the repair. The harming party should not tell the harmed party what the repair is going to be. Although the harming party has the resources to try and identify, do the research, for example, to find out what harms were done, they should not actually then say, well, this is how we're going to fix it. So it is very important that, and has been at least in Evanston's instance, and I want to say in Asheville as well, that the harmed party has had a seat at the table to be able to engage in those conversations. And I can't remember the other question that you asked, Martha. Oh, the African diaspora. So Evanston took a very unique approach and was very broad in its definition of who would be eligible based on blackness. That is a conversation within, and I understand that I'm a mixed company, within the black community as to who deserves reparations, right? There's a whole descendants of slaves, right? And to me, it's kind of short-sighted insofar as there are a lot of people, and I had the fortunate opportunity to attend the Permanent Forum of People of African Descent in Geneva, Switzerland recently, that don't speak like me, that don't come from where I come from, but look like me and have the same problems that people where I come from have where they come from, right? So it's short-sighted to say, well, only people of African descent, because there are people who are descendants of people who were captured as part of the transatlantic slave trade in this hemisphere who suffer the same harms that should be eligible for these conversations, regardless of their last name or whatever it is that you want to identify. So I think the conversation should broaden slightly, but that's not for me to say. And I acknowledged Evanston for taking that stance of defining it very broadly when they came up with the program.
Well, Victor, I don't know if you were a plant or not, because you want to make my job more difficult when I get back to Boston on that particular question as to who should be. As you can recall, when I made the four things that I said we had to consider, one was who was entitled to reparations. We've narrowed, at least as far as with the task force and what we've asked the researchers to do, we've narrowed ours. We've used the Freedmen Bureau definition, which talks about persons who are descendants of persons who came through the diaspora. One of the positions is, and I don't want to speak for the task force, but what has been articulated is that there is a folks who are descendants of folks from the transatlantic are the only persons who have come to this country not of their own free will. So we've narrowed ours in that regard. Now, having said that, certainly as you get into periods of time 1940s on, which is what Northeastern will be covering. We have the urban renewal. We have something in Boston was called Beberg, where people were areas were red lines. We've had all of those things, and that may more broadly incorporate persons from throughout the diaspora. But we're going to wait to hear what the research is. So I don't think, contrary to my good friend here in terms of Nick, I'm not going to say that we have to right now go that broadly, but great minds can differ on that particular point, and I'm sure that's going to be the community conversation. I can't wait after we get the research, and what I'm going to do, my hair will probably be grayer by the time that I get through that conversation, but nonetheless, we will get there.
We are over time. Last word, just if you live in New York, there is a state reparations commission, and there's legislation pending in New York City for reparations task force as well. So stay tuned for future New York conversations, and please join me in thanking the panelists for their expertise and time.
Hi, everyone. I'm Cindy Suhu. I'm a professor at CUNY School of Law, and I have the honor of moderating this panel that's going to bring us to lunch. We're starting about 5 minutes late, so I think we'll probably run 5 minutes late. And before we start, I just want to thank Martha Davis and Northeastern and Fordham Law School for hosting us for this day of CLE. I think it's been really, really fascinating so far. I'm really looking forward to the rest of the panel, rest of the day. I'm really excited today about this conversation with advocates who've been working to get and implement reparations. And we hope that this panel will help to inspire people to think about creative approaches, both in terms of how to try to achieve reparations and also what reparations might look like. It's really an outstanding group, and I definitely do not have time to go through their bios in depth, so I'm just going to ask that you refer to the bios in your programs. And I'll just give you brief information about them to give you context about the expertise and the work that they've been doing. So Roxana Oltos, who's at the end, is a clinical professor of law, the director of the Human Rights Clinic, and co-director of the clinic program at Berkeley Law. She's won several groundbreaking judgments at the Inter-American Court of Human Rights. Next to her is Randall Adams, who's a partner at Schulte, Roth, and Zabel. He represents the last survivors of the 1921 Tulsa Race Massacre in litigation in the state of Oklahoma, and he's going to talk about that case. Sylvia Yee is a senior staff attorney at the Disability Rights and Education Fund and has worked on implementation of reparations for survivors of forced sterilization in California. And then to my left is Joey Mogul, who's the director of Movement Partnerships at the Movement Law Lab and is counsel at the People's Law Office in Chicago. For over 25 years, I can't believe it, Joey has sought justice for survivors of police torture in Chicago. So I want to start off, I feel like Justin and Margaret really did a great job of laying a groundwork about the elements of reparations under international law, but as my teaching colleagues at CUNY have told me, a lot of times we need to hear things at least 3 times for it to stick. So I'm going to ask Roxana to describe how reparations are understood under international law, including going over the 5 components, and then to give an example of what reparations have looked like in cases that she's worked on.
Thank you so much. I'm so happy to be here. Just in the planning call for this panel, I learned so much, and I've learned so much this morning so far. I'm going to ask for your grace. I can't complain. I just spent 2.5 weeks surfing with my family in Nicaragua, which was amazing, but I got a really nasty cold at the end, and I feel like I'm in a fog of NyQuil and Dayquil and everything quills, so please be patient with me. I'm going to do the best I can to form coherent thoughts. I know that Justin really outlined the 5 components of the international approach to reparations, but I wanted to ground that, drawing on some of my experience litigating human rights cases, mostly in Latin America. But I've certainly brought those experiences to bear on the work that I've done in the United States in defense of human rights. I think the question that the reparations framework seeks to answer is, what does justice look like? At one point, I think Justin said, if you go to the streets and you ask, well, what does reparations look like? The response can be, well, where's the compensation? But I think the question is what does justice look like for some of the worst harms that humanity has done to itself? And generally, the U.S. legal system answers that question with money and jail time. That's what the U.S. legal system has to offer in terms of justice. And international courts have provided a much more capacious, a much more expansive answer to that question, especially for violations of life and limb. So these are crimes, violent acts such as torture, disappearance, and killings. International courts have upheld that states who commit acts of grave violence have an obligation to provide reparations to victims and their families for the harm suffered and ensure that the violations do not occur. And what is the kind of principle that is underlying that approach to reparations is that the state must wipe out, insofar as it is possible, all consequences of the legal act and reestablish the situation as it would have been if that act had never been committed. Now, obviously, in cases of gross violations of human rights, it's not an achievable goal. So in those cases, international law prescribes measures that states must implement, including measures of compensation, rehabilitation, satisfaction, guarantees of non-repetition. So for the last couple of decades, I've sued governments for human rights violations with a specialty in massacres, extrajudicial killings, torture, and forced disappearances. And I wanted to talk a little bit quickly about how governments have followed the orders, mainly of the Inter-American Court, in implementing these different measures of reparations. And first I wanted to kind of underscore the importance of restitution. So measures of restitutions are meant to restore the victim to the original situation before the violation occurred. And those, in cases of property, particularly ancestral property of lands of an indigenous people, restitution has been a really important measure. So per Inter-American Court orders, states have actually restored land. You can also imagine in cases of political prisoners, liberty, when violations of liberty have occurred per Inter-American Court orders, states have released prisoners, reunified families that have been separated, restored legal status, rights to citizenship when those rights have been violated. In cases, in terms of the measure of rehabilitation, those measures have been really important in cases, for example, of forced disappearance. Forced disappearance, I think, in my experience, is one of the cruelest crimes. Forced disappearance really atomizes a family because often the family is completely destroyed when a father, a brother, a mother, or sister disappears, and there's no answer to where that individual is. And so the way the Inter-American Court has responded to that kind of very dire situation, and in thinking about reparations, among other measures, is to require the state to provide the child of the disappeared, the siblings of the disappeared, an opportunity to try to recover their life plan, which is the word of the phrase the court will often use, through educational scholarships, through access to other rehabilitative measures such as psychological support or medical attention. Compensation. Compensation has been actually a very, one of the measures that we've seen most frequently abided by states when ordered by the Inter-American Court to provide compensation. The amounts have been quite large in some cases. And in certain countries, like the country of Colombia, the order of compensation has had a big impact because there's a law, for example, in that country that requires the institution responsible for the violation to pay the compensation. So the compensation comes directly from the budget of the institution responsible for the violation. Most of the cases I litigated involved the military and the police. I got one order of upwards of $30 million, which is a significant amount of money for the military to pay, for the military to come directly from their budget. Unfortunately, it's also the measure that the states have been most likely to abide by, to adhere to. And there has been preoccupation among those of us who litigate before the Inter-American system that we're kind of creating a kill and pay policy. Satisfaction, which is another measure. And in here I just wanted to underscore, apology is a form of satisfaction. It's a form of cessation. It's seen from the international perspective as a cessation measure. And I think that's an important element to keep in mind when we're thinking about an apology. An apology isn't something that is just word. It has to be accompanied by deed, by action. It is a form of cessation. And some of the apologies that I've been privileged enough to participate in have been extraordinarily impactful. I litigated a case against Guatemala involving the assassination of an anthropologist who was one of the first persons to document the military scorched earth policy during the genocide in Guatemala. And the apology took place in the National Palace by the president in front of 3,000 people, including the entire Supreme Court and the entire command of the military. And those kinds of apologies can be extraordinarily impactful symbolically, not just to the family members. Guarantees of non-repetition. Some of those guarantees have already been mentioned. They can include training, codes of conduct, mechanisms to monitor violations. I think one of the more important measures of non-repetition, however, is legal reform. Changes to law in Latin America. One of the more important reforms that were achieved through litigation was really limiting the jurisdiction of the military court system that historically in Latin America was trying civilians and also trying their own members for violations of human rights. And through really decades of litigation, that has become a practice that is almost, is no longer common in Latin America. And lastly, which is really considered the gold standard of reparations, is investigation and prosecution and punishment. There has been cases where very high-ranking officials have been prosecuted and convicted for violations per Inter-American court orders. Just to finish quickly, I wanted to measure these particular concrete measures because I think in the United States sometimes we suffer from a lack of imagination given how cramped our notions of justice is in this country. Some of these measures, as I mentioned, were achieved through court order, but some were achieved through friendly settlement, something that the United States has never engaged in before the Inter-American Commission, although it has a pipeline of cases coming through involving such serious violations as the Michael Brown case, but many, many other cases of extrajudicial killings and other cases of state violence. And I guess I'll end there. Thank you.
Thanks, Roxana. So what I'd like to do is give each of the other panelists about 7 minutes just to give an overview of the issue that you worked on and why reparations were important and the form that it took or the form that you sought. So maybe Randall will go first and we'll just move down the line.
Sure. Again, thank you for having me on this panel. So the title of the panel is Creative Solutions. And what's interesting about, I think, our case was the case in which we represent the last living survivors of the Tulsa Race Massacre of 1921 in an action against the city and the state of Oklahoma and the county of Tulsa and the sheriff and the Chamber of Commerce, is that it's just, if you just read the text of the statute we're relying on, there's actually nothing particularly creative about it. It's a public nuisance claim and the statute says that a nuisance consists in unlawfully doing an act or omitting to perform a duty which either annoys, injures, or endangers the comfort, repose, health, or safety of others, that's one prong, or it can offend decency, that's the second prong. There's a third prong that applies to navigable rivers, which we concede does not apply. But the last prong is in any way renders other persons insecure in life or in the use of property, provided that this section shall not apply to agricultural activities. So as everyone in this room knows, on May 31st, 1921, a white mob descended on the Greenwood neighborhood in Tulsa, destroyed 40 square blocks, killed 300 people, and otherwise eliminated what had been a thriving black neighborhood. And, oh, sorry. Closer, okay. Oh gosh, I wasn't, oh, okay, now you can hear me, all right. Sorry. The destruction of the neighborhood on that night, which... all right.
Can the people on the computer please mute your Zoom?
All right. So clearly, the destruction of a neighborhood satisfies the statutory text that I went through
You are
pretty.
muted now.
We're muted now?
Yeah, we can't hear you.
Okay.
Do we have
Yeah,
to
I'm not sure.
unmute us?
So I think he's going to try and unmute us. So just hold on 1 second, Rana.
We can't hear you.
Yeah, we're
Working on it.
We're working on it. I know they can't hear that we're working on it, but
You guys are unmuted.
All right. Can you hear us now? Okay.
Okay.
But we can't. Okay, perfect. Okay. All right. So, and then what we brought was a public nuisance claim. A public nuisance is one which affects at the same time an entire community or neighborhood. And then you might ask, well, what about the statute of limitations? The statute also says no lapse of time can legalize a public nuisance amounting to the obstruction of a public right. So again, based on that statutory text, the destruction of an entire neighborhood in one city in Oklahoma obviously should constitute a public nuisance. And so we brought a public nuisance claim on behalf of then the last 3 living survivors of the massacre, as well as a group of descendants of people who'd been affected by the massacre. And of course, the city and the state all moved to dismiss. We opposed those motions to dismiss in August of 2022. The court ruled that we had adequately alleged a public nuisance. However, we were dismissed for failure to state a cognizable abatement remedy. In our first complaint, we had set forth an abatement plan which had included things like a victims' compensation fund, scholarships, tax abatements. In the massacre, there was a hospital in Greenwood which was destroyed, which was never rebuilt, so we asked for the rebuilding of a hospital. And the court ruled that those things weren't cognizable, so the case should be dismissed. Oklahoma is a notice pleading statute, so there's no Iqbal, there's no Twombly, and all you have to do is state a claim, and there actually is no basis to dismiss a case for failure to allege a cognizable remedy. So the court just got that wrong, and when we repled the case, we actually took out the abatement plan and just said, okay, we're just requesting abatement, period. And that's enough under notice pleading standards in Oklahoma. And then the city and the state and everyone moved to dismiss us again. The court sat on that motion for a year. In a one-page opinion, dismissed our case, saying that it presented a political question, and then we appealed to the Oklahoma Supreme Court, and we were hoping to get that decision reversed, at least on procedural grounds, but last week, and since we did the planning for this panel, the Oklahoma Supreme Court affirmed the dismissal, which was quite heartbreaking for all of us, and obviously not the outcome we were looking for. We will be moving for a petition for rehearing before the Supreme Court, so the case lives on, at least through that petition. But, I'll get into this more, but what we found is really that just a different set of rules apply to us and to our clients. We absolutely stated a claim for a public nuisance. You all heard me read the text of the statute. How can the massacre not constitute a public nuisance, at least at the motion to dismiss stage? At a minimum, our clients were entitled to a trial to present evidence about the massacre, to take the stand and talk about their experiences and their families' experiences. And what we did or did not prove at trial was something that the Supreme Court could take up at that point. But to decide that we are not even entitled to a trial on the basis of a motion to dismiss, we thought is a real, I mean, it seems like an understatement to say, but a real miscarriage of justice. And so we'll be working on a petition for rehearing, which we're hopeful to be successful, but that's what our case has been for the last few years.
Thanks, Rhonda. I feel like that your case is a real great example of creative approaches and creative litigation approaches, and just also the way that you built sort of a reparations plan into the abatement plan. And hopefully maybe this is a model for other places, but I do think you're raising this issue of even when you have good creative legal claims, the hostility of the judiciary, especially in states like Oklahoma, is going to continue to be a challenge. Sylvia, I'll turn it over to you.
Thank you. Sorry. I just want to make sure it's on.
Yeah.
Hello. Thank you for the opportunity to be here and to speak. Mine is, I'll be speaking about a disability-related reparations scheme and a legislative one. So over 60,000 people were sterilized nationally in 32 U.S. states that adopted eugenics laws between 1907 and 1937. 1/3 of this total, or about 20,000 voluntary sterilizations, occurred in California, which had laws on the books between 1909 and as recently as 1979. Dr. Alex Stern is a professor formerly at University of Michigan and now at UCLA, who has deeply researched the operation of eugenics laws in the US. She approached DREDF, my organization, several years ago with a fascinating story of almost accidentally, while conducting research, finding a number of microfilm reels in a filing cabinet at the administrative offices of what used to be called the Department of Mental Health. It's now the Department of State Hospitals in California. The microfilm reels contained sterilization recommendations and the medical records for residents of state mental institutions between 1919 and 1952, the most active period of sterilization in California. In Dr. Stern's words, her data set revealed that those sterilized in state institutions often were young women pronounced promiscuous, the sons and daughters of Mexican, Italian, and Japanese immigrants, frequently with parents too destitute to care for them, and men and women who transgressed sexual norms. Preliminary statistical analysis demonstrates that during the peak decade of operations from 1935 to 1944, Spanish surnamed patients were 3.5 times more likely to be sterilized than patients in the general institutional population. There was a clear and strong racist element to California's sterilizations as people of color were institutionalized, with that institutionalization becoming the legal key to recommending and implementing sterilization. The law could either obviate the need for any consent, certainly at the beginning that was true, or consent could be obtained by dangling it as a condition for release from institutionalization. I have to note, however, that as a disability advocate and attorney, I object not only to the sterilization of people of color under the guise of having disability imputed to them, I equally object to the involuntary sterilization of people with disabilities of any race. I think it's equally heinous. And the International Convention on the Rights of Persons with Disabilities explicitly recognizes that. Even after the repeal of California's historic eugenics laws, we saw a disturbing repetition of involuntary sterilization when at least 146 female inmates in 2 of California's women's prisons received 2 allegations between 2006 and 2010 that failed to follow the state's own informed consent processes. As Dr. Stern notes, the majority of these female inmates were first-time offenders, African American, or Latino. Reparative and a coalition of other organizations, including California Latinas for Reproductive Justice and the California Coalition for Women Prisoners, fought for 2 years to pass legislation that would recognize and compensate these victims of involuntary and forced sterilization. Virginia and North Carolina are the only other states to have passed such a law. In 2003, then Governor Gray Davis of California apologized for the state's eugenic history. Note that the prison sterilizations happened several years after this apology. The reparations law, which ultimately was called the Forced or Involuntary Sterilization Compensation Program, finally passed in the fall of 2021 and sought to move beyond mere words. We all felt that it was important to concretely acknowledge the multiple economic, social, cultural, and physical and psychological harms that came with involuntary or forced sterilization, harms that individuals endured on their own, sometimes only discovering years later that they could never have children. Some never even knew they had been sterilized. We sought outreach to survivors and monetary compensation for them, even as the group of historic survivors in particular rapidly dwindled. The Sterilization and Social Justice Lab used historical data and projected that as of 2021, there were 455 living survivors of the eugenics laws, with 68% women who were on average 17 years old at the time of sterilization. I think that number might be down to between 200 and 300 as of the end of the application period, which was December 31st, 2023. We also managed to neutralize the potential state tax and benefits eligibility consequences of receiving compensation and set aside funds for memorialization of those who had been sterilized. We didn't seek any additional changes in laws as legislative repeal and change had already occurred, but at one point we sought to specify inclusion of eugenics history in California's public education requirements. This goal was eventually dropped, and maybe I'll get a chance to say why later. What we did get was $4.5 million to be equally split among eligible survivors, $2 million for the administration and outreach of the program, and $1 million for the establishment of markers or plaques at designated sites to memorialize thousands of wrongfully sterilized individuals in California. I have to say that implementation of the law was really challenging, especially when it came to 3 specific elements: outreach to both historic and contemporary survivor groups, how the applications were administered. The California Victims' Compensation Board acted as gatekeepers of compensation, and memorialization. The final June 4th report that I received from the California Victims' Compensation Board showed that there were 573 applications received. 118 of these were approved, and 431 were denied. 24 were closed because the applications were incomplete. Of the 118 approved applications, 115 were supported by the Department of Corrections and Rehabilitation's records. 3 were supported by the Department of Developmental Services. By the Department of Developmental Services, and none were from the Department of State Hospitals. And I still think of that a lot. 3 historic survivors were compensated.
Thanks, Sylvia. And I think hopefully we'll have more time to talk about the challenges of implementation, but also just interesting to underscore, that there was an apology and yet forced sterilization continued, though in a different form. So just thinking about how that could have happened. So Joey, I'm going to turn it over to you.
Hello, can you hear me? Great. It's such an honor to be here, and I really want to thank all the organizers for putting this together. I just also want to honor Margaret Burnham, who's been such a visionary thinker and a trailblazer for us all. I was the representative from Chicago who went to the Committee Against Torture in 2006, and I just want to name, I had no idea what I was doing at the UN, and there were many advocates here in this room that taught me the way. I have been one of many organizers, lawyers, and survivors who have struggled for justice and accountability in the Chicago police torture cases. And these are a series of cases where former police commander John Burge and white detectives under his command were responsible for torturing over 125 Black people in Chicago. And when we use the word torture, we don't do so lightly, flippantly, and we're not exaggerating. I'm going to go into the specifics, and here's a little bit of a trigger warning, but I think it's important because often I know one of the struggles in these cases was to get these acts deemed as torture. Particularly when it's by state actors, there's a reluctance by politicians and the media to call it torture when in fact it is. These police officers used electric shock boxes, cattle prods, suffocated people with typewriter covers and garbage bags, hit people with blackjacks and other devices, telephone books, that caused excruciating physical pain, but often left no marks. In addition to depriving people of access to attorneys, family members, loved ones, bathroom facilities for hours on end, until they all forced to confess to crimes that maybe some of them had committed, but some of them had not. But regardless, torture is never acceptable under international law, federal law, state law. In addition to the excruciating physical pain, these officers used racist violence, calling the survivors racist epithets and slurs to break their will and again to force them to confess. These confessions were then used in their criminal cases to convict individuals and sentence individuals, and in the case of 11, send them to Illinois' notorious death row. Now, another huge harm that came from this was not just that individuals were tortured, but that they then had these confessions used against them in their criminal cases. And so many of them went into court and they brought what's known as the motions to suppress to bar the use of these confessions. And the confessions were always admitted against them because these white officers went in, they testified, they denied they or others engaged in torture, and no one believed the Black torture survivors. And that led to just this profound level of disbelief that has haunted the survivors as well. So the struggle for the torture survivors has lasted for decades. It cannot be covered in 7 minutes. But a lot of the struggle began with litigation, representing people in their criminal cases and then representing people in their civil rights cases. I will say in every single case, if you look at this in the Chicago police torture cases, our most profound and holistic wins came outside of the courts and instead came through organizing and in the courts of public opinion. First, it was a struggle for what was known as the Death Row 10. These were torture survivors on Illinois' death row who named themselves the Death Row 10, who organized on their behalf, who solicited their own family members and organizers to help them. That movement then joined with a larger anti-death penalty movement that led to the massive clemency campaign in Illinois that was successful in 2003, that cleared all people off of Illinois' death row and then led to the abolition of the death penalty. The torture cases played a huge role in that. We then went to the international arena thanks to Standish Willis, who's an amazing civil rights attorney and founder of Black People Against Police Torture. We did get findings from the UN Committee Against Torture, calling on the US government to bring the perpetrators to justice. That led to John Burge eventually being prosecuted for perjury and obstruction of justice, not for the torture he committed, because those statute of limitations had expired, but for lying about the torture that occurred under his command at Area 2 and 3 police headquarters. I will tell you, though, that I was someone who obviously went to the UN. I wanted Burge prosecuted. I refused to call myself an abolitionist because I so wanted police officers to be held responsible. And I've spent the bulk of my litigation career suing Chicago police officers and among several others for their violations. But I will tell you that in terms of Burge's conviction for perjury and obstruction of justice, it was truly a hollow victory. Because it did not provide any measures or redress for the material needs of the torture survivors, let alone their family members and the affected Black communities that suffered because of this torture regime. There was no place for many of them to sue because the statute of limitations had expired decades ago, so there was no way to get any financial compensation. Further, there was no place for any of the survivors or their family members to go get any psychological counseling or wellness services, particularly those that are state trauma informed. The fact is, around the United States, the federal government provides resources to over maybe 20 to 30 psychological counseling centers that provide counseling to torture survivors. But those centers are focused and only can get federal resources for providing services to people who've been tortured outside the United States, not for people who've been tortured inside the United States, because our government refuses to acknowledge that law enforcement officers are torturing Black and brown people day in and day out. And so it was after Burge's conviction that I helped start this group known as Chicago Torture Justice Memorials. And it was in an artistic process where I actually drafted the reparations ordinance for Chicago police torture survivors. And we did not plan on launching a campaign to get the reparations legislation passed in the city of Chicago. But Rahm Emanuel actually made an apology in response to the settlement of 2 civil rights cases, and I just want to acknowledge what Justin said. I do think there is a lot of power in apology, but we need to make that apology mean something. And so Rahm Emanuel, in his typical half-hearted, insincere way, made a very demeaning apology that really incensed so many of the survivors, and myself included. And we then launched a campaign to get the reparations legislation passed.
Hi, can you put yourself on mute?
And we then filed the legislation.
Right now I'm only on the Connecticut Law Tribune board.
Hi, sorry, at home, can you put yourself on mute? No? Please?
Okay. And so we filed this reparations legislation in Chicago City Council, and then we ended up getting more than half of the city council on board in support of the reparations legislation. But we then, in order to get it passed, had to create a multiracial, intergenerational coalition. It was a movement to get Mayor Emanuel and the City Council to pass this legislation. And I just want to acknowledge Mariam Kaba, who was a co-leader in that movement, who is the Beyonce of social justice and the best organizer I've had an opportunity to work with. On May 6th of 2015, the City of Chicago did pass that reparations legislation. And it included several of the components that people talked about today. First, and it included an official apology that's a city resolution for the torture that occurred. There was then an ordinance that was passed as well that created a financial compensation. It created the Burge Torture Reparations Victims Fund that allowed torture survivors to get up to $100,000 for the torture they endured. And again, this did not matter whether you were so-called guilty of the crime or not. It was based on whether you were tortured or not. We now have created, through the reparations legislation, the Chicago Torture Justice Center. That's the first center of its kind that provides psychological counseling services to not only Burge torture survivors and their family members, but to all individuals affected by police violence and what we consider domestic torture. Again, first in the nation. We insisted that there be free enrollment in Chicago City colleges, not just for the torture survivors and their family members, but for their grandchildren, so that we had a full understanding of the generational trauma that came from this. We also created a curriculum that's taught to all 8th and 10th graders in Chicago public schools called Reparations 1 curriculum that allows torture survivors and others to go and work with students in our Chicago public schools, and may now not only learn about the torture cases, but imagine what a memorial would look like. And then finally, over the last 8 years, or 9 years at this point, we've been struggling to get the last part of the reparations legislation passed, which is the creation of a public memorial. And just last Juneteenth, not this one, not yesterday, but last year, Mayor Johnson awarded Chicago Torture Justice Memorials Foundation $3 million so that we can, in fact, build that reparations memorial. So we did, and the one thing we did not get was a commitment to non-refoulement. And I'll say that's because as someone who's worked in the Chicago police, not just like police violence realm for so many years, we could not really imagine any reforms that could truly stop the police violence without legitimizing police, which I think then means legitimizing police violence. And so we did not seek that, okay? However, I do think we created the building block or the seeds to help us fight police violence and help for reparations in the future. Finally, I just want to add, I know time's up, but I think that when we think about reparations, we have to be very mindful that it's not just about the product, but it's about the process. And through the fight for reparations, and now with the Chicago Torture Justice Center and the teaching about the reparations in Chicago public schools, there's a healing quality that is provided to the survivors. The survivors have been so instrumental in not only fighting for reparations, but fighting to implement the reparations and to then teach about it. So before, where they were disbelieved, we then would organize communities to come together to fight for this. And the torture survivors were centered in those fights. And people then would come and hear them and embrace them and revere them and respect them for what not only what they endured, but their perseverance, their resilience, and their willing to fight on. And that has provided a healing quality that no true product, I think, could result. And I think it's important for us as we think about reparations in the future is how do we think about the process of it, not just the product. Thank you.
Thanks, Joey. Before I forget, I want to give the CLE code, and then we'll continue the discussion. The code is LE12X7. Again, that's LE12X7. Joey, thanks so much for your remarks, and I feel like you really kind of underscored, I think, Roxana's initial point in terms of sort of the problem with legal remedies in the United States, which are really limited to, compensation or incarceration. And also, I feel like you've sort of brought us into the next question, which was really thinking about what are the challenges in developing what to include in a reparations scheme and how. So I don't know whether other people want to address just in terms of who's included in the class, how are we defining the harm, and other types of challenges. Because I think, we're really hoping to inspire people to think creatively. So how do you go about thinking about how you're going to structure a reparations scheme? And maybe Randall, I'll start with you.
Yeah, so just a very direct example of that is, in our case, Oklahoma has a Government Torts Claims Act statute for which all tort claims need to go through this sort of notice process that only has a 1-year statute of limitations before you can sue a government entity in Oklahoma. And so the reason that statute did not apply to our case is because we were not seeking individualized compensation for each of the plaintiffs or the members of the community. Everything that we asked for was technically injunctive relief. So the creation of a compensation fund, the establishment of the hospital, the tax abatement, scholarships, things like that, those were all equitable remedies as opposed to money damages. So in this case, we were very much shaped by the legal requirements for what we could and could not ask for because we the Tort Claims Act, if that had applied, then that would have triggered the statute of limitations, which would not have worked for our case.
And also, I mean, Joey or Randall, can you also elaborate just in terms of thinking about how to involve, I mean, you sort of talked about working within the limitations, but also the involvement of the community, right? And just in terms of thinking about more creative things that maybe wouldn't necessarily occur to someone not working with the communities.
Sure. Yeah. So so this is something we talked about in the pre-call. But so our litigation takes place in tandem with the organizing work done by this tremendous organization in Tulsa called Justice for Greenwood, which is led by Demario Solomon Simmons, who's also our co-counsel on the case. And so what Justice for Greenwood does all kinds of advocacy for the Greenwood community, but this really kind of extraordinary thing that they do is that they are basically helping organize the Tulsa diaspora. So after the massacre, many, if not most, people left Tulsa, and as a lot of you probably know from the history of the massacre, families were encouraged not to talk about the massacre. So there are a lot of people whose grandparents were affected by the massacre who have no idea because there's sort of a family secrecy and even some shame around the massacre, and even more importantly, a fear that if it was acknowledged, it would happen again. So there are people who left Tulsa, left Oklahoma, and through the organizing work of Justice for Greenwood, they've created these survivor and descendant communities, which have these really kind of incredible meetings where people sort of realize, like, oh, like we're cousins, or they realize that their families have the same stories because they were next door neighbors to each other, but they don't know each other because they were displaced from Tulsa. And so we've always said, like, no matter what happens with the litigation, and obviously we had a tremendous setback last week with the litigation, but the organizing work that's being done in tandem with the litigation has been really extraordinary. And the litigation also sort of serves a, in addition to just doing the organizing work and the lobbying that we're doing, the litigation gives like Justice for Greenwood something to update people on in the course of these meetings. It's something everyone's sort of cheering us on from the descendant community. And then, as we mentioned, so when we began the case, there were 3 living survivors: Mother Randall, Mother Fletcher, and Uncle Red. During the pendency of the appeal, Uncle Red passed away, but Mother Randall and Mother Fletcher are still alive. They're 109 and 110. But through the litigation has sort of helped create this apparatus by which the community can kind of cheer Mother Randall and Mother Fletcher on. And that, again, no matter what happens in our litigation, that's been an incredible thing to witness.
I feel like there's 2 directions I want to go in, but maybe we'll, interesting, Randall, also just thinking about the challenges of a historic case, right, and sort of the issues in terms of people who have communities that have really been torn apart, and also issues relating to shame and secrecy. And so I don't know, maybe I want to ask about the challenges that people have had in implementing the reparation schemes, and maybe Sylvia can talk about that, and then maybe we can go back to other issues in terms of creating reparation schemes.
Sure. So with the historical survivors, is that the distance of time, often decades, very much a sense of shame for many of these individuals. When former Governor Davis apologized, I think it was because there was a former victim of the sterilization who spoke up, a man who was interviewed and talked about how he didn't know what was going on, the whole thing, and but also he came to a point where he just didn't want to talk about it anymore. Right? I think for many of these individuals, you don't want to be defined by this, but at the same time, there are no descendants that's the heart of what's been done here. Not with everyone. Some people had children before, and in a few cases, I think it was because I had too many children, and it was like, oh, got to control that immigrant population. Surprise, that issue is still there. And then, the man or the woman in a married couple was institutionalized and sterilized. But for the most part, there's not necessarily a community. State mental institutions they don't have alumni associations, right? So it just doesn't, so that's very challenging. Outreach was extremely challenging because of all these factors of shame and not having a community. People would disperse. And some of the people we heard from were nieces or nephews, but the individuals themselves, it was really hard to find historical survivors. And then the prisoners had their own, some of them were still in prison, and communications were really fraught. So outreach was a really big issue for us, and wanting to get people involved. Yeah.
Yeah, I think, I think that's one of the issues. Shame and stigma is one of the defining features of a human rights violation or of state violence in comparison to a private crime. It's that breaking of the social contract. It's the state doing this to the individual that the state has the mandate to protect. So I think stigma and shame is a feature of trying to think about reparations. How do you bring the crime into light? I was really interested in the prior panels, how in the United States there was an effort to engage in the conversation in reparations, and internationally, although of course, one could argue that the United States isn't in a moment of this isn't an issue of transitional justice. We've had a democracy in this country for a long time, but internationally, usually reparations is preceded by a truth commission. It's preceded by an effort to really document and bring into light the crimes that have been committed, the harms that have been perpetrated, and the individuals who've been affected. In my own litigation in the United States, I think that stigma and shame should also inform who are the allies or the communities that we're trying to be in solidarity with. In litigation, you have the obligation to obviously represent your client. We're undertaking litigation right now against the United States for a killing at the border. U.S. Border Patrol beat my client's father and husband to death, and the beating was videotaped. And in thinking about which communities we wanted to ally with, we didn't think about just the U.S. population. The victims are Mexican nationals. So we've done an enormous amount of work trying to build relationship in Mexico through a communication strategy, trying to really, as a way to counter the shame and the stigma, to think about the most affected by really draconian, violent, brutal immigration policies, how to speak with, how to be in conversation with folks in Mexico, because they're the percentage-wise the greatest victims of U.S. immigration violence.
Thanks, Roxana. Joy, I want to turn it back to you, and I feel like, what you were talking about in terms of education, right, and the role that the people who had been experienced the police torture, like changing the response and the attitude about police violence and recognizing it as torture, how key that was, and I feel like that partly addresses the stigma issue. But so maybe you could talk about that a little bit more, and recognizing people who have survivors as really elders, right, who have so much to teach young people, but also thinking about the issue about creating the reparations, because I think on the one hand you could have just limited it to people who had been directly tortured by the police in sort of traditional ways, but I think that your remedies are slightly broader. But like in terms of the, or maybe they're not, but just thinking about what the class was, because I think that there are generations of people who have been affected by problematic policing, right, and how you sort of navigated that.
Well, okay, I'm going to support something that my former opposing counsel, Nathan Cummings, discussed today, which was that I don't think litigation is our way to move forward. And I actually think that litigation actually is producing more shame and trauma, right? And that's one thing that I spent years representing Chicago police torture survivors in their criminal cases, at evidentiary hearings, in their civil rights cases, at their depositions. And those aren't truth-telling forums. They're adversarial, they're antagonistic, they're humiliating. They're in fact recreating the circumstances of people's interrogations, and they caused as much trauma. And that particularly was the case for the survivors who testified against Burge in his criminal proceeding. And I think, as someone who did so much litigation and always strives to be a movement lawyer, was trying to include survivors and particularly their family members who were the ones who always came to the criminal cases and were affected by those court proceedings profoundly as well. There's just not space for survivors and family members to be able to be the centered, to have their experiences heard and privileged and respected. And in fact, it's really the lawyers who are doing most of the work and the ones who are given the voice. And I think that if you think about it on a process level, besides the product level, I think we can look at litigation across the United States and see that for the most part, it has not succeeded in terms of reparations, let alone in terms of other movements we want it to. However, I think we can look at litigation as ways to uncover information. We can use legal tools to uncover information. It could advance us in many ways, but it's not going to get us across the finish line in several ways. I think in terms of, and again, so I think around the shame, I will just also say, so many of the survivors in the Chicago police torture cases felt enormous shame, not just by being tortured, but by confessing. And then in some cases to confessing to things that they were implicated of, but then having to implicate others. And to then go into prison and, they would not share with others what occurred to them because they felt humiliation, but they also felt like that they had so-called snitched on others, and that would put a target on their back. And so, eventually through the organizing, the creation of the Chicago Torture Justice Center as well, we now have a space and place where people can come and say, yes, this did happen to me, and they can relate to one another, and they can be with one another, and that's another profound sense of healing that occurs that, again, the litigation couldn't. I can tell you in the litigation, the city's response was, you weren't tortured, and if you were tortured, you made up those allegations because you were in prison with other torture survivors and you learned how to fabricate those allegations. And it was just outrageous considering that most of them had motions to suppress. But again, this is how the litigation, just will twist all the facts and the realities. I think we are organizing and we are creating our own spaces. Not only are we creating spaces where the folks who are directly impacted get centered, get their voices heard, and get respected for that, but we also control the narrative. And that's the other thing that came from the Chicago police torture cases that litigation alone could never do. But even with Burge's conviction, we didn't create the dominant narrative about this racist and anti-Black racist pattern and practice of torture. And now I think with the passage of the reparations legislation, we absolutely have created that dominant narrative, and we own that dominant narrative in a way that wasn't in the past. And so those are just some other things to think about in terms of where that healing comes from. I want to add, though, that yes, reparation schemes are problematic in the creation of the class of who's entitled and who is not.
Hold on one sec. We can hear someone's phone ringing, so can you please mute your computer?
And for example, in the Chicago, in the Burge torture cases, we were able to get reparations for people who were tortured by Burge or under Burge's command. But when Burge was ultimately, suspended from the police department and later terminated, even though he was terminated, his henchmen were not. And they were allowed to go on and torture others. And that has been a huge problem. But that's why we're now fighting for reparations for what we're calling the Burge disciples and trying to create it, to continue to fight on. But I think but I think we need to realize we are creating precedent. that each of these reparation struggles are creating room for more reparation struggles. You know, that reparations needs, you know, I think it's an understood concept, and it's a common term, but back even in 2015, having a hashtag reparations, now helped, I think, create a larger space for more reparations fights. And I think we need to look at these and realize, reparations isn't revolution, but one reparations struggle can lead to another struggle. And so I'm not giving up on behalf of the survivors of the Burge disciples, and I'm not going to give up on behalf of other people impacted by this state racist violence. But we can't do it all at once.
Thanks, Joey. I'm going to open it up for questions. I have another question while we're waiting. Martha, do we have any questions online?
Can I start with a question over here?
Oh, yes.
I'd like to follow up on Roxana's genocide in Guatemala. I have a friend from Guatemala who said that at least 400 to 500,000 people were killed in Guatemala, and of course the U.S. government was involved in that. Then when we go, I just want to put this in context, when we go to the Vietnam War, when Henry Kissinger and Richard Nixon initiated the secret bombing of Cambodia and Laos between 1964 and 1972, the U.S. dropped 300,000 tons. That's 300,000 tons. If you can imagine, that's a lot of bombs on both Laos and Cambodia. And in that Vietnam War, as you may know, approximately 57,000 U.S. troops were killed, and yet there were 3,340,000 civilians killed in Vietnam, Cambodia, and Laos. So that brings us up to the current situation where the U.S. and NATO have taken on a war with Russia.
I'm sorry, sir, can you...
I'm going to sum it up. This is international human rights. This is what's happening right now.
I know, so maybe you want
So
to...
the U.S.
Sum it up, and then we're going to go over...
supplying cluster bombs, which is against human cluster bombs. Approximately 600,000 Ukrainians have been killed, and the U.S. policy is to fight Russia to the last Ukrainian. And as I said, 600,000 Ukrainians have been killed to date. And I'll sum up with the
Reparative justice.
this is international human rights who, and I'll just like to finish up with the Gaza war, where 38,000 38,000 Palestinians have been murdered with money and weapons from the United States, and that's why the International Criminal Court has brought Israeli government officials to the International Criminal Court.
Okay.
Sorry to bring this good news to you, but
thank you,
I
sir.
think this is
We're
the
gonna move to
forum
this
to talk
question.
about international rights.
Thank you, sir. Yeah.
Hi. Hi. Thank you all for this panel discussion. My name is Sara Davila, and I'm coming from Chicago, even though I'm not from Chicago, from UIC, the International Human Rights Clinic. So I want to sort of maybe get your opinion about Roxana's comment on creativity in human rights, and sort of like, I think that's one of the biggest things that we can learn from human rights work. So I want to say, I mean, in the case of Midnamak, I think it's like one of the landmark cases for defenders, and I think we need to continue using that framework. And then Joey, I also teach about your work, and I want to say it's especially meaningful for students coming from Chicago to understand what can happen locally. And I also assigned the We Charge Genocide Shadow Report and sort of spoken word and poetry as part of the work that was done in that campaign and the art installations. And so my question is, in this upcoming election and in a moment of perhaps tidal change of political will, how do we keep momentum in this creativity to keep this work moving forward?
Okay, let's take this question and then I'll pose them to the panel.
Hi, my name is Wanu. I'm actually a Canadian. I work for my province's Human Rights Commission by day, but I'm actually here as a startup founder of House of Prima Facie, which is a litigation support and clothing procurement service. So we actually partner with fashion brands to take their excess stock and supply legal institutions with civilian clothing to uphold the right to wear civilian clothing instead of prison uniform during trial, and ensure inmates released from custody have adequate clothing to wear. And so my question is, are you able to identify a specific problem that you believe entrepreneurs such as myself or other people with creative talents might be able to solve and support attorneys in their pursuit of justice?
Okay, so we have one question about just keeping the momentum going and then maybe the role of entrepreneurs.
Well, okay, I'll just say that, I litigated and worked with organizers, particularly the survivors and family members around the courts. And then eventually what we did was start Chicago Tortured Justice Memorials. And essentially it was an art project where we invited people to submit speculative memorials around the Burge torture cases. And because we wanted people to unleash their radical imaginations on what a public memorial could look like, and how do you deal with the heinous racist violence while also honoring the resilience and perseverance of the survivors and the struggles for justice. And we mounted an art exhibit at the Art Institute of Chicago, the Sullivan Art Galleries, and that's where I drafted the first draft of the reparations ordinance, never in my wildest imagination thinking we would file that and then launch a campaign to get it passed. And I guess I just want to say, in thinking about what's coming, first of all, when I started doing this work 25 years ago, we were hated, going into court, there would be city lawyers, the private lawyers paid by the city, 6 or 7 deep, and I'd be there with 1 or 2 individuals. And we were, constantly losing and struggling and fighting. And then it was through the organizing work that really we started to change the tide. And I wanted to say, but the problem is that it kept a very small field of people. Where when we started doing the art project, and we got to invite so many people who have different talents, different skills, different visions, different imaginations. And this makes me think also about abolition, okay? And I'm an abolitionist now. But thinking about, 2020, if we think about just 10 years ago, we would not have heard abolition and abolitionist visions and dreams expressed in any really non-abolitionist spaces. And now, 2020, even though it may be unpopular, it has seeped into the mainstream. And so, yes, we have fears about what's to come, and I think no matter what, it's not looking good, whoever gets elected, all right? But I think it's truly important for us to continue to create our own, radical, revolutionary, abolitionist, democratic visions of what could be. I think the international law and the artistic world provided us with ways to get beyond U.S. domestic law, to think of new things and new remedies. And I think that we have to continue to invest in these spaces. And so in addition to mutual aid that we're going to all have to invest in, I think we definitely have to continue to invest in these creative spaces. And I just also want to look at the work of the Equal Justice Initiative, right? I think that Brian Stevenson and the amazing lawyers and people he works with have not resorted to just litigating alone because, again, we have not captured the dominant narrative. And so that's why there are memorials. That's why there are other artistic endeavors, because we need to, really try to educate people and get into the popular education. But again, I'm also going to say, I hope that we're not just lawyering and litigating our way, but that we're trying to be movement lawyers where we're trying to really empower the directly impacted and other organizers who I think are really the ones who can shift power, change narrative, and meet material conditions.
Does anyone else want to respond? And then we'll take the last questions.
I just wanted to say that the memorialization, I mean, we got the state to put 1 million toward memorialization, but the state is not very imaginative. So we have plaques that have been put up at certain hospitals, locations. Some of them are on grounds that are not necessarily public, let's say for the prisoners. So you have to get permission to go on the grounds to view the plaque. One of them is, I think, a bench that is under a tree where many birds go to roost, and then they defecate on the bench. So you have that. At the same time, I know there have been these attempts to memorialize in more creative ways. The California Coalition for Women Prisoners has a quilt put together by women who have experienced the involuntary sterilization, and that travels, and is on display. I really, really wanted some of the money to go towards the creation of fully accessible playgrounds, because I thought that would be a way just to reach next generations, but the state wasn't having that. So I think that the division is like funding, the kind of funding you might want to go behind these projects, and then the sort of burbling and artistic creation of memorialization, and getting those two together. And because I've been an artist or not a musician, and they often say it's you have to make a living too. As an artist, as a musician, whatever you do, there also has to be funding. And I find it really hard to get those streams together. So I just putting that out there as a practical thing.
Do you guys want to?
I think there's a lot of questions.
Okay. All right. So why don't we'll take these 3 questions, and then I think we'll wrap it up. We'll be out of time. Let's start here. Then we'll go here, and then Justin, you have the last question.
Thanks, everyone. I'm Tor Hodenfield from the Columbia Law School Human Rights Institute, but I'm reading questions on behalf of colleagues online. So I have 3 questions. I'll be very brief. The first is from Portia. Portia's asking, can any of the panelists please speak to the alleged psychological hesitancy to reparations to Black people, given past and current perceptions still of Black people as not being perceived as worthy of reparations. Tina is asking, or saying, I'm interested in the issue of using reparations framework to end policies that violate human rights and are still explicitly legal under the domestic law, particularly all forms of institutionalization, including involuntary mental health commitments. Can any of the panelists please comment on the use of reparations framework as part of an advocacy strategy to change public opinion, domestic law, and the actual practice in this context? The last question is if anyone has done any work to support reparations for Kurdish people who have been victims of liberty violations. Thank you so much on behalf of Bonnie.
Okay. Thank you, Martha. How much more time do you think we could have? Okay. All right. So why don't we hear these questions, and then you guys can choose maybe amongst the questions that you want to respond to. Yeah. Okay.
So my question is, you all basically address standing. So the issue is, where do you cut it off? And also, do you have preemption issues, whether, some kind of federal preemption issues, which would cut off the standing, because you're all talking about 50 states here.
Okay.
So standing, basically.
Justin?
Yes, well, two points. First, inspired by you all, and I am responding a bit to the entrepreneurship question. We're starting a reparations bar association, which is going to work to try to get reparations-oriented lawyers to build community and to understand that as these cases proliferate around the country in local jurisdictions, you're going to need lawyers who are barred in those local jurisdictions to help. So that's what I would encourage people to begin to organize, even doing it independently, also in Canada and other places, to try to build communities of reparations lawyers.
The second thing, really quickly, just this is a broader question that's been bugging me on reparations when the perpetrators are not apologetic or even interested in coming to the table. Can we really call that reparations? Because that's really what we're faced with here in the United States is, we have, in some cases, governments willing to make small concessions, but the actual perpetrators usually reject what their government is doing, and in some cases are trying to pull that back, as we're seeing happening, as we see that happening politically, nationally. So do you even consider that to be reparations when the perpetrators are recalcitrant, or what are we doing exactly?
All right, quickly over here.
Great. Hi, my name is Sama Sise. I'm at the Center for Constitutional Rights. Thank you all so much for all the work you're doing. I have a question about the non-repetition part of reparations. I think you all talked about, especially with the California example, how, there's an apology and then we see a different group or class, if you want to classify them as that, facing the same harm. And just wondering how you think about that piece when you're doing this work. And even within the police torture example, right, we know that it may not be specifically within Chicago, but these things continue, and whether, what does that look like, the conversations with community and thinking about how we ensure that non-repetition is not just for the specific group or the historical survivors, but also for people in the future, and what does that planning and that work look like? Thank you.
That's a great question. Okay, so why don't we just go down the line? Maybe Joe, we'll go down this way. So Joey, do you want to go?
Well, I think, we're in a different place now in 2024 than we were in 2015. I think that there are a lot of ways to think about guarantees of non-repetition. But that said, with respect to police torture, in 1970, it was illegal to engage in police torture. There were rules and regulations against it. There were laws against it. At this point, I don't think there's ways to reform our way out of police violence. I think we have to take power and resources away from the police, and we have to look to alternatives for safety and to be free from violence. And I think that's what organizers are doing right now. And I think we all believe in a world where we all can be safe, free from violence, and live with dignity. We're not going to get there with a police state. And so I think there are new ways to think about it, but I will say that in terms of our reparations legislation, that we did not invest any resources in legitimizing the police or the criminal legal system. And instead, we sought to move all of our resources and make the city pay for resources for survivors and family members in affected Black communities. And so I do think, again, reparations is a step, but it's not the resolution of this all. And so I think we need to continue to try to creatively think about commitments to non-refoulement, but I think we also have to recognize that it's not going to be one and done. And then with respect to your question, Justin, yes, is John Burge or the police officers or the Fraternal Order of Police ever going to apologize for what they did? No, never. But to then claim that they own the power of reparations over the people who actually were impacted, struggled, and fought for that, I'm not willing to give that to them. We forced the city of Chicago to admit that this pattern and practice occurred, and we forced them to provide money and a plethora of resources in order for, and those resources are now helping us fight on. So I'm not willing to let the torturers, the human rights violators get to own the definition of reparations. I think we get to own that definition of reparations, the people who are impacted, and we should claim it loud and proud and keep fighting for more reparations. Otherwise, we will never have reparations.
I'll try to be quick about this. Addressing the idea of non-repetition. Reparations is one thing. I think from a disability point of view, and I think it applies more broadly than that, is that the root of non-repetition, or one of the roots at least, is separating where blame is placed. And often with people with disability, it's like, well, the problem is that you have a disability. And so if you can't get into the room, if you have bad health outcomes, if you are not being educated well, it's really because of you. And as long as that is our perception, then we're always going to be able to repeat something because it's always justified by, well, the problem is you. And so without the kind of education that goes to understanding how flawed that reasoning is, the things we do to one another because we don't acknowledge that someone is a human being with the same rights that we have, I think we're always going to have repetition that demands reparation or demands, change. So.
I'll be super brief. Just with respect to the question of sort of who gets to control the story and memorialization too. So in Tulsa, there's this shiny new museum that people might have seen called Greenwood Rising, which is a $40 million, in some ways, a memorial to the victims of the massacre. But it is, so we actually sued them also because our clients and the descendant and survivor community of the massacre had no role in that museum. They don't get any of the $40 million that was raised. It's been turned into sort of a object of cultural tourism for people who own the businesses and the land around the museum, which are mostly white people. So we think the people who should be deciding how the massacre is memorialized and what that looks like in Tulsa should be Mother Randall and Mother Fletcher and the community they represent, not the landowners around the museum.
Sorry, is it possible to answer the questions in order? Like, I still haven't heard an answer to my question. I don't know if we're just picking questions. Like, it's hard to follow what you're even answering.
It's actually just because we're out of time, so we just asked them to choose one of the questions because we can't respond to them all.
Oh, okay.
Yeah,
Okay.
yeah.
Okay, thank you.
Yeah, no problem.
I'm not answering your question because I don't have a good answer to your question about entrepreneurship in the way that you're asking it. I mean, I think that for me...
Randall, maybe share your mic.
Oh, yeah, great idea. That works.
Thank you, sorry. For me, I'm often thinking about technology and how technology can contribute to some of the investigations of crimes against humanity that I'm engaged in. And I don't think that's going to be a satisfying answer to your question. I would say these are generational struggles and we need to see them as such. Just drawing an experience of other areas of conflict and mass violence. I mean, I don't think we can focus just on who's in power now, but we have to build the infrastructure and the architecture to create the ability for change in a generation from now, 2 generations from now. And you can hear in the way folks on this panel are engaging with these questions that is precisely what they're trying to do. I agree with so much of what Joey has said today. Maybe with the one point about how abolition shows up in the work that we've been doing. I struggle with abolition, especially in the immigration space, because I see such an intense militarization of our borders and such an absolute absence of any kind of accountability or oversight. I mean, it's absolutely, there's nothing there. I mean, in Border Patrol's 100-year history, there's never been a single agent held accountable for excessive use of force for a killing. So in a space where there is absolute impunity, I struggle with how to engage with abolition. Although I respect and honor a lot of the principles and values that inform that movement. But I think that's the question for us is I often with my students talk about how do we create the tree? How do we plant the seed that's growing, it's not my idea, that's going to grow into the tree, and for our future generations will enjoy that shade, and that's I think the challenge that we have to think about. And Joey, I agree, that's not a question that lawyers should be centered in answering. I think in this country especially, we've relied way too heavily on litigation. on the law to answer our questions. And it is a time for lawyers especially to make space for others to engage and to contribute.
Thanks. All right. Yeah, so join me in thanking the panel. If people have questions that weren't resolved, feel free to come up. Thank you.
Okay, I'm going to call everybody back to order here. I know hopefully people had a chance to schmooze and to have some lunch. We'll have some other people joining from the outside, I think, once we get started. But I'm very excited that we were able to line up the next presentation during this period from 12:45 to 12:15. And I'm going to turn it over to Carrie McLean, who's a longtime core member of the PHRGE Lawyers Network, to introduce our speaker. So Carrie, you can take it away there. Thank you.
Hi, good afternoon, everyone. My name is Carrie McLean. I'm very pleased to join you all today to discuss this important topic. Reparations for the transatlantic slave trade and the enslavement of Africans is an issue that I've researched and advocated for, examining it with an international human rights lens and collaborating with reparations advocates in the Caribbean and Europe. It is with pleasure that I introduce Mia McMorris, who will be giving a special address. Mia McMorris is the Junior Research Fellow in the Center for Reparation Research, where she works closely with Professor Vereen Shepard. Professor Shepard is, as you know, a member of the CERD Committee and a leading reparations advocate. Mia graduated with a degree in history from the University of the West Indies. She previously worked as a research assistant at the University of the West Indies Mona History and Archaeology Department and the Caribbean Institute for Health Research. Building on her undergrad studies, Mia pursued a Master of Arts degree in Public History from the University of Massachusetts in Boston. She's dedicated to making history more accessible and has worked in museum education. She co-hosted and was a researcher on the radio show History for Tomorrow. Mia also volunteers with Boston Women's Heritage Trail, to ensure women's history is acknowledged in the city. Without further ado, Mia McMorris.
So I'm just going to share my screen quickly. Good afternoon, everyone from Jamaica. I am so pleased to join you at this forum and present on reparative justice and human rights in the Caribbean community. I've enjoyed listening to today's speakers. Unfortunately, I didn't get to hear Justin's speech earlier, but I've listened in on the other two panels. As a historian, it's incredibly valuable to hear how evidence that we gather can and will be used towards justice. It also helps us to understand what perspectives we may be missing, so that when we eventually do take this case forward, we can fill those gaps. And I'm really looking forward to any of your questions and comments after my presentation. So, the Center for Reparation Research. We are a special project of the Vice Chancellor at the University of the West Indies, and we were established in 2017. Our primary objectives have been to promote research on and engage in advocacy campaigns regarding the legacies and conquests of colonialism, genocidal actions against indigenous peoples, the trauma of the transatlantic trafficking in enslaved Africans, African chattel enslavement, and to help bring justice and positive transformation to societies and peoples affected by these legacies. We engage with various levels of society, from academics to students, politicians to members of civil society, and the center regularly holds seminars and lectures to make relevant research on reparation accessible to the public, as well as we do markets, film festivals, interviews, and recently we had our talk show, Reparations, that's now airing on UETV Global. So we engage, as I've said, with the region as the research arm of the CARICOM Reparation Commission, assisting them in building awareness, advocacy, engagement, research advancement, and supporting the justification for reparation. At the July 2013 meeting, heads of the CARICOM, which is the Caribbean community, created the CARICOM Reparations Commission and also put forward the need for national committees on reparations in each country to establish the moral, ethical, and legal cases for the payment of reparations by the former colonial European countries to the nations and peoples of the Caribbean community. And the expectation was that the CRC would comprise of the chairs of the national committees and representatives of the University of the West Indies, and that they would report directly to the Prime Ministerial Subcommittee on Reparations. Currently, there are 12 national reparation committees whose chairs are of the CRC, and it is chaired by the Vice Chancellor of the UE, Professor Sir Hilary Beckles, and the 3 vice chairs of the CRC are Professor Marine Shepherd, who is the director of the Center for Reparation Research, Dorbreen Omar from Antigua and Barbuda, and Eric Phillips from Guyana. In 2014, the CRC established a 10-point plan, and this is the foundation of the Caribbean reparation movement. It is aimed to provide a guideline for reparation, one that would allow for the redevelopment of Caribbean nations. First, we require a full and formal apology. A full apology accepts responsibility, it commits to non-repetition, and pledges to repair the harm caused. And I've seen and heard this repeated throughout the presentations this morning, so I know that we're on the same page here. Next, an Indigenous Peoples Development Plan. As a result of European conquest and colonization, the indigenous peoples of the region were subjected to forced migration within their countries and across the region, to brutal work conditions and genocide. Former colonizing European states need to take responsibility for correcting the damage and, where possible, restoring the communities that still exist. Next, funding for repatriation to Africa. The CARICOM Reparation Commission has been in contact with the African states, and they have made contact with those who are willing and able to allow stolen persons to return. The burden, however, of the funding for this resettlement must be given from European states. A fully funded resettlement program that allows the repatriation of the displaced Africans in CARICOM member states who wish to return needs to be a crucial step for the wrongs of enslavement and colonialism. Next, the establishment of cultural institutions and the return of cultural heritage. Part of the devastation that comes with European colonization was the fact that there was a deliberate attempt to destroy cultures, languages of indigenous peoples, of enslaved Africans, and then the indentured workers who would follow. We need to find a way to restore that memory, and it is a crime that we still don't have access to some of that memory. Addressing and remedying the public health crisis. We need to deal with the public health crisis. We are so devastated, our infrastructure cannot manage, and we saw that so clearly during the COVID-19 epidemic. We were barely surviving in the Caribbean. Education programs. CARICOM governments inherited a flawed education system, inadequate schools, high literacy that did not even begin to start rectifying itself until the 1990s, and a structural system of discrimination. CARICOM countries have worked hard to correct this, but we do need more work in that area. The enhancement of historical and cultural knowledge exchange. Part of reparative justice, therefore, requires a program of restoration of pride. And one way of doing this is to intensify efforts to rebuild bridges of belonging. The region cannot do it alone. and the years of creating this represents an undue burden on newly developing states that must have had to tackle other developmental challenges. Psychological rehabilitation as a result of the intergenerational transmission of trauma, and I heard someone else mention this earlier, of course in a more modern context, but the history of colonialism by certain European states has created a intergenerational trauma upon indigenous and African descendant populations. Therefore, we need to have spaces and systems in place to deal with that. The right to development through the use of technology. And so this is talking about technology transfer and science and sharing for development by responsible European states, allowing the CARICOM region to create better systems for themselves. And finally, debt cancellation and monetary compensation. So we currently are under a lot of monetary distress in the Caribbean with international debts to all of those major world organizations, IMF, World Bank, etc. And it just seems like this is a necessary step towards us moving forward. Sorry. And so I want to go to why we at the CRR do what we do. Firstly, colonialism and poverty. And this is an extract from the Durban Declaration and Program of Action in 2009. This, of course, is not new work. We have seen similar statements from George Beckford, Walter Rodney, Eric Williams. In the Caribbean, we've been doing this research, and we know that historical injustices have undeniably contributed to the poverty and underdevelopment, marginalization, social exclusion, economic disparities, instability, and insecurity that affect many people in different parts of the world, in particular in developing countries. And we need to recognize that to develop programs for social and economic development of these societies and the diaspora within the framework of a new partnership based on spirit of solidarity and mutual respect is necessary. Yet, we still are not seeing, people don't seem to understand. And so I'd like to just play this video for you. In 2021, Slate animated a map showcasing the evolution of the trafficking in enslaved Africans. As we watch, we're going to see a gradual uptick in voyages. So these dots that are flying across the screen, these are voyages. And this information was collected through the slavevoyages.org project. And you're seeing as the dots represent the size of the cargo as well. And I say cargo, I of course mean the trafficked Africans. And with this swell in voyages and the speed that they're going, you're seeing the profits in Europe also grow. Merchants, insurance agencies, manufacturers, lawyers, bankers, everyone is profiting except for Africa. And we're coming closer to the period where technically the trade and the trafficking should have stopped, but it's still going at a shocking speed. And you're seeing that in South America, you're seeing that in the Caribbean, you're seeing that in the US. And for a little more information, these are the figures. Oftentimes we hear people say that reparation advocates don't have figures, we don't have numbers, we don't have evidence, but here's evidence. We know that for a fact, 1,083,443 Africans were trafficked to Jamaica over the course of this period. 151,869 died in the journey. 361,148 were born there. And at the end, planters collected compensation for 311,692 enslaved Africans. The numbers are really horrifying. We also know that the US trafficked and had trafficked to them 341,734 enslaved Africans. 60,679 died in their journey. 7,623,675 were born into chattel enslavement. And at the end, 4 million received freedom. I'm just going to name a few abolitionists from the Jamaican War of Emancipation, 1831 to 32. We have Catherine Brown from Cascade Pen, and she was sentenced to death, commuted to 50 lashes and 6 weeks of imprisonment. Anne James, free, but she was executed. Jenny from Kirkpatrick Hall, St. James, executed. Kitty Scarlett, Cambridge, St. James, death and commuted to transportation. Francis Duncan, death. Eliza Whittingham, death. Jane Whittingham, death by hanging. We do this because an administrating power is not entitled to extract for centuries all that can be got out of a colony. And when that has been done to relieve itself of its obligations by the conferment of a formal but meaningless because it cannot possibly be supported political independence. Justice requires that reparation be made to the country that has suffered the ravages of colonialism before that country is expected to face up to the problems and difficulties that will inevitably beset it upon independence. The fact is, the system was wrong. They know it. We see it in British parliamentary records. In Prof. Beckles' recent book, How Britain Underdeveloped the Caribbean, he cites two such records in the book's prologue. First, A. Creech Jones, MP, 1939. The hopeless squalor of today is in a real way the measure of the shortcomings of our colonial policy and our economic neglect. And then later, Sir S.E. Luke, Assistant Undersecretary of State, with superintending responsibility for the West Indies in 1952, said, "Until quite recently, nothing has been done to put money back into the islands in order to expand their economy, and that effect of this are now being felt." And even when we come with this evidence and when we talk about these obvious facts, we're still getting significant pushback, not just externally, but internally. The legacies of enslavement are racism, systems which promote underdevelopment, with colonial-style oversight systems. So we're talking about why is it that when we are requesting a loan for a debt, we have to jump through all of these hoops from these agencies. Monuments that honor our enslavers, colonizers. Street names glorifying enslavers and colonizers, the loss of language and culture. Our education system continues to suffer under a colonial pall. History is not a mandatory subject, and oftentimes the syllabus propagates these really old colonial narratives. And we just think about even what we call this period. We call it a trade. Africans were kidnapped and trafficked. When we think about that, language matters, it really does. And these things are coupled with this growing wave of imperial nostalgia. And I wish I could take credit for this phrase, but I must admit that I read it in an article published by Sathman Sangero, the author of Empireland and Empire World. He discussed the risks that are coming to those who speak out against imperialism. The risk of campaigning for reparation when so many are clinging stubbornly to the old vestiges of empire and ignoring the significant trauma that these systems created around the world. I resonated with his point, thus equating history with status when statues are not history. They just offer one view of a historical figure at one particular point in history and propounding the peculiar idea that history is erased with their removal. And he goes on to say in brackets, our knowledge of Lenin and Hitler continues to grow without their statues. And I think that You know this most in the US with your current situation. However, there is positivity. The state of the movement is evolving. We're seeing states apologize. We're seeing non-state actors apologize. We're seeing donations from the heirs and heiresses of enslavers, collaborations with Laura Trevelyan, Alex Renton, and Charlie Gladstone, particularly in the Center for Reparation Research. We're seeing opportunities for publications and research on reparation, including the Brattle Group of Economists, who last year partnered with the Center and with the ICJ Judge Patrick Robinson to create the quantification for chattel enslavement. The Repair Campaign, as I mentioned earlier, we have publications in newspapers, documentaries. Documentaries are a big thing that's coming now to the reparation movement, and we're so excited to see it. We had Robin Ruth Simmons, who come to Jamaica and show her film in our Reparation Film Festival last October. We also have the joint masters between the University of the West Indies and the University of Glasgow, an MSc or MA in Reparative Justice. And this includes courses that have historical basis and connection with present-day realities as a primary content to intentionally facilitate a deeper understanding and appreciation of the demand for reparative justice. With many grassroots activists participating in the fight for reparations justice, it's important to broaden the access to information and allow for their certification in the field. Finally, I would say, is reparative justice a human right? And we've heard all of you talk about this throughout this discussion. And what we're really campaigning for is, of course, for fraternity and cooperation. We want to see persons from varying levels of society step forward to acknowledge the crimes against humanity perpetuated during the colonial period and push for a repair. We don't want just an apology and say, oh, but you don't really need anything. But we do, because we're not equal right now. And it just seems strange that there have been efforts for reparation where we see it in other areas. We see that finally, after so many years, New Zealand has granted Maori people their reparation. We see it in Africa, where Britain and Germany have finally, and over the last few years, granted reparations. And in Jamaica as well, we have given reparation to the Rastafari community for the horrors of the Coral Gardens massacre. It just seems right that our ancestors be compensated for the harm done to them. And I'd just like to close by acknowledging the enslaved persons who toiled on the Mona plantation where this office is located. I'm just going to say a few names: Frankie, William Bennett, Thomas, James Allen, Kofi, Mono James, Jeannie, Mino, Abba, Phyllis, Queen, Suki, and Diligence. Thank you.
Thank you for that excellent presentation, Mia. I think we've only got a few minutes left. And you know that I have a couple of questions that I'd like to pose to you, but I'll just ask one, given our time. Can you talk a little bit about CARICOM's vision regarding repatriation and what work is being done to advance that vision?
So the CARICOM Reparation Commission has been in conversation with, of course, the civil society in the Caribbean. A lot of that group is, of course, Rastafari. But we've also been in communication with various states in Africa. One of our vice chairs, Eric Phillips, frequently is there meeting with leaders of community, of society, and seeing what's the best way forward, because we understand that Africa has been moving past. They've been on their way developing, even if at a disadvantage. Whereas in the Caribbean, this is a great hope, and I know in America as well, a great hope that you can find your home on the continent. But we respect that we can't just go back and expect everything to be as it is. And that's why it's necessary for reparation to facilitate a safe path for both of these communities as they converge. So community outreach and development and discussions, we recognize that we need to speak to each other and create systems that work.
Okay, thank you. All right, maybe I'll squeeze in the other question.
Yeah, Carrie, why don't you go ahead and ask one more question, and then we'll close out this. Thanks a lot.
Okay, thank you. All right, so it's been said that there's a divide between reparations movements in the Caribbean and other parts of the world. Do you want to discuss that? I know this is actually a very big conversation, but do you want to discuss it a little bit?
Well, I have to say, I came in with an understanding, and I'm seeing, even from this conference, that there is a kind of an evolving thought on the matter. I've attended a few meetings of U.S. Reparation Commission, specifically the San Francisco meetings. Been hoping to attend the Boston one since, I've lived there for a few years, but I haven't had the opportunity. But I'd say that the thing about the reparation movement is everyone's needs are different. Every community is suffering a specific issue. And in the Caribbean, we have a particular way forward, which is the fact that we think the whole region has been impacted. I know that in the States, there is a kind of need to qualify. There is the need to identify your connection to the harmed community. And I recognize that might be necessary. But in the Caribbean, we have a different approach. And there's also kind of a situation between the Caribbean and the UK. So there is, unfortunately, not that much unity within the movement. But I think we can all understand that we have similar issues and we're campaigning together towards a better goal. And I would say that one of the big wins is that we're seeing the Caribbean and the CARICOM Reparation Commission has formally partnered with the African continent for reparation discussions. So that's one step forward, at least, towards unity in the movement.
Okay. Thank you so much. That was excellent. I know that we're out of time, so I want to announce the CLE code for the people attending. It's S as in Sam, Y 28, A as in Apple 4. I'll say it one more time. S as in Sam, Y 28, A as in Apple 4.
Great, thank you very much, Carrie and Mia, so much. And now we'll move to our final panel. I'll call up Kathy Albiza, the moderator, and the other panelists.
All right. As you can see, we have a lot of people at this table, which means you're going to get a lot of insights from this very rich day. It's been a wonderful conversation, and I just want to thank the organizers for pulling it together. And we are going to start with actually hearing from each of you what your big takeaways have. And just introduce yourself as you do that, please. I'm Kathy Albiza. I work with Race Forward. I head up the Institutional Sectoral Change Department, but I've worked with many of you for decades in multiple capacities. So big takeaways from today's conversation. Any order. Introduce yourself, and let's start sharing.
I'll just get us started. I'm Sushma Raman. I'm currently president and CEO of the Heising Simons Foundation. It's a relatively new role I'm in, so I'm still in that listening and learning mode, but drawing on my experiences also in past capacities working on issues of racial justice in the U.S. I was really struck by all of the presentations today, and I think the one reflection I'd like to lift up is that we heard about instances in specific geographies or with specific communities to think about how to repair the harms that have been caused. And I am thinking about this now from this sort of more global lens, as we heard from the last speaker, that the enslavement of Africans affected individuals, it affected societies, it affected communities, and it affected people in many countries, and that, we need to think about this in that context, that really this repair needs to be at the level not just of individuals, it's institutions, systems, policies, and it's essential that we do this now in order to look to the future for more just, peaceful, sustainable futures.
Okay. Who wants to follow that?
I can build on that. Hi, everybody. How y'all doing? Good. I come from a Baptist, so I'm like, hello, how y'all doing? It's better. Beautiful. So I think just to build on that, my name is Margaret. I use she and her pronouns. I'm now with CUNY Law School, but have spent the last 15 years inside of Black Radical Movement and Law for Black Lives. So super happy to be here. I think, I'll name two or three. I think one of them, and a number of people said this, but I think it was the second panel who kind of said it most clearly, that this really is a political question, that there are lots of ways we can think about litigation, ways to support and try to kind of like put cracks in like the edifice. But at the end of the day, reparations, whether it's granted or not, will be a political issue. And for me, that means it's a power issue, that it actually isn't the purview of lawyers or even legal workers, that ultimately it's about organizing, and it's about how we can shift and build power to make these demands possible. And so I think that kind of, it feels really bleak when you hear and talk about all of the challenges, all the legal challenges, all the standing issues, and I think it is bleak because at the end of the day, it has to be kind of a political shift that we have to see. I also will say I think this idea about us suffering from a lack of imagination is really important. And I come to this space, almost all of my reparations conversations have happened in movement spaces where there's not a lack of imagination, thankfully. And that people are really thinking in really bold, global ways about how reparations is actually about redistribution of power and resources on a fundamental level, right? And so I think this idea of thinking really big and embracing the kind of generational nature of this is really important. And then I'll just end really quickly with Joey and kind of the incredible work that Joey's done in Chicago. But they say that it really is about kind of the possibility for more wins. That every small victory, even when we seem like we failed, even if it ends in a dismissal, that opens up a bit more space for our imagination to imagine what it would be like to actually have repair for the long-standing racial harms and other harms in this country, but also this globe.
So generational and global. How about the other side of the table?
Well, I'll add, because...
I don't think your mic is on.
Mike?
Is it on? Okay, hello? Should I just try to turn it on?
Yes.
Okay, thank you. So I'm just going to build off of what the last panelist just stated in terms of my takeaways from today. My name is Camila Moore, and I served as the chairperson of the First in the Nation California Reparations Task Force. We worked for 2 years to not only study, but to also develop reparations proposals for African Americans with a special consideration for descendants of persons enslaved in the United States. Thank you so much to Northeastern for having me. First, before I get into my remarks, I do want to pay homage to, African American attorneys who have pursued strategic litigation in the past to achieve reparations, particularly for descendants of enslaved Africans in the United States, like Johnny Cochran, like the late Johnny Cochran, like the late Charles Ogletree, and even today, a living, amazing attorney, Deidre Farmer-Pellman, right? These are people who have worked over the past 20 odd years utilizing strategic litigation as an avenue for repair. But, you know, as Randall, actually my former colleague at Schulte, Roth, and Zabel said in the other panel, in reading, right, the Supreme Court opinion from Tulsa Supreme Court case, you know, they said quite clearly, right, that reparations is a political question, and we're seeing, you know, jurists state that time and time again. And so, in a sense, not entirely, but in a sense, strategic litigation, particularly for reparations, a lot of the avenues within strategic litigation seem to have exhausted themselves. And so, you know, it appears as if there needs to be a shift to legislation, right, legislative action. And, you know, that's what the California Reparations Task Force was all about, right? The task force came to be by a piece of legislation called AB 3121 that was championed by then at the time a state assembly member, Shirley Weber. Now she's California's first African-American Secretary of State, right? She shepherded that bill that created the task force through the state assembly and the state senate. The governor of California, Gavin Newsom, signed it into law. And then that created the task force. The task force, we were a legislative advisory body. So our official role and capacity was to advise the state legislature on the types of reparations proposals that they should then turn into legislation. And so that's where we are now. The task force has sunset. We sunset last year, and now we're in the phase where legislators, particularly the California Legislative Black Caucus, has turned our recommendations into a package of reparations legislation that is currently going through the California Assembly and State Senate currently. So I just wanted to concur and state that in terms of my big takeaways, you know, it does seem as if strategic litigation in certain instances have exhausted itself, and it's time to turn to legislation, right? Power concedes nothing without a demand.
Okay, let's keep it going.
Okay, all right. My name is Tabitha Bonilla. I'm an associate professor at Northwestern in the School of Education and Social Policy, but I'm also a political scientist. So I join as a non-legal scholar, not a lawyer, never have been. So I've done a lot of learning today about how this is being approached from a legal perspective and what the constraints are. I think I agree that when you spend more time in spaces with social movement leaders, you have a lot of imagination and sometimes a lot of frustration with the legal constraints. And I think as someone who's helped to think about some of how people are understanding the program implementation in Evanston, there's a lot of frustration of what has happened, even as there is a lot of appreciation for the progress being made. And so I think, you know, just listening to some of the other panels talk about the need for organization, the need for the combination of this strategic legal thinking along with people who have broader imaginations is a really interesting grappling point, I think, for me today.
Hi, I'm Robin Toma. I'm Executive Director of the County Human Relations Commission in Los Angeles, part of county government. I should also mention that I'm on the board of the International Association of Official Human Rights Agencies, which is a network of all of the state, county, city, governmental, human rights, civil rights, human relations organizations around the country. This has been wonderful in the sense that thinking about my own experience around redress and reparations, it just, listening to all the speakers really highlighted how so many different approaches have been taken. And it really corresponds to what your situation is in your community. I just mentioned for the, you know, one of the cases I did for reparations was suing the US government on behalf of a little-known group of Japanese Latin American former internees who were brought forcibly by the US government during World War II to be used in prisoner exchange with Japan. And they were basically uprooted out of their own countries, brought here, put in camps, and then shipped to Japan to get US civilians who were in territories held by Japan. And that lawsuit really came about based on the 1988 Civil Liberties Act, which was intended to compensate those Japanese Americans who were interned in the U.S. Camps during World War II. That included my mother and my aunts and uncles. And it was through a legal clinic that I learned about this case, and I went, what? And it was, part of the actual official report of the U.S. government U.S. Commission on Wartime Relocation and Internment, tucked in the appendix, that acknowledged this whole sordid episode, which took people who weren't even from the United States, stripped them of papers so they would be undocumented, so they could be used in this prisoner exchange. And then when it came time for reparations, they were being told by the U.S. government, even though they were living here, that, I'm sorry, you don't qualify because you weren't a U.S. citizen or permanent resident at the time of your internment. Well, of course they weren't, because they were forcibly brought here by the U.S. government and stripped of their legal status. So the way we brought about change was through litigation, but it was through the connection and coordination with community-based organizations. A group called Campaign for Justice for Japanese Latin American former internees really pressured and led this struggle over many years, and we connected with another two groups that were key in the struggle for Japanese American redress. They were the ones who really brought the political and community pressure that ultimately forced the Justice Department to come to a resolution. And we had numerous meetings with members of Congress as well as the White House. And of course, we had the Clinton administration, who was much more open to coming to a settlement. So redress and reparations comes different ways in different contexts. But I really, what the takeaway for me was just listening to like Tulsa, Oklahoma, using public nuisance law being, that blew my mind that was the way that it was approached. But, whatever means that you have that makes sense in your context, and also you're going to learn and find limitations, but it also told me we need to have more of these discussions, because I think that we can so benefit from hearing from one another and understanding what has been used in different contexts to achieve whatever limited reparations and redress we've been able to achieve.
Wow. Well, thank you so much for all of you for your rich work and what you've shared. I think what I'm hearing is a little bit of agreement that it is all political, right? That it's a bit complex, and not just reparations, right? But all justice work, all human rights work. So why shouldn't reparations, with its particular challenges, also ultimately be a political project, right? An ethical and political project, and that it is complex, that it is multifaceted, and that it's not just about the lawyers if we're going to be successful, right? That's my takeaway from your takeaways. Also that it's very long-term work, right? And I just want to, everyone that I heard today who've been at this year after year, I just want to acknowledge the level of investment and commitment you have shown. So thank you very much. All right, so we're going to move on to the next question. And gonna start with Tabitha, but please, other people jump in if you have a thought on the question. The question is, where do you see reparations fitting into the broader goals of the U.S. racial justice movement? Today we heard it was necessary but not sufficient for some people. I've also heard people urge that in essence all racial justice work is reparative, and we should think of it that way, right? How should we strategically think about the possibilities and limits of reparations, whether as a legal project, an organizing project, a narrative project, or something else?
Who are you starting with? Sorry.
Was it me?
Yeah.
Okay. Oops. Moving off my notes here. Okay, so I think I'll answer this by chiming in to agree with the idea that I think reparations are necessary, but they aren't sufficient because of the legal realities of how they can exist and the political realities of where they can happen. Along with a colleague, Alvin Tillery, I helped to do some work to try and understand how the city of Evanston understood the implementation of the reparations policy. So we conducted a survey in 2021 2022. So this is after the first round of reparation funding had been given and before the correction or alteration, I should say, to the way that the reparations were distributed happened. So we surveyed the entire city. Everybody was invited to participate who was an adult. There's about 62,000 adults in Evanston. We reached about 3,600 people. We sent mailers specifically to communities that were higher population density, Black and historically Black neighborhoods with the hope of really reaching out to that population first and foremost. And what we found was that the majority of Evanstonians, Black or white, thought that this was a great policy. They appreciated it. They wanted it to continue. They thought it made a lot of sense. We also saw some increases in the trust of city government, which is sometimes hard to do. But the biggest increases and the biggest areas of approval came from white Evanstonians, who I think we saw increases in approval of city government by almost 25 points, which is a pretty big increase. And among Black communities, probably only 10 points of increase in trust in the government. I think in the sense that people are appreciating the policy, that seems very clear. But in doing this work, it became very clear that there's a core contingent of Evanstonians who felt that some of the implementation wasn't quite how they wanted. So there was only about 6% of our sample who are really opposed to this policy. I think some of those people have joined this lawsuit, trying to say that they too deserve to be included in thoughts like this. But surprisingly, some of the Black Evanstonians were upset with the program as well because they felt like it didn't include them and it didn't represent them. And I think when you think about all of the legal realities of the program, it was very clear why that couldn't happen, and yet that there was a little bit of a translation issue that I think was rectified as the program adjusted a little bit. But one of the things that we heard from people was that many of the original ancestors weren't eligible for the original definition of the program because they were renters. I think it was about 106 ancestors. And several ancestors actually died while waiting for the funds in the program. And so there's some realities of the program while doing a lot, not going as far as it could. I think in the context of reparations not being enough, I'll just pivot a little. Well, let me end on a slightly happier note, if that's okay. I think, though, one of the things to think about from a political project is that Evanston is quite unique. It is, as other people have mentioned earlier, very blue, left-leaning. I think that this was an important policy window when this happened in 2020, 2021, even though the groundwork was laid even before all of the racial unrest of 2020. There was a lot of citywide movement toward repair that included not just the reparations program, but also included some of the trying to correct some of the harms done during the 60s. There was a Fifth Ward school that had been shut down when schools were integrated, and those children in that predominantly Black neighborhood were bused outside of their neighborhood, and that is still the case today. So during the same period, the city voted to rebuild a school in that neighborhood, and then the busing program. So there's a lot of effort within Evanston to provide repair, and I think that political context is meaningful, but also suggests that we have to think, to the point of why I think this is necessary but insufficient. There's a lot of people for whom being a descendant of an enslaved person still matters in their life, but for whom this program does not actually have impact. So if you are not able to move to Evanston because of those policies, you were impacted by that policy and still unable to receive this. If you had to move out of Evanston because the increase in housing prices during that period, you're no longer eligible for this. So as much good as this is doing, there are a lot of people being left out. And then I think the final addition to that is that there are a lot of communities that are not like Evanston, where you don't have 80% of the city voting for the Democratic president. And even in this city where we have so much support, when you do a project like this, just asking people what they think of the program, there's a lot of negative reaction. So my colleague Al, whose email was on the project and who, as leader of the work, received many complaints directly to the university for even asking the question. He had to have several meetings with the university leadership just to explain what was being done, and people just outraged, emailing him every day to talk about the negativity. So I think it's also a really real concern to think through, what does this mean in communities that that aren't quite like Evanston. So
let me turn to you, just zoning out more nationally, since you did spend 15 years very involved with Movement for Black Lives. Where do you see and thank you for that, that was beautiful explanation of where it can, have a significant role in some of the limitations. But I wanted to ask you, in terms of the larger national strategy, how would you answer that question in terms of its limits, possibilities, and where it fits in?
Yeah, so thank you for that. I think it's, I agree that I think it's necessary and not sufficient. I'll say two things. I think that when I think about reparations, I think about kind of two ways of thinking about it. One is demands around specific harms that have happened. And for that, I think we have to be very specific. We have to name who has been harmed. We have to assess all of the ways in which they've been harmed. We have to allow and support and empower them to think through how repair might look. And I think the kind of UN definition that gives us a sense of not just it ending the harm, which is a policy and a legal challenge, but how do we also repair psychologically? How do we repair legally? How do we repair in all these different facets that's holistic? And that's really helpful. And for me, I think Joey said this, and I believe this wholeheartedly, that every time we win one small reparations fight, we actually open up space for a bigger one. And so to me, I've been supporting a lot around the war on drugs reparations fights. I think every single time we open up more space for that, the demands around kind of the global racial order that led to chattel slavery were closer to making those reparations real too. So I think that's one kind of thing to think about is, you have an injury you want to repair, you have a reparations campaign to repair it. But I have to say that I was transformed in my exposure to reparations as a frame, not just for demand, but as actually a way to think about how we do policy and how we do campaigns. And so I think this idea that whenever you have a policy in mind, whether it is forward-looking and backward-looking or just forward-looking, that it includes a commitment to trying to end harm, that I spend a lot of time in the criminal legal space, and so often we are passing policies that, although stopped one harm, open the door for a new harm. And so to think, okay, before I do any kind of policy, I want to have a reparatory framework that includes really an assessment of how do we actually use this moment to stop all sorts of harms. I think also an assessment or an approach that assesses critically the kind of scope of harms that any type of policy has created or formed. One that is concerned with rehabilitation as well as compensation, that looks back as it looks forward. And one that really ensures that we are acknowledging through narrative. And this is something that came out a lot for me in the first kind of half of today is I think it's essential. Apologies are not satisfaction by themselves. They are one element of satisfaction. We live in a country where if you go to North Carolina or to Alabama, literally every other street is named after a slave hurdle. We have spent so much time in this country memorializing, really, and in many ways glorifying the violence of chattel slavery, the violence of Jim Crow, the violence of lynching. And so the project to satisfy is not just someone saying, I'm sorry, it's renaming every street. It's the memorials that EJI has done. And so I think this commitment to memorialization, to ritual, to retelling the history, because it is in retelling the history that we make the case for the reparations. That if all of us know that history, we're much more likely to have the kind of public opinion we need to pass reparations. And so I think that narrative project should also be embedded in all of our policy work. So I said to say, I think, that reparations are not sufficient, but this idea, this commitment to reparatory justice, to thinking about every single campaign or organizing approach as being reparatory is a really powerful, I think, shift in how we might be doing policy.
So it's very specificity and its power. It's both its limitation, but strategically deployed can open the door to a much deeper, robust approach to repairing the country, not just individuals. I saw you wanted to jump on in.
Yeah, no, couple of points as I'm hearing you speak. Of course, everything you say, I'm just going to say yes, yes, me too. But, when you concluded your remarks earlier, you mentioned about like the political nature of the project, how complex it is. And I say yes, but, and the but is because people often use that as the excuse to say not now. It's too complex, it's too political, we don't have the support. And so I just want to caution, as we think of our framing, how we ensure sort of forward momentum. And with respect to what is the right container, and is this necessary but insufficient, so I thought that was an interesting way to think about it, because I think of it as necessary and foundational. And like, that's the foundation to address past harms, the history of the country, sort of the full truth. It's not just the sort of the legal aspects, it's the memorials, it's the public space, it's the ways in which we frame our language and how we think of what is right, who is deserving of freedom and opportunity and so on. And then we look to the future. So I see this complementary, that ability to focus on past harm and repair and reparations, in addition to thinking about liberatory futures.
See, and I wasn't going to ask everyone every question, but now I want to hear from LA, from Edmonton, like how was it, how did it play out where you were? I mean, Robin, it's quite the story, right? The things that people think about and do are sometimes hard to even wrap your brain around. What a contribution did that make to the sort of more systemic efforts your commission is pushing?
Well, I have to say that I'm also kind of in a unique situation in LA County, because we have the wonderful situation of having an all-women led board of supervisors, which is really amazing. And in my 20-some years of being there, I've seen it go from, with a very conservative bent to being one of the most progressive governments that I've ever been a part of. So I'm proud to say that, that's where we are. I do want to mention, because I just told the story, that I want to make clear that litigation against the U.S. government wasn't while I was an LA County government employee. It was in my prior life as an ACLU staff attorney. Very important detail I didn't want to leave you with. I think what I wanted to say is that impact of that shift, I think, in the culture and the realization, because of George Floyd's murder and really honoring him and his family and the whole movements that sprouted up around the country, it really created the fertile ground in LA for us to focus on reparations. But because we were limited in California by a measure that prohibits affirmative action by government entities, the approach is, when I think about it, has really been issue-based. So we had a Measure H that infused from tax dollars anti-homelessness initiatives, right? We had Measure J, which then focused on alternatives to incarceration and has created $100 to $300 million each year in our budget for those alternatives to incarceration. And then we have Measure B in anti-violence, which goes back farther, but we've utilized to do anti-hate work and build a system, because I think, one of the things I wanted to say is, there's so many, hate crimes can often be pushed to this point of where it's just a reason for expanding sentences and broadening nets. But we are of the mind that, for every hate crime that you may hear about, there are hundreds, if not thousands, of hate incidents which are going on. And what does it mean if we don't speak out and create its connections to the people who are experiencing those? The truth is that most people who've experienced this, I'm sure everyone in this room can think of you or someone you know who's experienced an act of hate that was not reported, that was never taken action on. And I think it goes to the idea that, when we don't take action against it, we're basically sanctioning it. And that environment of hate is what allows more intense hate violence to happen. It empowers white supremacists, white nationalists, racist organizations, and it creates a sense of lack of belonging. So what we've created is a system that for the first time says if you've been a victim of any act of hate, whether or not it's a crime, you don't have to go to the police. You can come to us, a community-centered based system that is an alternative route. And the fact that we've already become, since 2019 when we launched, we've become the third largest source of hate crime reports that exceeds 44 city-based police departments and dozens of other school-based police departments, et cetera, speaks to the fact that people have not been reporting because they don't want to go to the police. And that's true of so many of our target population. So, and I think of it as a way to address the fact that people who suffer what may not be a hate crime, but been told, get out of here, you don't belong here, or shower you with epithets in a supermarket or in a public space, and nothing happens to them. I mean, the victim carries trauma from that. I remember when I was a young adult, before law school, going with my mother to get, she was going to get honored by the PTA, and my whole family was there. There were 5 kids and my parents, and we got out of the car, and this little kid on a bike, 9 years old, rides by and says, "Get out of here, you Japs." I'm thinking, what? And for me, because I didn't grow up in that era, my mother was incensed because for her, those were, that was a word that sent an arrow right through her heart. But for me, it was just a weird thing. Like, why would a 9-year-old kid use that term in a way that is so targeted? Well, obviously, he must have heard it from parents, grandparents, right? And we didn't know we didn't report it. Something like that is indicative of something going on that we're either not addressing or failing to take action against, like education, strengthen education in the community. And I just think of that, and I've heard so many stories after Trump was elected from folks who are just in supermarkets, in public spaces, where all of a sudden they have somebody yelling at them epithets, and they feel empowered to do that openly now. So how do we make sure that that doesn't get normalized? And so this is a way that we're saying, let's tell us what's happening to you. We connect the victims, we connect them to each other, we empower them to become advocates for change, and more than anything, we're providing services to them in a way that says we care. And I think it's an important way that we have seen when no other agency of government or community-based organization is helping them, we're able to help them. And I feel like using art, using community-based organizations as networks, we funded over 57 nonprofits to directly assist victims and to advocate for change. I feel like that this is so critical to shifting the environment and to basically say, no, you cannot say those things, and just because it's not a criminal action, nothing happens to you. So that's, and it's adopted by California. They've begun California versus hate. We're still building the system, but I really feel like it's such an important one, not only for victim assistance, but to build inter-community solidarity. We talked about us standing together for each other, and we just had a gathering with over 57 community-based organizations, and we said, you need to collaborate with one another. And out of that, nurturing that, we've had so many different collaborations begin. And so that's the kind of thing that we're very excited about. But thanks to our unique situation.
Actually, what you just raised sort of begs the question, how broad is the sweep of reparations, right? Racist harm is systemic, endemic, pandemic, it's everywhere. And it sort of relates, I think that question in a way connects to what was going to be my next question. While it is true that it opens the door, that it could be a foundation, we're also in a moment of backlash. And that question of how broad are we going to have to, uncomfortable white people, right? Are we going to have to repair everything? How much do we owe? Is our debt ever going to be paid? And how are we going to pay it when it's happening every day? So how do we respond to the deep discomfort and resentment that the concept evokes in some, in certain sectors, primarily white, but not even exclusively? Sometimes you get odd reactions from other communities as well. And that resentment, that racialized fear and resentment undergirds a lot of the backlash. How do we engage in the fight for reparations, define the breadth of reparations, talk about the depth of reparations in a way that inoculates against that kind of resentment and backlash, which has been so fierce and damaging in the last couple of years, and in fact began 3 weeks after the murder of George Floyd, with the first blog by Chris Rufo that organized the right in the backlash and led to the Trump executive order banning conversations on race. So how do we do this work that to overuse word, but triggers certain white people, triggers people on the right? We know we got to do it. How do we inoculate against backlash? Who wants that easy question? Go ahead, somebody. I'm calling you if you don't.
I have a thought, but I'm going to wait for someone else to speak.
Oh, look at that, playing it safe.
Those are two kind of questions in one. So I'll address the backlash. Yes, sorry. I'll address the backlash. I think first we need to learn from history and know that, political backlash is not new. I'll argue we're kind of in the third era of Reconstruction in this country, right? We've heard, right, the first era of Reconstruction was, right after slavery, and that period of Reconstruction only lasted 7 years, right? The late W.B. Du Bois said in Black Reconstruction, right after emancipation, the slave went free, stood a brief moment in the sun, and then moved back towards slavery, right? That's where we are now. We have never gotten away from that moment of slavery, aside from the short-lived period of Reconstruction after emancipation. And then after that, you had the Black Codes, the rise of Jim Crow, apartheid. And the second era of Reconstruction, I would argue, is the Civil Rights Movement, right? Where we saw some progress. We saw the Civil Rights Act of 1964, the Voting Rights Act of 1965. But then right after that, you saw a backlash, right? Schools still are segregated, right? You have, for instance, the rise of neoliberalism, the rise of neoconservatism, right, that has worked to undo a lot of the work that was done by folks in the civil rights movement. And then I guess you could say now we're in this third era of Reconstruction where we're seeing a backlash, right? Some Reconstruction, very brief, as you mentioned, right, due to the racial reckoning that happened when George Floyd was murdered. But now we're seeing the backlash to that, right? Just 4 short years after that moment, we're seeing the energy has completely almost dissipated in terms of people's appetite for achieving justice. And so how do you work with that? Learning from history, nonstop education and organizing is, to me, the solutions. That's what we're doing in California. We are, creating a broad-based coalition of allies, because African Americans, those who descend from persons enslaved in the United States and California, are a minority. We only represent 7% of the state of California, so we cannot achieve reparations for ourselves alone. We have to lead the movement, and that's what we're doing. But we are working actively with other cultures to, collectively, educate the entire state of California as to why reparations for this particular group of people is important and necessary. So I would just say, learning from history is definitely important, and then gleaning from that, what I've learned is you just have to keep educating and organizing.
Go ahead, you got your weight to be second, now you get to be second.
Well, I had 2 thoughts. One is that, movement organizations, progressive organizations, all kinds of groups now are just being bogged down with infighting. And in this era of backlash, I think that ability to kind of go to the balcony, to get some perspective and to say, what are we trying to advance, and how do we work together to get to that goal, as opposed to being so fractured, right? So I think that is, for me, like an urgent call to action to be able to deal with sort of the broader societal backlash. The second thing I wanted to say was the comment on CARICOM and the perspectives on sort of who is eligible, and an earlier comment earlier in the day around sort of this notion of kind of the eligibility being people who are descended from slavery in the United States versus those, with this broader definition. And I think one of the challenges is that the nature of the transatlantic slave trade and the growth of capitalism was such that it was global in nature, that the people in Boston or Maine or wherever else who were making money were making it not just in their own backyard, but also the plantations in the Carolinas, in Barbados. And so you really have to think about this in this context throughout the Black Atlantic and account for that. And so, again, ensuring that we don't let these internal divides within the reparations movement slow down the ability, because then others will say, oh, well, it's very hard to decide who's eligible. None of us are responsible anyway. This is too complex. So in the face of backlash, which is predictable, we need to sort of be more aligned and united.
So unity in the face of backlash is usually pretty good advice. So thank you for that. But I just want to push a little on part of the backlash is also, demanding ever higher burdens of proof, demanding more specificity. How do we, and the narrowing, right? What the promise of reparative efforts are. How do we navigate these very technical attacks that seem, that it's harder to kind of message in the public against?
I was going to speak to hearts and minds a little bit, so I'll try to touch on that too, though. But I think, I'll say two things. One is my grandma used to always tell me that if everyone likes you, it probably means you lack character. And in the same way, I think if everyone agrees with your policy, it probably lacks substance. And so to me, at its most ambitious, which is what I believe in, reparations is a radical redistribution of resources, of power, and of narrative and history. And so there are going to be lots of people who don't want to do that, and because they benefit from the current distribution. And so I think more than trying to your point, avoid backlash, I think we have to prepare ourselves and our movements for backlash. How do we make sure we have the power, the resilience, the coalitions, the unity to actually be prepared for what would be a very, very, very strong backlash? Because I think if we win reparations, we're actually winning a massive redistribution, which is disrupts the status quo to the point that, of course, lots of people disagree. But I think for people who are inclined to agree with things around justice and redistribution, there's a few arguments that we can and should be making. So one is that if we have any interest in ending these global cycles of inequality, these global cycles of exploitation, of racism, of gender-based violence, we have to actually engage in a reparative project. That if we don't look back to assess what has happened and how we got here and start to rethink and redistribute resources and power, that we are inevitably going to recreate the exact same situation. It's why, despite reforms to the criminal legal system or housing, we see continuous disparities that seem unstoppable because we've never actually derooted them, right? So I think if you're interested in justice, you want to see something that actually works. Reparations is required for efficacy. The other thing that I'll say is I think, and there's a new book called Reconsidering Reparations that I think is really helpful for this, is I think it's helpful to get away from language around blame or even responsibility. I think the kind of strict liability standard is actually really helpful here. What's at stake is that the way that kind of history has distributed power and resources, has ordered who gets what, is that people who have the most, institutions that have amassed wealth and power, are responsible for redistributing that power and wealth, right? And so I think this idea of you're to blame or your ancestors are to blame, as opposed to actually this is an unfair system that was created by this history and we have to be invested in undoing that, and you are liable even if not responsible for it, I think is a helpful way to think about it. The other thing I'll say is, my reparations vision that has been really fed by the movements that I've been a part of is visionary. That it's not actually just about equity, that we could all live in really shitty conditions and that could be equitable, and that might be the direction we're actually going. That instead the goal is actually something where all of us are in a more just world, that all of us have more access to resources, all of us breathe clean air and drink clean water and aren't in cages, right? And have the things we need to thrive and succeed. And so I think this idea of actually this is not a scarcity model, it's an abundance model is really important. The last thing I think that is is helpful when we think about how do we kind of win hearts and minds to this argument is this idea that kind of reparations seeks to address racialized harms because our society has been organized through racial capitalism in a way that it impacts Black and brown people more than other people. But actually, reparations as a concept isn't just racial, right? It's also about how do we invest and engage in harms that have been perpetrated against different groups of people by those who have power. And so I think of kind of the Combahee River Collective, that if you get Black women free, everybody is free because the very kind of institutions that necessitate all unfreedom will get everyone free. I think the same thing is true for a reparations fund, that ultimately you think of kind of environmental justice or the war on drugs, that although these systems were created and racialized, the harm actually extends beyond just Black people or just brown people. And so how do we think about actually repair in a way that is holistic, that centers, right? And I think the war on drugs is a really powerful example, that the war on drugs was clearly from its origins a racialized war. It was meant to suppress the political power of Black people. It was meant to deal with a growing economic problem about labor. But actually its consequences, the engines that were built, the institutions that were built, the cages that were built, the drugs that got imported have harmed lots of communities. And so how do we think about repair centering the racialized nature, but expanding repair to all those who have been harmed?
So in essence, what I'm hearing is as a strategy, thinking about a reparations movement is shifting the gaze from the victim to the institutions. It's complicated, right? Because I've also heard earlier that those who have the survivors have, by becoming visible, have had a, healing kind of experience as well. Just curious how others see that tension between the system, right, that creates the harm and these sort of large sweeps of harm versus many of the very specific, deep work that people are doing to repair for particular people and communities. Does anybody have sort of thoughts on that?
Well, I think that one of the ways that I see in our county that we've been able to address a lot of major issues without running into challenges is, I think we started to really look inward first as a county government, and we spent a lot of time doing equity education, and then we decided instead of just making it a high-level value pronouncement, it became part of, through the leadership of board members and creating an Office of Anti-Racism, Diversity, and Inclusion, ARDI, that really began to implement in a very concrete way equity as a goal and as a practice and operationalizing it into government. So then all of a sudden you had department heads who were being evaluated on very specific deliverables related to equity. We had every single department having an equity action team that's being trained on how to provide leadership within that department. We have, using the ARPA funds, the over $1 billion that came to LA County, there had to be equity goals and alignment with the data for whatever project you were doing, how you were addressing the most underserved, disadvantaged communities. And so through all of those ways, we're starting to see such an impact, and it's become not just something that the county is doing as a sideline project or as one of their projects. It's really become central to the strategic plan and priorities. And I think that's, in my view, when I came to county government, I thought, okay, how do I make sure that instead of suing the county all the time, which I was doing as an ACLU staff attorney, how can we actually get the county to, see things in the right way and not just figure out how to sidestep, litigation. And what I've seen in my years there is that we have gone to, reacting with measures to proactively integrating it into our approach. And, we're not there yet. We have a long ways to go, but the transformation is incredible to see how if you use the right kinds of metrics and strategies to make it part of what the Department of Public Works decides to do, or the Parks and Recreation, where they're going to, expand new parks, or the way that the Internal Services Division, which does procurement, how they prioritize, communities and businesses that are underserved or have been received less consideration in county business. So all of these things put together, I think it really is astonishing and probably lesser known, but I've just been seeing this transformation, and part of that transformation, we've been doing training within county departments. I think it really does, we haven't really seen, we do have people coming to the board meetings with incredibly rude and racist, rants that aren't probably surprising, but in the end, people can have their say and the government moves forward. And so I think that the progress through strategizing through government, with government, as well as building community power to keep the pressure on, has been so critical. Even in the reform of the sheriff's department, which in my lifetime I thought would never really get to where it is today. But we finally gave the power to the Board of Supervisors to be able to remove a sheriff for something less than a criminal behavior. So that's powerful, given that it's a position that's elected countywide.
So let's move to the, I'm sorry, go ahead.
I was gonna, if I could just answer, I think the tension you're describing maybe in this way, which is that part of the difficulty with reparations in general is that you're asking a system that retains the power to release it in some way. And I think what I understood you saying is that there are different ways to do this, and encouraging those in power to take responsibility instead of blaming helps to ease that tension and relax it in a way that enables them to move forward with these claims. The other tiny little note, which I think pales in comparison to what others have said, is that I think one of the nice things about what Evanston did with the narrow policy, beyond the legalities of it, was that I think it actually enabled members of the white community in Evanston who might have been opposed to it to actually really understand what was happening and really pair a direct, discernible harm to a remedy and a fix. And that understanding helped learning that I think might not have otherwise taken place.
That's the power of the specificity. So I'm just moving to the state of California here for a second, as both a little bit in relation to that last question and to the one I'm going to slide into here. What I think the last question surfaced a little bit for me is it's a bit of a gray area between equity and reparations, right? California, the state of California, has made a big commitment to both. How does the state see the distinction? And what, both in terms of what you've heard here today and your own experience, do you see as one of the most powerful vehicles, right? Like you have a commission, is it city councils, is it lawsuits, is it targeting large private institutions, like all the vehicles you see out there as you're thinking about how a whole state comes up with a strategy? Which ones are the most powerful, and how does California distinguish between the equity commitment it's made and its commitment to reparations?
Well, first, the state of California, we have a state reparations task force that just concluded its work, but we also have an official racial equity state task force. So that in and of itself is showing that there's a distinction, because there's two separate state commissions. One has studied and developed reparations proposals for a particular group of people, and have also developed racial equity policy recommendations to complement the policies that are specific to descendants of persons enslaved in the United States. But then the other commission, the Racial Equity Commission, they're tasked with, studying and developing more broad-based policies. So, me personally, I'm not speaking for the state of California, though. I do see a distinction between, reparations and racial equity, particularly in a state like California, where race-based affirmative action in the areas of employment, contracting, and education have been illegal in the state of California for almost 30 years. So we've been in a landscape far longer than the federal government has in contemplating, how to achieve racial equity and reparations in general with that particular ban. And so again, for reparations, the task force, we utilize the 5 forms of reparations under international law as our guiding light, as our North Star, to structure our reparations recommendations to a specific group of people. So in all, reparations to me is particularized, it is targeted to a specific group of people for a historic and ongoing experience, and that is for descendants of persons enslaved in the United States, but then there's also racial equity policies that the task force and other commissions have championed that are intend to be more broad and inclusive. And I guess I'll go on to say, and what I'm going to say might be a little controversial, but just to illustrate it a little bit, because I do think sometimes it's problematic where people kind of tell African Americans, well, if we can't do reparations a certain way for you all, if we can't do it so it's so broad-based, or if we can't do it to include all Black people, then we shouldn't do it at all. And I don't think that's fair, because that's never been told to other groups who have suffered particular injuries, right? No one has told victims of the Holocaust and their heirs that you all, you don't deserve reparations because we can't solve anti-Semitism if we give you this package, right? They needed reparations because they deserved it for a particular experience, and the curing anti-Semitism doesn't have to be attached to that. In the same way that I see folks from the outside saying, curing anti-Blackness has to be a part of reparations, right? It's naive to say that once African Americans get reparations, that anti-Blackness will cease to exist. There's going to be deeper and longer work to really cure anti-Blackness, just like there's going to be deeper and longer work that's needed to cure anti-Semitism, right? We aren't going to deny Japanese American internment camp survivors reparations. Well, let me invert it by saying, right, Japanese Americans receiving reparations did not stop, anti-Asian hate, right? So these are these deeper issues, right, that are going to need deeper thinking and solving, but that should not stop or get in the way or impede for specific redress for specific groups of people who have, have been affected by particular harms.
I just want to jump in and say I totally agree that, the work of reparations is really in support of this wider view of equity, because, you can't just put all in one big pile, and just say that we're going to solve it all with this one act or whatever. It really, to respect the communities that have been affected, you have to understand their own history. And I just want to say that for folks who haven't seen the report that Camila and the commission put out, you really should take a look at it. It's extraordinary and really deserves attention, even though it's very long. It does have, you just read the executive summary, which in itself is long, but really is an incredible summation of the harms historically and very specifically that African Americans in this country and in the state of California have suffered, not just because of institutions broadly, but specifically what California has done in other communities. And I think one of the things that the LA County did early on to sort of in the same way is that it identified one case, Bruce's Beach, where a Black family had been dispossessed of their land by using eminent domain in one coastal city in LA County. Back in the 20s, that the county decided, we're going to go back and we're going to fix that. And they actually went and reversed it and got the title given back to the original landowners 100 years later almost. But through that, it was such a powerful story about how government had wronged people and can right it, right? And even though it was that one case, it begins just to pierce that notion that, we can't fix anything because it's so long ago, or, there's too many people or too many issues. If you just take one step, it does start to lift up the reality of just one story of suffering and deprivation that occurred. So, I think that's what the county governments, I think that has really helped power it forward in embarking on a equity approach that is really gotten wide support and not to say it's no backlash, but really nothing that's been able to hinder its progress.
So I'm standing because it's a great conversation, but also because I've got a code to read.
Okay.
It's Q as in quiz, V as in Victor, 8, 2, W as in Wilson, 9, QV 8 2 W9. Thanks.
Are we supposed to know what the code is?
CLE.
It's for what? Oh, for the CLE, okay. Just for those of you who are as clueless as I am, that's for the CLE. So I'm going to go back to you, but also to connect it to, and I loved what you said, because essentially what you're saying is that while, the fact that reparation isn't going to cure anti-blackness doesn't mean that we should let anti-blackness stop reparations. Right? But when we did our prep call, you also expressed some frustration that while there are some specific wins, right, in the work, in the movement for reparations, that there's not enough actual material conditions changing. So as a broad matter, right, there have been some great efforts where there have been individuals who have benefited, and we should not at all dismiss the importance of that. But what you noted is not getting enough implementation in these bigger efforts. So what is that? Where do you see the value of all of you, the value of the conversation in reparations, separate and apart from how broadly it might, improve material conditions? Like, what does it feed into beyond the specific cases, I suppose? Or do you think that we would get to a place, if we kept going, where it could dramatically shift material conditions? So I'll go back to you, Camilla, because you were going to say something more about California.
Well, I was just going to give LA County some kudos because just to show some synergy between what the state commission has done, and we're already seeing counties and cities kind of implement certain aspects of the task force's work. So in terms of the task force, the state task force, in terms of who we decided should be eligible for some of the more material, substantive forms of reparations, we adopted this definition that we considered the community of eligibility, kind of taking from the definition of the Freedmen's Bureau that the chair of the Boston Reparations Task Force mentioned earlier. And so the definition that we said, you're eligible if you're a descendant of a person enslaved in the United States, prior to the 19th century. And recently, on Juneteenth, actually, LA County, they just adopted a reparations ordinance just a couple of weeks ago, led by Supervisor Holly Mitchell, who is the lone Black supervisor on the board, and that passed with flying colors. And so for Juneteenth, actually, so yesterday, LA County, through self-attestation, allowed for descendants of persons enslaved in the United States, so they lifted or adopted the definition from the task force and stated, if you fit this definition, you can get free access to LA County beaches, parks, and museums for Juneteenth and dates leading after Juneteenth as well, right? So we're already seeing, which is absolutely amazing, counties, municipalities, right, learning from the state task force and starting to, utilize their power to implement, reparations for this specific group of people in the way that they can.
Do others have thoughts about how far implementation you think they will go? Do you want to?
Well, the task force, we concluded our work last year. So as I said in the beginning of our conversation, we're in the phase where legislators are right now, as we speak, debating and passing various different reparations legislation and racial equity legislation. And so August 31st is the deadline for the California State Legislature to pass any and all bills. And September 30th is the deadline for Governor Newsom to sign those bills into law. I will say, I want to just mention two pieces of legislation because there's over 15, but two pieces of legislation that I can highlight right now are Senate Bill 1403 and Senate Bill 1331. Senate Bill 1331 would create a new account in the California State Treasury
specifically to fund reparations policies and programs for descendants of persons enslaved in the United States and residing in California, of course. And that bill has passed the entire state Senate. It is now in the Assembly. It passed the Assembly Judiciary Committee, so now it only has 2 steps left. The Assembly Appropriations Committee, then the Assembly floor, and then it goes to Governor Newsom's desk. The same for SB 1403. That would create a new state agency in the state of California, and that agency would be called the California American Freedmen Affairs Agency. And that agency would administer the reparations programs and policies, particularly for descendants of persons enslaved in the United States and residing in California. And that bill also passed with flying colors in the state Senate and is in the same process in the state Assembly. And so, we're seeing really good progress and, anticipated also passing on the Assembly floor as well. And then obviously we're going to need, and we are already organizing for a broad-based multicultural coalition to get Governor Newsom to sign these pieces of legislation into law. So, I already stated before, strategic litigation in certain instances is not completely closed off, but it has in its way exhausted. So, legislation really is one of our only, viable solutions. So it serves in our best interest to just keep on the fight in terms of ensuring these legislative wins. And California is making good progress in that end.
All right, all eyes on California for a while. You're close. I'm gonna, as a former litigator and campaigner, I'm gonna use the word targets, but they could be friendly targets, so not to be taken wrong for the government people on the panel. Could ask each of you, perhaps, there's so many ways to enter this fight, right? There's working as you're doing at state level, there's the local level efforts that are also, programs, litigation, different approaches. There's looking at, private institutions that were enriched historically. And there's also, local, state, federal, like what is the let's talk about what might be happening at the federal government next year, but as a long-term vision, what do we imagine that as well? So my question is, what do you each see as the sort of, what should be a higher priority targets where we have most possibility? And what are the vehicles that you would use to engage that target? You want to go? I see you making a face. Oh, you don't want to go? Okay. Well, who wants to lay out the national reparations strategy for us here? Because that's what you're here for,
No, I only have one quick comment, and I kind of had a eureka moment in, when the Tulsa Supreme Court met out its decision a couple of weeks ago. It was a tearjerker. A lot of people in the reparations space, we were completely devastated by that opinion. But I made a tweet that went semi-viral in a sense. It was just like kind of me just doing in despair of the moment, where I was like, we can't rely on the courts anymore. We have to put pressure on Congress and our state legislatures, because our legislatures have the constitutional responsibility, particularly Section 2 of the 13th Amendment. They have a constitutional responsibility to eradicate any lingering badges and incidents of slavery. And we've seen, and that was the thesis of the California Reparations Task Force report, that since the end of slavery, the federal government, and not only that, the state and local governments have abdicated, neglected its role and responsibility in doing just that. And so it's up to us as the people to hold our Congress and our legislatures accountable to its constitutional responsibility, and that is enacting legislation that is supposed to, eradicate these lingering badges and incidents of slavery, these major areas of systemic discrimination that still persist in this society and disproportionately impact, African Americans today.
You wanted to jump in?
Yeah, it's a big question, and it's a hard question, and I'm thinking of a couple of very specific ideas to lift up. One is like really thinking about the role of the media, and you touched on narrative, and if you take the issue of reparations and you look at the role of the media in actually promoting the slave trade, listing sort of ads for runaway people who are enslaved, sort of making money off of this system and what is owed by that set of institutions. So institutions like that, thinking of sectors like the media, thinking of civil society writ large, so many institutions are working in areas like health, education, et cetera. Like, what is the lens that they are bringing to the work to ensure that they're not just providing services, but also bringing that equity lens to ensure that, past disparities are not just being baked into current policies and so on. So, yes, we may not have a momentum on a legislative front or on a political front. Our elections may be fraught, but, thinking of...
And you're going to wrap this up how?
Really, like, are there other forces to think about how we as a society grapple with the history of the country and move us forward? Because the legislation is one piece. It comes back to your point, like, even if you have something in place in terms of financial compensation, it doesn't address the deep sort of systemic views that people often hold. So really thinking about like multiple approaches to build these movements.
Like a multi-sectoral strategy. And I will add, people may have noticed that the opposition has gone way out of its way to just shut down the conversation on race, which makes me think they may be onto something. Maybe it's a good thing to keep talking about reparations. I'm going to give everyone, just anyone, not all of you have to, but if you have a 1-minute closing thought that before we go to questions, that you felt like, hey, moderator, you didn't ask me the right question, I didn't get that out there, this would be your chance. Anything else left on the table you'd like to share?
I guess a little bit as closing and also to your last question. Yes, to that come with it. Robin Kelly says this about capitalism, that it would die not by one blow, but by 1,000 cuts. And I think a good friend of mine, Ashley Henderson, at the Highlander Center says, when we say by any means necessary, we mean by all the means. And so I really do deeply believe that we have to kind of approach this with 1,000 cuts. I agree that the courts, the rules of the court are meant in many ways to cabin and limit repair and are meant not to redistribute power in a fundamental way. And so I agree the courts are not the only way. But I think whether it's drawing off of kind of history lessons and the Black Manifesto work of targeting churches and faith communities, whether it's looking at corporations as well, whether it's looking at cities where we have the most power, but there are clearly limitations as was discussed, or states, or ultimately the federal government, I think that we should be approaching every single way that we can imagine and fighting on all fronts, and then really building and connecting our struggle in a meaningful way. What I will say, though, that I want to just kind of end with is I think the only way we win these fights, and for me the fight is not just about reparations for a single act or thing, but actually restructuring our society with a mind towards the kind of global racial economy and how it's been formulated, and undoing that. I think the only way we win that is by organizing and by power building and by centering folks who have been most impacted in that struggle. And for me, that is why I think an expansive version of reparations that doesn't cut off hundreds of thousands or tens of thousands of Black people or other forms of people, that understands the global dimensions of shadow slavery, that understands the continuing harms of slavery, whether it's in the form of Jim Crow or redlining or the war on drugs, that are really large and expansive view that takes into account, and it builds coalition with those people that says actually all of us have grievances that we should be thinking about, and whether or not reparations campaigns address one or another of those, that we should understand ourselves as in solidarity and in unity and backing each other's claims. That I back ferociously the kind of land back claims of Indigenous people, that's part of my vision of reparations. I think we have to think about a united front coalition that can't be so divisive, that can't be xenophobic, that has to really embrace, I think, the global dimensions and the ongoing, that it didn't stop in 1864 or 1900 or 1920, the harms of slavery, the harms of these systems continue, and those who benefit continue to benefit. So I think part of it is power building and a really embracing a coalitional politic and embracing a unity politic.
So it sounds like Thank you for that, Margaret. Not that I would expect any less of you, but it sounds like there's a role for everyone, right? We bring cases that lift up stories, that give us the conversation, that can push the legislation, that can build the movement, that can create the vision. And everyone here and beyond has a role because it's a big lift. So thank you all so much for your thoughts, and let's move to the questions, if there are any.
Thank you all so much for this panel. It was really informative. I was hoping you could speak a little bit more. I completely agree about the multi-sector approach and how we all have a part to play. And I was hoping you could speak to just how institutions, private institutions, should be thinking about their role in this movement. And if you had time, you could also speak to how faith institutions and what their role is in this narrative. I know we heard a little bit about that on the earlier panel, but there's more probably to be done. So
Let's take several of them, and then that way you can each jump in where you feel fit. You want to go over there?
Yeah, so I've also, it's a two-part piece. First of all, just trying to get some clarity with what Margaret was saying. I know you were talking about the repertory lens being a lens that should apply to all public policy, and distinguishing that, I guess in my mind I was distinguishing that from what you see now in so many governmental and business institutions that have a pro-diversity or pro-equity lens, and really trying to move away from equity and diversity lenses to reparations lenses. I think about how, in the policing context, we used to talk about how foolish it would be look at diversifying police departments as the win, whereas, if you have what Joy had described, in terms of a reparations lens to a response to police harm is so much better. So I just want to make sure I'm on the same page with you on that. And then the second question was for Robin, and even more so Camilla, which is more just of a, how did you guys do it sort of question, because you said that you're in an environment where there's 7% African American, and I know for me, when I think about these political coalitions, I always think about Derek Bell and his interest vergence philosophy, and I'm not sure if you were trying to navigate through the converging interests of different coalition groups. I know that in California, at least my understanding, when San Francisco had its report leaked, the NAACP, I'm not sure if it was San Francisco's NAACP or California's NAACP, came out against reparations. So it's clear that you did not have the traditional civil rights infrastructure behind you to build this coalition. And so how did this coalition get built? Was this something that was a ready-made coalition, or were there certain techniques and strategies that others could adopt to try to build that coalition, to build political power, especially in the absence of traditional civil rights support and leadership in this context? How did you do it?
Okay, and over here.
Hi, how are you? I'm particularly interested in the tension I hear on the panel, and I've also heard all day, which is the move for reparations as specific to individuals who have been harmed versus reparations as a way to redress and address the systemic and structural racism that continues to plague society. And is that what And are you thinking about this separately when you speak about equity and this multicultural perspective and then reparations being separate, or do you see them together? Because, yeah, and I'll leave it at that.
Okay, one last, go ahead, Rob.
So, thank you to everybody, particularly Martha Davis and the folks at Northeastern for putting this together. My name is Rob Robinson. I'm a community organizer. I'm an academic. I teach a course in urbanism at the New School, and I'm a longtime volunteer at the organization that moderator started up there, called Partners for Dignity and Rights. I approached this work lately with a little bit of skepticism and frustration. And the skepticism is, and maybe in response to your comment, Margaret, is will we ever get there?
You've got to get to a question, right?
Yeah, I believe we need to transform society, not reform. I keep hearing the word reform. I don't need to put a Band-Aid on the shit that's already screwed up. I need to change it, right? We need to create something new. So that's where I want to go. But the question for me is, how do we get a critical mass of the community to believe in, I'm zoning out from reparations, human rights in general, right? I believe there's a way that the community thinks about human rights that is almost disrespectful the way our government is. So how do we change that culture? Because none of this shit will happen unless we get people to rise up and say, I've had enough and something needs to change. So thank you. There's no disrespect to anybody in this room. A lot of people in this room have mentored me, and I come in these spaces all the time. But I want to see more people from the community in spaces like this and engaged in the conversation.
So we have some questions from online in addition to how do you get people to rise up? Don't forget that one.
Thank you so much. So first question is brief from Maya. She asks, as some have mentioned, the harms that require repair are ongoing. How can we stem those harms when both individually and as a nation we seem so unable to recognize them as they are happening? And then Maura has a slightly longer question, so bear with me. She says she's been thinking about reparations in New England and specifically Maine. Maine was part of Massachusetts until the Missouri Compromise. Thus, the existence of the state depended on the agreement to extend slavery. Both people in Maine and Massachusetts in the colonial era until the end of the Civil War benefited from slavery through such industries as textile, shipping, shipbuilding. Almost done. The benefits created generational wealth that extends to the current times. The large majority of residents in Maine is white. So the question is, there are also a lot of economic disparity within the white community. Must the repair be limited geographically, thinking about limited amounts of money from local and state governments, and are there efforts that cross states to get at legislative and other systemic ongoing problems nationwide? Thank you.
Okay. You have so many options to choose from. Pick one. And Martha, when do we need to close out? 10 more minutes. Okay. Okay. And things to say. Okay.
Okay,
All right.
quickly do the role of faith-based institutions, private one, the first one, yeah. Okay, so there was a question about what's the role of faith-based institutions and private institutions. Both groups are really important for helping to organize. So faith-based institutions have been traditionally critical in mobilizing opinion, and so I think that is still valid. But another way is also through funding these projects. So in Evanston, cannabis taxes were supposed to pay for the reparations, but only one of the 3 dispensaries were opened by the time that the payout started to happen. And so it was really faith-based institutions that started donating to the reparations fund. And so they were actually really critical in helping to provide the funding for that in general.
Okay.
I can take my shot. To Justin's point, I would just say, like, amen, yes. I think the repertory frame demands, just imagine if, like, corporations and police departments and whoever else took, instead of like a DEI frame, like a repertory frame. It's like, actually, how do we guarantee non-repetition moving forward? How do we actually, like, acknowledge and apologize? It's, like, fundamentally different. And so I really do think that this idea of, like, how do we take a lens that acknowledges, that is about building off of and undoing past harm is really important. And it's different than reparations. I think this idea of, like, a frame that might help us think about how we organize, how we make demands, how even corporations or faith institutions might think about their own repair is different than the reality that for every single harm, I think every single systemic harm, I think that we should think about reparations that's not the same as equity, that it really is centering the actual harm that's been done, who it's been done to, and how we might therefore address or undo that. And I actually think that if you think about reparations for, the war on drugs, for redlining, for Jim Crow, for lynching, for chattel slavery, if we could have each of those fights and we do that in a way that is complementary to each other, the end result is that we're much closer to a society that reflects our goals of justice, right? And so I actually think, and I think that these commissions and here in New York as well, the work is to think about it's not that there's one home that all Black people in the U.S. are reparations for. It's like that actually there's like 100 homes. And how do we actually think about and assess the full range of each of those homes and try to create policies to address them? And the totality of those policies moves us closer. But I think it's important to name that equity and reparations are not and should not be collapsed in any way, shape, and form. That the key to reparations is naming what the harm is, accounting for how that harm has worked itself out, who it's harmed, and then having those folks who are closest to that harm remake and reimagine how repair might look. So yeah.
Okay. So I'm just going to say yes to everything you said, and yes. Yes, we need to address both the individual harms and the systemic issues. We need to bring that broader lens. I'm going to answer a question that you were going to ask, but you didn't ask, which is really that connection with human rights. And, is it useful to think of this within the human rights frame, or are there downsides? And I think there are other examples we could look to in the United States. For example, groups working on issues of water, not just looking at it as like a public utility or a service, but framing it in the context of the right to water in Flint and Jackson and other places, Native American communities. And I think there's that possibility then for that transnational and global solidarity. Similarly, mothers of, people who've been killed by police violence, and thinking about that sort of solidarity with women in Brazil, and how to really think about how do you tackle racism on this global level in addition to a national level. Equally, I think the human rights movement and human rights organizations need to then think about reparations and a frame that brings into account how these individual human rights violations are connected to systemic discrimination and be reflective of what is happening within their own organizations. If you look at global human rights organizations, their leadership, their funding, their compositions, and how do we then lift up, like you said, the voices and the perspectives of people who have been most directly affected to be able to be in that leadership role. So I think in both ways, trying to build those connections would be valuable.
What do we have at the other end of the table there?
Okay, so first I just want to thank everyone here for just being here, and for Martha Davis and the whole, yes, really, this has been an amazing day. And, I think it just underlines, as I said earlier, the need to, have continuing conversations, because the other thing I want to say is that I think that the role of government here and for everyone to think about is that, obviously this is a very long journey. And so I try to focus in our work on building things that'll last, that'll endure, and that will spawn other things. So I'm always pressing the community-based organizations that we work with, like, what can you build that's going to last? Because I don't know if next year we're going to have the funding to continue this, right? Because of the shifts in the cyclical funding and budgets of government. So always thinking about like what is going to continue beyond, and I think building networks that have that start to take on their own life and are able to respond to obviously the changes in our environment, like the upcoming election and what that will bring. But I also want to just hold up the value of the smaller acts that we do, and even though sometimes we look at them and think, wow, that's just one person being affected. We had this, during the pandemic, this Filipino-American man, elderly man, who's walking with his wife in this park, taking their walk, and they're approached by a young white man who starts to accost them, blame them for the pandemic, and harass them. So they're like, okay, let's get out of here. They get into their car, and before he can lock the door, he opens the door and punches him in the face several times, leaving him a mess. I've seen pictures of what happened. And they were so traumatized by that, and we held rallies at that park, bringing him forward. His wife didn't want to come back there. She was afraid to even step into that park. But he came back, and then we came back again, and we put up a huge 100-foot mural on the side of their one of the walls at the park that talked about anti-Asian hate and standing together. And his response to it is like, I really feel safer now to be at this park. I can come back to this park because of this mural that is announcing that, we're standing against this hate. And that's the kind of thing that a rally, you know, that we did that was fantastic because we had all these great leaders there and community folks. That's there one day and it dissipates. But that mural standing up there created a safer environment even when we were gone. And so we've used art as part of our strategy and murals in communities to send a message of belonging and inclusion. And I think connecting arts and strategies in the schools, what we built dream resource centers in schools, all of these things, even though they may begin to only affect a small number of people at first, are the kinds of things that can create the models and inspire others to do the same. So I think that nobody should devalue their work because it doesn't hit as many people, but at the same time, obviously, systemic approaches, which is what I'm so proud of at LA County that we've been able to do, I think is going to have a huge impact as well.
Anyone else want to answer some of those questions?
I'll just answer Justin's question. A quick clarifying point. It was the San Francisco NAACP who wrote a press release rejecting the San Francisco Reparations Task Force recommendation for a $5 million payout to Black San Franciscans. And they wrote that because they felt as if, or at least the San Francisco NAACP felt as if they felt as if the commission was getting the hopes up of Black San Franciscans with this idea that, or with this knowing that the San Francisco Board of Supervisors would not actually implement that recommendation. But I mean, as it relates to how do we build coalitions, right, with the idea that, Black Americans represent such a minority, I guess the way that I can answer that question is sort of limited. I've done the best that I can after the task force is over, in between my day job to meet with folks, different organizations. But, I would really give credit to grassroots organizations that do this day in and day out. And in California, that grassroots organization that I would give credit to is the Coalition for a Just and Equitable California. That was one of 7 organizations that worked officially with the task force throughout the 2 years, hosting listening sessions, focus groups, various different activities to support the task force's work. But after the task force is over, you had CJEC meeting with all sorts of organizations, different Democratic national Democratic committees within the state of California, faith-based groups, you name it, yeah, you name it. But in terms of interest convergence, so it's really interesting that he brought this up because I was on a panel yesterday at USC Law talking about the intersection between reparations and the entertainment industry. And it's a really well-known music lawyer, Professor Kevin Green, where he talks about interest convergence all the time. And interest convergence is the idea, from Derek Bell, that states that white folks, will not, agree to change any policy unless they see a benefit for themselves. And we've seen that historically as well. Kevin Green, he brought up, affirmative action after the civil rights movement. On his face, that was supposed to primarily benefit Black Americans. However, over time, we've seen how white Americans have overwhelmingly benefited. In fact, white women have benefited the most from, affirmative action. And so that was a question that the panelists were wrestling with yesterday, right? We want to see reparations in our lifetime, but we have this very credible theory that reparations won't happen unless white people see a benefit for themselves in this actually happening. So I think something just came up to me. I think we need to have more focus groups with white people. Please let us know. How can reparations benefit you? Let us know so we can put that in our advocacy. But I mean, nevertheless, I would say, lots of meetings and a lot of narrative change is also helpful. For instance, I worked with someone who was a contributor at Forbes magazine, and she wrote an article that went semi-viral that talked about how reparations in California could boost the economy, right? That's not necessarily the moral underpinning for why this is necessary, but it was, something that I collaborated with her to try to converge interests, right, between the moral necessity for reparations for African Americans and, the economic concerns that white Americans or other Americans may have as well. So just being creative about that.
And then I wanted to address her question as well, kind of putting on my human rights law student hat, if I could. So I went to Columbia for law school, and I took a course on intersectionality with Kimberly Crenshaw. That was in 2017. And, I do credit that seminar for, the ways in which I advocate for who I advocate for. So we had to write a paper on hyper-marginalized communities within already marginalized communities. We had to figure out who or what we were going to talk about within that topic. And so just to remind you all, intersectionality is a tool applied to unveil different aspects of a person's social and political identities and how they intersect and create overlapping and interdependent systems of discrimination or disadvantage. And so in my paper, I talked about the intersections between race, nationality, ethnicity, and even caste to make a novel argument that descendants of persons enslaved in the United States within selective colleges and institutions like Columbia, Harvard, Yale, we actually are underrepresented within the Black student group. So of the Black student group at these highly selective colleges and universities, African Americans, those who are descendants of persons enslaved in the United States, were actually the minority within that group. And so that was back in 2017 where I used intersectionality as a tool to unveil how African Americans are hyper-marginalized group within an already marginalized, aka Black group. And then, coming up with specific interventions for that. So, that was all the way back in 2017 where I said these institutions of higher education that have a history of discrimination against this particular group, Harvard, Yale, right, who refused to admit, right, African Americans very early on in its history, right, there could be a specific educational benefit, right, free tuition, right, certain benefits for this particular group of people in the educational setting and context. And so,
I just don't want Martha to be mad at me and I'm late.
Oh, no, I was just going to say just one last thing. You can think about in an international context, that country of Mauritania or the country of Nigeria, right? They're all in Mauritania, everyone's Black, right? But there's a specific ethnic group called the Haratane that are, victims of descent-based slavery. So yes, everyone in Mauritania is a victim of colonialism, but the Haratane ethnic group specifically, right, needs specific targeted intervention, similar to Nigerians, right? In Nigeria, the entire country of Nigeria and everyone within it has suffered from colonialism, and there needs to be specific repair and reparations for that. But there's groups within Nigerian society, like the Osu or the Ohu, again, that have been victims of descent-based slavery, victims of certain aspects of social discrimination and caste that need targeted and specific interventions. And so that's kind of where I pull my analysis to advocate specifically for reparations for descendants of Africans enslaved in the United States.
A very short one? Did you have anything? Okay. Okay, that's it. No, I just didn't know if anyone else was. Okay, so can we thank them? Thank them for their work and for sharing today with us. Okay.
So Kathy knows very well how much I'd like to keep to schedule.
Martha knows how often I'm late, so it's preparing.
I'm going to give two more codes. I'm going to give one now, and I'm going to give one at the end of my remarks, so you have to stay for that. The one I'm giving now is the one I gave earlier. Apparently, people online didn't hear it very well. It's Q as in quiz, V as in Victor, 8 to W as in Wilson, 9. QV 8 to W9. So it's been a really great day. Thank you so much to all of you for staying till the end, and to the latest fabulous panel we've had, as well as the others. I want to thank all the speakers and the moderators for their contributions. There's some folks behind the scenes without whom this program would not have happened. I want to particularly thank Elizabeth Ennin, who's on Zoom, who coordinated the entire event, and Camilla Agak, who might be in here but might be sitting outside. There's Camilla. Thank you. And they both handle most of the administrative and logistical details. Thanks also to Manmeet Nijjer, I'm not sure how to pronounce Manmeet's last name, and Tor Holdenfeld from the Columbia Human Rights Institute, and folks from the Fordham Center on Race, Law, and Justice, Cameron, who helped us out. And let me thank our hosts at Fordham and the patrons who supported the program, and congratulations to everyone for pulling it off today. So in closing, just this past Tuesday, the UN High Commissioner for Human Rights, Volker Turk, called for a new international decade for people of African descent starting in 2025, which academics are always thinking like the term ahead. That's really soon, 2025. We're already preparing for that. And this is an opportunity for focused progress and for evaluation and benchmarking on racial justice internationally. For us in the U.S., this is going to provide another opportunity for activists and lawyers in the U.S. working on racial justice to bring an international lens to bear on the work. And we know that the global context has made a difference in the past. We heard today from Joey Mogul about Chicago, and in particular how the global context really moved the ball in that instance. And I know that folks in this room and online will continue to embrace these opportunities to make progress in this arena. So thank you for that. And now here's the final code. It is C as in circus, H as in Henry, 39, J as in joy, 4. C, H, 39J4. I'll say it one more time. CH39J4. Okay, thank you all very much.